I've been meaning to ask you, y'all have a media logistics person with Fulton?
When you say media logistics,
Like for the courts and so on, basically, do you have a,
we have IT, we don't have, we have a PIO, but that's a job that bounces around all over the place. David Woods, wow. Okay. Good morning, everyone. Please be seated. Morning, sir. Good to see you again. Unmuted. Do I unmute it? Great. Excellent. Daggers. Good to see you. Here. Womble, are you ready? As always. Okay. Well, good morning, everyone. It is the 14th of September, a Thursday, here in the Cobb County Ceremonial Courtroom, and we are hopefully ready for day 3 of the hearing concerning Judge Peterson. We left off when we wrapped up our last session with Judge Emerson's testimony. We had taken a few witnesses out of order because of conflicts they had this week. So Judge Peterson had been testifying. We paused that. She was in the midst of, well, the director was in the midst of her cross-examination of Judge Peterson. We took a few witnesses out of order for all sorts of good reasons. Then we had to take our break. We are back. The lawyers for both sides have shared with me, and I've shared with the other panelists that you all don't forecast that we'll be done with everything by close of business tomorrow. So we'll need to figure out if it's one more day or however much it is, and then find that day or those days in everyone's complicated schedule. But we'll do that. But hopefully we'll be as efficient as possible today and tomorrow. Ms. Veal, before we ask you about your plan for today, is it getting Judge Peterson back on the stand, or there's some other witnesses we need to shuffle around? Is there anything procedurally we need to take up from the director's side?
Your Honor, when we convened last week, or when we finished up last week, the respondent had moved to tender an exhibit. It was at the conclusion of Judge Emerson's testimony. It was a complaint that filed against Judge Peterson. It's no longer part of the formal charge. I have had the opportunity to review it. I identified one area that I believe needs to be redacted, and I don't have any issue with it coming in. I spoke to Mr. Tate about it this morning, and I think he wants to be heard on it.
Okay. Mr. Tate, good morning.
Good morning. How are you?
Okay.
So one of the issues that was raised, so what this is, just so you all are aware, this is the complaint that Judge Emerson filed in March of 2021 after Judge Peterson took office. It contains a bunch of attachments that have stuff that is relates to that complaint, but is not part of the formal charges. I didn't think much about it, quite frankly, when I tendered it, because it was part of the motion for interim suspension that the Supreme Court denied, but it's since been withdrawn. So the purpose of my tendering it,
When you say it's been withdrawn, I'm sorry to interrupt, meaning were any of the allegations set forth in that complaint part of a previous set of formal charges? Because of course we've had several iterations.
It was this is prejudicial conduct that
Oh,
we have always argued was not there. Supreme Court finally answered that question for us in the Coomer case, and so when we argued the summary judgment or dispositive motion thing, this was one that was withdrawn. There was absolutely no dispute about it. It's clearly there. It relates to stuff in 2018, I think, when she was practicing law. So, my clients indicated, and I certainly understand that she doesn't really want to put all that stuff in the record. And all I wanted to do was to put in to show the date and to show that Judge Emerson, when asked what his interest was, had written none on there, both of which I elicited from him there. So, but I've told my client, director's entitled to put the whole thing in, I guess, under the rule of completeness if they want to. And so my position is, I've tendered it. I would really, and by the way, this part does not contain any of the stuff that Ms. Veal identified. There's really just an address or whatever that we would need to take out, but it doesn't contain that. So I would like to only tender the first 4 pages of that if they insist on the rule of completeness, because he's testified about it. My client does not want it in the record. And again, I understand completely why, because it was an allegation that's irrelevant and it's contains hearsay.
It may not be irrelevant, but it's certainly nothing within our jurisdiction.
Correct. So I'm sorry.
Anymore.
Yeah, or
Anymore.
for now.
So in any event, my position is if they want the whole thing in, I would just withdraw it. I don't want to have a big argument over it. If they don't object, I would put the first 4 pages in.
Okay, so
that-
to distill that, you are sort of amending your tender to the first 4 pages with maybe a redaction of an address or personal identity.
Not actually in the first 4 pages. So we don't even have to worry about that if it's in there. And I don't want to argue about it at length here because we've got other stuff to do. So if they do want the whole thing in, then I would just withdraw it and stand on the testimony of Judge Emerson there.
Got it. So Ms. Veal, what is the director's perspective on that? First 4 pages, all of it, nothing.
I'd love for the hearing panel to have all of it. I would hate for you all to ignore relevant evidence at your peril. So, but anyway, if he's going to withdraw it, if I'm asking the whole thing to come in, that's fine.
Okay, so I'm going to distill that as you think everything should come in and not just the 4 cover pages, which says to me, Mr. Tate's going to withdraw. What can we, for the record, what number had you made that?
Peterson 1.
Peterson 1. So Peterson 1 is being withdrawn. Obviously, Judge Emerson's testimony remains in the record, in our notes, et cetera, and we'll consider that. But there is no longer that Peterson 1. You may have a new Peterson 1, or you may want to jump to 2, but it is withdrawn.
I have to look and see what's already been pre-numbered. So it may be, but
Okay.
Thank you. And I
You bet.
appreciate it. I thank Ms. Veal too.
Sure. Ms. Veal, anything else procedurally before we talk about this morning?
No, Your Honor.
Okay. Mr. Tate, did you have anything other than Peterson X1?
No, Your Honor.
Okay. So Ms. Veal, what's the schedule look like for this morning?
My plan is to start back and finish with Judge Peterson, and then I have witnesses reporting at 10:30 throughout the afternoon.
Okay. Now, Mr. Tate or Mr. Chamberlain have the opportunity to do some direct examination of Judge Peterson because it'll be fresh with all of us, et cetera. As long as your witnesses know they may not jump on the stand right away, that's great. But if they have scheduling constrictions as well, talk about that with Mr. Tate. It will become increasingly, I don't know if peculiar is the right word, to have Mr. Tate say, well, I want to do my direct after 3 more witnesses. I think it would be procedurally cleaner to have that direct examination occur immediately following your completion of the cross exam. So are any of your witnesses folks who got to testify before lunchtime, for example?
No, Your Honor. I
Okay.
have one that has to testify today. but
We'll get
that's
to
it.
that. Excellent. Okay, then let's do it that way. Mr. Lopez, Mr. Hyde, do you have anything else? Let's get rolling. Your exhibit list, Ms. Veal went through exhibit 60 and then we've added a few because things came up. Is there an amended exhibit list?
Judge, we have up through 64. Do you want us to continue as we admit new things to?
No, I just wasn't sure. We have through 64 also.
Yeah.
I just wasn't sure if in the intervening days you had said, hey, we're going to have these 8 other exhibits and we've typed it up, but otherwise we're good for right now.
We are.
Thanks.
One other thing I will just bring up, something we need to go into in depth right now, but there are a couple of new exhibits. For example, one of the things is a clearance rate certificate we got from the Office of Administrative Courts last week. So there are a couple of things like that that we may at some point take up. I just want you to know I think the stuff we have, I'm trying to share with Ms. Veal. We're trying to work that out. But
Okay,
it's stuff that's sort of popped up here in the last week or so.
okay. So, Ms. Veal, do you want Judge Peterson sworn in again, or you're comfortable that the oath she took at the start of the proceedings carries over? I'm fine, but I didn't want anyone to think, gosh, all these days have passed. I think Judge Peterson understands what she needs to do here, but I want the record to reflect that she was sworn in several days ago and that oath continues to apply.
I don't have any issue with that, Your Honor. Thank you.
Okay.
Good morning, Judge Peterson. At the risk of aggravating everybody here, I've got to go back a little bit to a few things that we've already discussed, in part based on some additional information that I received from you and your attorneys, okay?
All right.
So I want to go back to the April 17th of 21, the Saturday wedding.
Okay.
And I just want to flesh out that the timeline of events a little bit further. Your wedding, according to you, was set to begin at 2 o'clock, correct?
That's right.
Okay, what time did you get to the courthouse?
It would have been before 2 o'clock. I'm not sure the exact time, but I was there on time for the wedding. So maybe like 1:45, perhaps. I don't know the exact time.
Okay. By the time you arrived, you had already spoken to Captain Wilson, correct?
He called me when I was still at home. Yes. I talked to him several times though throughout, but the first time I talked to him was around 1:30.
And then you said you probably got to the courthouse around 1:45, wedding set at 2.
Yes.
You testified last week that Sheriff Pounds told you that it was okay for you to enter the courthouse.
Yes.
Correct?
Yes.
Okay. When did that phone call occur?
Once I saw Deputy Clayton there, and then I immediately called the sheriff. Yes.
So sometime after 1:45?
Yeah, I believe so. I mean, I haven't looked at the video again, but yes, it was once I got there and I saw when I got there and I came down to the atrium, I immediately saw Deputy Clayton. And when I encountered him, then I called the sheriff. I believe I called the sheriff and captain. I don't know in what order, but I called.
Did you reach Sheriff Pounds on your first attempt?
I don't remember. I reached him though on the call.
And you called him, not he called you.
I called sheriff. On his cell phone.
Okay. Was the conversation you're alleging that you had with the sheriff, did that occur before or after you let your wedding party?
I talked to the sheriff before I let my party into the courthouse.
You spoke to Captain Wilson to advise him that the deputy was there and that he had let a bunch of civilians into the courthouse, correct?
Yes.
And during that phone call was after you talked to the sheriff, right?
Yes.
Okay. And so during that conversation with Captain Wilson, did you bother to tell him, hey, the sheriff has given me permission to be in the courthouse?
No, I didn't feel the need to.
So you allowed Captain Wilson to continue to tell you, don't let these people in. They haven't been screened. Don't do it. And you didn't think you should let him know, hey, your boss, the elected sheriff, told me it was okay.
I'm sorry, that never happened. You're testifying. I mean, you just stated something that never happened. So the only time Captain Wilson ever told me that I couldn't have the people in the courthouse was when I was still at home. And he asked me to ask my party he asked me to have him reschedule. And I said, Captain Wilson, I can't do that. I'll see if they will have the wedding outside. So once I got to the courthouse, they were willing to have their wedding outside, but then I ran into Clayton, Deputy Clayton, at that time. So when my party was willing, they were able to do it outside, contacted sheriff, yes.
Okay. So you just said the only time Captain Wilson told you that you could not bring your party into the courthouse was when you were still at home, correct?
Yes, I don't believe I talked to him again. Well, I talked to him again, but he only mentioned, I told him about Deputy Clayton there. I said, hey, you have a deputy here. He's doing a wedding. He has people in the courthouse. And he was like, really? Oh, I said, yeah. He's like, oh, I didn't know that. I said, yeah, you have a deputy here. I thought you said no one would be here. And he said, well, I guess I didn't know. So, but he said he's not supposed to do that. He did say that.
Okay.
I'm sorry, Captain Wilson said that?
Yes.
Or the sheriff?
Captain Wilson
Okay.
said it after, that's when I was in the courthouse, like when I was actually watching the wedding, that Deputy Clayton was performing. That's when I called Captain Wilson.
Okay. And so you did speak to him again, but your testimony is that during that conversation, he didn't tell you not to take your party inside.
No, it didn't come up in conversation.
Okay. And so you're watching Deputy Clayton's wedding take place. You're on the phone with Captain Wilson and you do not mention, hey, I've gotten permission to do this. So let's just end this conversation.
I called him. I don't know why I would end the conversation. I felt like I needed to inform him because he was under the belief that there would be no deputies there. So I was telling him, hey, you have a deputy here.
And he told you during that conversation that what the deputy was doing was wrong, correct?
He said, well, he's not supposed to be there. And I said, oh, well, he is. But no, I don't think it came up in that conversation that nothing came up about don't be there, because I don't know if he's already known that I talked to the sheriff. I don't know if the sheriff communicated with him, but yeah.
He told you what the deputy was doing was wrong, correct?
He said he's not supposed to be there. He didn't say what he was doing was wrong.
He didn't say that.
He said he's not, well, the words were, I say your deputy's here doing a wedding. He's not supposed to be there. He's not supposed to be doing that. He didn't say it was necessarily wrong.
You recorded at least some portion of that conversation, correct?
Which one?
That conversation.
Yes, I believe so.
How did you do that recording?
On my cell phone.
Do you have some kind of app on your phone?
I did.
Okay.
So I want us to make sure we don't revert to how it was before. Please let Ms. Veal finish her question before you answer.
Okay.
And I'm sure Ms. Veal will let you finish before she asks her next question.
All right, Judge Peterson, you provided those, at least portions of some recordings you took to your attorney, which have been provided to the JQC in this matter, and I want to show you two documents related to what you all have provided. The first is JQC exhibit number 65.
Mhm.
The second is JQC exhibit number 66. Exhibit number 65, can you tell us what that is, please?
It looks like the app, one of the apps where I would record or use to record.
Okay, and does this fairly and accurately depict what that app would have looked like back on that, or at the time that you screenshot it and would have sent it to your lawyer?
It would have looked like the calls that I recorded, yes.
At this time, I move exhibit 65 into evidence.
Mr. Tate, any objection to Director 65?
No.
Admitted. What's the name of the app?
Cube ACR,
Cube
Cube CUBE.
ACR?
Mhm.
And exhibit number 66 is a transcript that was prepared by, I believe, your counsel in reference to one of the clips that was contained on this recording. Are you familiar with this?
I'm not.
Okay, you didn't have any part in preparing that?
I didn't.
Okay. Do you have any objections to this, Mr. Tate? Exhibit 66?
No, I do not.
I'd move to tender exhibit 66 into evidence.
Okay, can we, I know they're not in the binder because they're new, but you're about to put them.
They're actually, the transcript, I think is in mine at 45.
Okay.
I'm leaving all the zeros out, but at 45.
Which tab?
Tab 1. Although it's back toward the very end, Mr. Hyde, I think it's about, in mine at least, if it hadn't got moved around, it's
What's
about,
the Bates number on it?
it's 45.
Gotcha.
And the transcript is of the call between Judge Peterson, a call between Judge Peterson and Captain Wilson.
I think it's Trent Wilson.
Okay.
Yeah.
While we're talking about exhibits, I know you're about to put something up. Do we have in evidence the letter that Judge Emerson sent to the county commission? We've heard reference to it. I just don't know if that was, and he talked about it a lot. I just don't know if anyone tendered it or held up a piece of paper and said, didn't you write that letter? Do you know, Ms. Field?
I have not tendered it. I can obtain it if the hearing. Review
Yeah,
it.
I think that would, I think it'd be helpful. I had it, I don't think I had it marked at the time. My purpose was to show that he complained
Sure,
about
okay.
that, but I would like, I guess I would like for it to be in evidence if Ms.
All right,
Field has
if someone just make a note of whether it's from a Judge Peterson exhibit or director exhibit, doesn't matter to us. We just like the letter.
We'll get a copy and
Thank
put
you.
it in, Your Honor.
All right, Ms. Field. Oh, yeah.
So what I've got pulled up on my screen, is what is reflected in exhibit 65. The Cube ACR app. And Judge Peterson, again, you provided a report into your counsel with this phone call.
I believe so. I don't know what call you're gonna play. I believe so, yes.
At this time, I'm going to, I'd like to play the phone call and I'll note it as JQC exhibit 67.
Okay, before you do that, question for Judge Peterson. I'm not familiar with Cube ACR. If we look at the screen for Saturday, April 17th, so that's the date of the wedding. There's a call with Sheriff Pounds. It's got a green arrow that points up and to the right. Does that mean you called him? Or he called you, or those arrows have nothing to do with who called whom?
I believe that I called him.
So then you would have called Captain Wilson, if we can make the little play thing go away. If you're right, I'm not, well, I just don't know how it works. You would have called Captain Wilson at 2:08, and then he would have called you back at 2:13, and then 20 minutes later-ish, you called Sheriff Pounds.
Right.
Okay. Thank you.
I thought you said your deputy just let 13 people in without going through the scanner. The white man, what's his name? He's a deputy that works at the courthouse. He let 13 families. He just let them in. Now I'm trying to see how he bypassed the process. I took pictures. I got proof. I'm trying to figure out. I'm about to make some calls. I don't understand how he was able to do this. Yeah, he said, well, you wasn't on the list. And I'm thinking, y'all, listen.
He's wrong.
No, he said, he claimed, but he said my stuff wasn't on the list, on the event calendar. I'm like, how do you know? Did he take it off so he could do his 2:00 wedding?
I don't know. I figured this all out.
Yeah, he let 13 people in here. None of them went through security. I got pictures. Okay. Bye. Not,
Event form for that day.
I did, well, my assistant did.
But we
I s-
haven't, I'm sorry, I interrupted you.
I requested it. I still haven't received it from anyone. There was talks about I put in the wrong time and I've never gotten to see what my assistant actually put in.
I don't think, at least I've not seen, and maybe Ms. Phil has, I've never seen that form for that day. It's a.
That's what I recall from testimony from last week was that folks have looked for it. Someone said it said 11, other people thought it said 2.
And we know there was something because it was on a list at the wrong time, but we don't
Right.
know what.
Judge Peterson, the recording that we just heard, according to the app that you used to record it, that would have occurred at 2:08 PM, correct?
It appears, yes.
Okay, and you said that when you were on the phone with Captain Wilson, it was the conclusion of his wedding, and you had taken pictures up there. You hear a bunch of people clapping. Is that correct?
I don't recall. I know when I was on the phone, I said it was during the wedding ceremony.
Okay, you hear a bunch of people clapping and celebrating in that call at the beginning?
I didn't, I'm sorry, but I don't know if that was before, I don't know if the wedding was completely over. I don't recall. I know I was on the phone or I was making the call when the wedding was in session.
Is that the entirety of the phone call that you had with Captain Wilson at 2:08 PM that day?
I believe so.
And you testified earlier that your purpose in calling him at that time was to let him know that his deputy had let people in the courthouse, correct?
Yeah, when I spoke to him earlier, he was so adamant that there was this process or procedure or policy that everyone knew about. And it was strange to me when I got there that that wasn't absolutely correct. So I called him to let him know to see what his thoughts were.
Okay, and by 2:08 PM, you had already let your wedding party in as well, and they were upstairs with you, correct?
I believe so, yes. At the time, by the time I called Captain Wilson, I had talked to the sheriff.
Okay, but you still felt the need to make this call despite the fact that you had gotten permission from the sheriff?
Yes, I communicate with everybody. I'm not an elected that doesn't. I would contact the captain. If I knew about Lindy West, I would have contacted her too, but I haven't seen her in this matter. Heard from her, but I contacted the sheriff as well. I also contacted some commissioners throughout this as well.
This is the transcript that I was referring to, JQC Exhibit 66. I know portions of that phone call are a little bit difficult to hear, but after listening to it, you agree with me that Captain Wilson clearly told you that what Deputy Clayton was doing was wrong.
It appears so, yes. After hearing the recording, yes.
Okay, and then he actually said, you wrong to follow that, correct?
He said he wrong.
Object on relevance, what order he's given a subordinate and the sheriff's department is not relevant to this. And the fact that, Ms. Ville's asking, he told him you're wrong. Well, that's a matter for the sheriff's department. It's not a matter for judicial discipline.
Well, I'm the oldest, maybe the oldest ears in here, but I heard words on the recording that are not reflected on the transcript and vice versa. So I don't know what to go by. For instance, you said, I don't know how he was able to do this. In the transcript, you actually said, I don't understand. All I'm saying is the words I heard do not fit the words on the transcript.
Do you know who prepared this?
I don't.
You didn't talk with anybody about preparing this for this case?
Didn't.
I think my office did it.
I'm
And
not
it was not a certified court reporter either.
It's very difficult to hear either way.
I understand that there's one that was left blank because there, but it was, I just want to be clear that any fault is, if there's some fault there, we tried to do that, to transcribe it so you'd have it.
I
So
understand.
You said during the call that you were about to make some calls.
Yes.
Who else did you need to call at the point that you're already in there with your wedding party? Deputy Clayton was already in there with his wedding party, and you've already spoken to, according to you, the sheriff and the captain.
Additional people, I spoke to commissioners who are actually over at the courthouse. I made some calls.
After the one to Captain Wilson at 208.
Yes, I made calls. I spoke to several people. Several of my commissioners that spoke to the chairwoman. I spoke to the vice chair at that time. Yeah.
Judge Peterson, and something we did not touch on last week, I don't want to spend a lot of time on it, but May 11th of 2021, so shortly after the wedding on that Saturday, you activated the panic button in your office, the probate court office, correct?
I pressed the button to what I now know is called the panic button. Yes, it's a button under my desk.
Said to what you now know, what did you know about that button at the time you pressed it on May 11th?
Well, when it was installed, I was advised that anytime I needed to summon a deputy, that I would press it. Anytime that you require a deputy's assistance or presence.
Who told you that?
That's what, when I came in office, there was furniture there that belonged to the prior judge. So I replaced my furniture. The people installing it, I think it was building maintenance at the time, who installed the button or reinstalled the button on the new furniture. So that's what I was advised at the time. I don't remember who exactly was, but generally building maintenance is Mark Price or Alan, this guy, Alan Mashburn, I think his name was, but it was basically, this is a button to summon a deputy.
Where's that button on your desk?
It's under the desk on the right side. Yes.
Have you ever hit it accidentally?
No, I really, I knew where they installed it when they installed it, but I've never hit it accidentally because I'm kind of short. So I don't have those issues.
So none of the people that met with you when you took office explained that this is a button, not for somebody to bring you a Coca-Cola, but for somebody to come help you protect your life.
No one met with me when I took office. Not one person.
But someone told you, I guess I'm confused. I thought you said someone told you that you pressed that button when you need a deputy.
That's when I was getting my furniture installed. So when they put the button there, I said, so what is that? And then they said, this is a button to summon the deputies. That was just a
Judge Emerson never met you to explain the panic button?
No, he's never met with me at all.
Did anybody from the sheriff's office meet with you to advise you how the panic button worked?
Never before this incident. After the incident, Trent Wilson came to my office and said, hey, Judge, you don't use this button. It's just used for emergencies. I said, okay, thank you. That's good to know. So he said, yeah, he just came in, had a conversation. I think I was going to court. So after I got back from court later on that day, he came and talked to me.
You worked in courthouses your entire career, Judge Peterson, correct?
My entire legal career? Not necessarily. There was some firms I was at that I was not in the courthouse, not in litigation.
Have gone into and practiced in courthouses your entire legal career. You were a prosecutor in 2 different jurisdictions, correct?
Yes, I was a prosecutor. That's correct.
And you thought that you didn't understand the concept of a judge, an elected official, having a button that was used for emergencies. You just thought it was like a summons.
Yes, that's what it's been used for, in the courthouse, according to the clerks at my office.
So you talk to them before you press the button?
No, I would talk to the person I said. I only talked to the person installing it, but thereafter, when I talked to Trent, I wanted to inquire about from the people who've been there to know what is the button used for? Am I getting the right information? Because I haven't seen any formal policy. And I was advised that they've always just pressed it when they needed a deputy. So say somebody came to the counter and there was a weapons carry license. They were trying to get a weapons carry license, but they had a warrant. They would press the button to get a deputy up there. And it wasn't an emergency. It's just,
The clerks have a similar button.
I learned that out thereafter too. I never knew the clerk's area had a button too.
Do y'all not have telephones?
We do. I don't know the telephone number to the sheriff's. I've never gotten that either. I don't know how to call the sheriffs on the line. I mean, that would be extreme, I would think, to get deputy to,
Well, I'm confused because we just listened to you talking to Captain Wilson and we know you and the sheriff spoke. So did you just randomly dial those numbers and luckily got Captain Wilson and the sheriff, or you actually have phone numbers for the sheriff?
no, okay, I have phone numbers for the sheriff. The sheriff is not present at the courthouse. He doesn't do the courthouse. Captain Wilson is present at the courthouse. I don't generally call them on the line. Like I said, the initiation that day was when we were talking about the wedding is he called me. I don't generally call them. So, and he's generally not present at the courthouse. So in order to get a deputy at the courthouse, in the courthouse, all I knew was this button.
When you started as judge, you never got like a directory, here's the extension you would call for the sheriff's
I didn't
station?
I didn't get a thing, not one piece of literature.
And it did not dawn on you to send an email or to try to figure out how to just call down to the security station 1 floor down, hey, where's my deputy?
I did. I requested, actually, I think I sent an email to the sheriff before this. Somehow, I believe I sent an email like asking, what is any type of plans or security plans? I believe I sent an email. I believe it was before that date.
Did you, the outgoing judge, chat at all?
I did go to his office a couple of times when he was still in the office.
On May 11th, when you pushed the emergency button in your office, was that the first time you had pushed it?
Yes.
And just giving context to the time frame, that came on the heels of you having gone back and forth with the sheriff about the sheriff providing you a deputy escort to and from your courtroom, correct?
I'm not sure. You said it came on the heels. I'm not sure what you're talking about. I do know that I'm required to have a deputy to escort me to court. I have to cross through the public way. My office is on the 3rd floor on the back side. The courtroom is on the 4th floor on the front side, and there's no back hallways. So the law requires that a deputy escort me.
Okay, I understand that, but the prior probate judge had never made that request, correct?
The prior probate judge didn't have court.
My question was, he had never made the request to have a deputy accompany him. in there.
Objection, that calls for a hearsay.
I wouldn't know.
Just
Don't answer
hold on.
yet.
That calls for a hearsay response, and it's also speculative since she wasn't present for the entire 4 years that, or whatever term that.
But hearsay at a minimum, because the way Judge Peterson would know that would be if the prior judge told her.
Judge, I can rephrase if I need to. I'm wanting to know if she was aware whether there was ever a deputy escort needed for the prior judge.
You can rephrase it, but the way she would know that would be, she asked the prior judge and the prior judge said yes or no, which would be hearsay if you're offering it for the truth of the matter asserted.
Did you had to have multiple conversations with the sheriff about the fact that according to you, the law required that there be a deputy go back and forth with you to accomplish getting an escort, correct?
Yes, to my courtroom.
Okay. And initially, they provided you with a bailiff, and that was not satisfactory, correct?
Correct.
And that interaction and back and forth with the sheriff occurred prior to your pushing the panic button on May 11th, correct?
I don't recall. I don't have the email. I'm sure there's an email chain somewhere, but I know that I requested deputies.
Was the bailiff armed?
No, bailiffs are not armed, and the code specifically states that a deputy has to be present.
So the purpose of pushing the button on May 11th was to summons a deputy, right?
Yes,
And that was your deputy escort to the courtroom, correct?
yes. So according to what I was advised for protocol is if I need a sheriff for court, I need to advise my assistant sends an email to whoever and gives them the time of court. So that was done. It got to be, I'm never late for court. That's one thing I don't do. And the deputies were not there. They were not present, nowhere in sight. So yes,
So somebody advised you on protocol, then you
To-
just said,
to request a deputy after after I was granted a deputy for court, they needed to know when will you need the deputy. So that makes sense. You know, they don't have deputies just there. So we would let them know of all my court hearings.
And did they say press the button when you need that deputy, or did they say you need to schedule it so someone calls or emails or whatever?
They said, well, to schedule it, you had to email so I have to schedule in advance. So it's advance. I don't know how much notice my assistant gives them, but they haven't complained of it. So I don't have that knowledge on how much.
The May 11th proceeding, had you requested a deputy by email?
I did. We did.
Do we have that?
I'm sure I could go pull it. Yes. But that was never a question. But yeah, it was requested.
And what all happened after you pushed that button?
When I pressed the button, I sat there and just waited. And finally, a deputy came. And he escorted me to the courtroom.
So a deputy just comes in and says, hey, did you need something?
Yeah, he was like, what's going, my chief clerk and my assistant at the time, Sandra Hall, encountered him first. And he's like, what's up? What's going on? And they said, the judge needs escort to the courtroom. And he said, okay. So we walked to the courtroom.
So one deputy showed up.
Yes.
Peterson, that's all I have on that issue. And I'm sorry to go backward, but I have had an opportunity to review the emails that came up last week that you indicated that you requested from your IS department. Is that correct?
Yes.
Can you tell me how you requested those emails?
I requested it by email.
You sent them an email
Yes.
that said,
I would like the emails of all communications from my staff and Jaquita Mercado. I think I specified the staff that would have, the accounts that would have had emails to it. So it would have been the probate court. Perhaps my email, because I send out the Zoom link. It's a Microsoft Teams. Bonnie, Shanika, and probate court judge fax.
so your request would have been, I would like all email communications between Bonnie, Shanika, myself, the probate court judge fax, and
Probate court.
or probate court judge fax and Ms. Ricardo.
Yes, and probate court. There's another. Yes.
And the format that they provided those emails to you in, is that the format that you provided those emails to your attorneys in? Or did you change the format?
I didn't change anything, no. Mhm.
When you collected the emails to provide them to your attorneys, did you remove any
No,
emails?
I did, no,
No edits or deletions?
did I remove any emails? No, I think I turned over all the emails. That was,
You did?
yeah, well, that was given to me, I believe, so, yes.
Well, there would have been no reason to
No,
remove any of these emails prior to giving them to your counsel.
correct.
So your testimony is this is everything that was given to you by the IS department based on your request.
Everything that I gave my attorney was everything that I received.
Sorry to steal your exhibits.
Oh, that's fine. I just want to make one comment about that. The witness would maybe know better than I would, but I do think that some of those, you know how when you get an email string going,
Mhm.
some of the ones that were produced in other places may not have been reproduced every single time, but
So what I'm understanding your client to say is, I got a universe from IT, they call it IS there. And I gave that entire universe to Lester Tate, who has given it to Courtney Veal. And so if there's something funky or missing about a string or a thread, it would be how your client received it. Unless what you're saying is, no,
we need to ask the client. I think we need to ask her that question. Because my understanding was, and I did not personally go through it, but my understanding was, so for example, you and I, Ms. Veal, we've had a lot of emails and there'll be a string. So there may be one that when you were asking about how long we're going to take, there may be one in the string somewhere that has to do with when we're going to have a dispositive motions hearing, whatever. And that one would pop up every time. And I'm not sure all of those were produced, but we took it and turned it over as it was given to us. And I think that is as it came from the IT department.
that's the testimony as I've heard it so far.
Yes.
Okay, Ms. Veal?
Have any objection to 68? It's what we received from you all.
I would welcome it because if you put it in, I don't have to.
Okay.
Wonderful.
So 68 would be that universe of emails that, according to Judge Peterson, is exactly what IS gave her, she gave to Mr. Tate, and it's been given to you.
That's correct.
Okay.
And I've made 3 copies.
68. Yeah, 67 was the recording of the call.
Judge Peterson, I got an Excel spreadsheet that summarized, it's kind of a timeline, but it summarized some of what's in these emails and then contained other events as well. Did you prepare that
Yeah,
timeline?
I believe I did, yes. If you're talking about the timeline, I prepared.
Your testimony last week regarding the service issue with the heir, Ms. Mercado. At the time, you explained that the way in which we accomplish service according to the law for individuals like her was pursuant to a certain statute. Do you remember?
Yes, I said the way I extended service and I gave additional notice.
Okay. Specifically, you explained the piece about the return needing to be signed by the individual whom the notice was sent to, correct?
Yes, if you send by certified mail.
Right, but there was explanation by you when I asked you about why an additional notice was sent, which extended the deadline for the objection. You explained that you guys had gotten the card back, but it was signed by Jose, not Jaquita.
I said we hadn't got it, no, we hadn't got the card back and the file was just sitting. It was placed So if the file is pending, we have to have the file moving. So if we haven't gotten a card back, sometimes we never get them back. So then I have to move forward with trying to find additional service.
Okay, well, your office, we agreed your office sent the first notice on March 22nd of 2021.
I believe that I don't have the timeline in front of me, but that's what I think that's the date that was certified mail was sent. Is that right? I don't have it in front of me.
Would you like to refresh your recollection with your timeline?
Sure. Yes, the 3/22.
That's us. And you indicated that because you guys got no card back, you decided to send an additional notice and give her more time. to file
Yes.
an objection. Okay, and last week you indicated that you did that because pursuant to the law, the person specified in the citation needed to be the one to sign the return receipt. Correct?
We have to have, for it to be good service, we have to have a signed card with the signature of the person. If it's sent by certified mail, correct?
Okay, and is that, are you pulling, is your authority for that found in OCGA 5311(3)? And that's what's cited on your.
It's one of them. It's 5311(3) or 5, one of them.
I want to show you 5311(3). And you're the expert in this area, Judge. I'm not. So I looked at that.
Okay.
So
All right, 5311(3), personal service generally. So in subsection A, except as otherwise prescribed by law or directed by the judge, a party in interest who is a resident of this state is entitled to personal service of any petition and citation for proceedings that are subject to provisions of this chapter. So this statute, and then down in E, it provides the bit about if the return receipt is not signed by the addressee dated at least 30 days before the date specified, except when shortened, good cause shown and received by the court, service shall be made as otherwise required in this code section. Is that the provision that you are relying upon for the idea that you have to receive that return receipt back from her?
Yes, that's my understanding. Absolutely.
Despite the fact that subsection A specifies that this is to apply to parties in interest who are residents of the state.
That's for parties that are residents of the state.
Okay, well, is there a similar provision for parties who are non-residents?
I'm not sure.
I'm going to show you up on the screen, OCGA 5311(4). Are you familiar with this code section?
No, I haven't looked at that one, no.
Okay, so you weren't aware that there was a separate code section that governed service for individuals who either resided outside of the state or who had an unknown residence.
can you slide it up a little bit more so
Sure.
we can see D?
Would you like a copy?
I was happy reading it on
Okay.
the screen while you were talking. Great. Thank you. Perfect.
Okay. No, I haven't looked at this code section.
Okay, and so, I mean, so since you've been in office, you've been sending any required notice, whether the person is a citizen or whether the person is in Georgia or they reside outside of the state, you've been sending all those notices pursuant to the first code section you looked at.
Not necessarily pursuant to that, pursuant to what I'm taught in training as well. So we get a lot of training on service, and we have authority to require additional or different types of service. And I prefer to have service that indicates that the person served got notice of it. So that might be preference as well, because there's a lot of services not required that I require.
Okay, so do we agree then that, your idea regarding the return receipt having been signed by the person that it's sent to and coming back to you, that is something that is a preference. It is not supported by the law as it relates to people who live outside of the state.
Well, I've never seen the code section distinguish the two, but now that I've seen it, I probably would still require it because we've seen a lot of issues in probate where people's estates have been, taken, wasted, different things like that. So in order to protect those estates, I make sure that the interested parties that require to get notice, get notice.
Mr. Tate?
Yes, Your Honor, I just want to know that, and I guess technically I'm objecting to the question because the question was basically, it's not required on out-of-state residents. Both of the two code sections that Ms. Veal has shown to Judge Peterson, paragraph A, it begins, except as otherwise prescribed by law or directed by the probate judge. So it doesn't mean that it's illegal to require that. And I just.
Okay, so two things. One, that's argument you could make, something you explore with your client on direct. But two, I didn't hear Ms. Veal say you broke the law as so much as maybe you misapprehended the requirements of the law. That's how I suspect we're processing this. Ms. Veal.
So again, you said you sent another notice because you guys had gotten no card.
Yeah.
Do you agree with me that your timeline reflects that your court received the card back signed by Jose on April 5th of 21?
Yes. I don't think I said we got no card back. I said at the time that I reviewed the case, we hadn't received a card.
When did you make the decision to send a second notice to Ms. McCarthy?
I'm not sure.
Before or after you received the card signed by Jose on April 5th?
I would have to look. I really looked through my file. I did a good job with it and I prepared a timeline. If I could see the timeline, I would be able to give you more definite answers because it's so many things with this case.
If we could just leave the timeline with the judge, I'm not remembering the dates either. We all talked about this.
I think it's the timeline that you admitted into evidence. Oh. It was, I thought it was attached to the front of the two, the exhibits you put in.
Mm.
This is my copy. I can make her a copy if she would. I can go ahead and show this to you guys.
The first few entries.
That's okay.
Okay. Okay. I've looked at it.
So at what point in the timeline did you decide, hey, I'm going to send her an additional notice? Was it before or after you got the card from Jose?
Well, it was after the card was in the file. After.
Your timeline indicates it was May 26th of 21 that there was an error in omission sheet sent,
Yes.
right? And there's a message here on this timeline. We're going to get you a copy and I'm going to get the hearing panel a copy that says Jaquita did not get notice.
Yes.
And it says that was from the judge to Bonnie Fasick. Was that an email that you sent?
No, it would have been a written piece of paper, work product for the court.
Okay, so over a month after you get the return receipt from Jose, you then decide, I'm gonna send Ms. Mercado an error in omission sheet, giving her 2 additional months to file an objection.
No, I gave it to Bonnie, telling her, so if the case has been sitting a while and we need to move cases, if it comes to my desk to review and I see there's not sufficient service, we have to cure that service. So I sent the message to Bonnie on a form. So Bonnie knows what's wrong with the file. We didn't get, Jaquita didn't get notice. So I must have saw the card that showed Jose signed it and it wasn't sufficient for me.
The second notice that was sent to Ms. Mercado, you all sent that to her via email, correct?
I didn't send anything. I don't send emails to parties per se. They get an email when they ask for a link to the hearings, but I don't send emails.
Okay, so I'm showing you JQC exhibit number 19 again. This is the second notice that was sent, giving a deadline for objection of July 10th of 2021.
Okay.
And we had talked last week about what's written down here at the bottom. And I had asked you, that says emailed to Jaquita Mercado, and then it has her email address
Yes.
there, correct?
Yes,
I assume that's the certificate of service.
perhaps. I think it would have been Bonnie's writing. That's Bonnie's writing. So if she said she emailed her a service notice, she likely did. Bonnie doesn't. She's very honest.
How did Bonnie get her email address?
I don't have the answers to that. That's why I requested all of the emails. It appears that Jaquita emailed the court somehow. I don't know how she did. But I think she emailed either the probate court or she emailed Bonnie.
Okay, and that email you're referencing, we talked about that last week, is here on the front of JQC exhibit number 68. Is that this email on Thursday, May 27th?
Yes, that's the first email that I saw.
And she indicates that she got a message that you were trying to contact her regarding her deceased father.
That Bonnie she sent this to Bonnie. So when you say you, I believe, I don't know if she meant Bonnie, who she meant, but yes, it was directed and addressed to Bonnie.
Okay, and we agreed Thursday, May 27th of 21 is 3 weeks after the initial deadline that had been set for the filing of objections of May 3rd of 2021.
Yes.
All right, so we have a second deadline now, and this has been emailed to Ms. Mercado of July 10th of 2021. Did nobody from your office notify the petitioner or her attorney that Ms. Mercado had reached out and you all had given her additional time to file an objection, correct?
I wouldn't have the answer to that. I don't contact the parties. My clerks would be better able to answer.
You didn't direct them to alert the petitioner that this process was being extended.
Generally, anytime I sign a notice or order, the interested parties are supposed to get notice. What if they were doing it? At that time, I'm not sure. I don't know if it happened.
Have you trained your clerks on just the basics of, providing notice to all parties, providing copies of responses, petitions, any of those things to parties?
As the issues come up and I learn what they know and they don't know, yes, I do. We are, and that was what month, May of my first year. So a lot of it's operating off of what they were taught in the prior administration. So it was functional, it seemed, but I had to learn that a lot of things that they were doing were not correct or proper or appropriate. And that's, so I did have to start saying, hey, if you send notice, you have to send the notice to all interested parties. If you send an email, you have to copy all the parties, things like that, that I've had to make corrections throughout my term.
When did you start noticing and threatening?
From the first week. So what I do is anytime I see an issue on my computer, I send out an email to my staff and I call it new office policy. And then that policy was, it alerts whatever I've learned that they've been doing or whatever I've learned that we need to be doing.
So essentially what I'm hearing is you address things and provide guidance only after something has happened and you realize it's an issue.
No, I provide guidance when it's a lot. Let me explain. There's a lot of things that we do in probate. It's a lot. It's not something that you can learn in a week. We are not e-file. So you're not pressing a button to accept a case. My clerks have to physically intake the cases. They have to make sure the petitions are sufficiently completed. If not, we have to reach back out to them to complete it. So it's a lot to know in regards to solemn forms. It's going to be different from service on the letters of administration. Clerks have to know these different things. It's going to be different from a guardianship, from a conservatorship, what notice is required, what service is required, is publication required? If they're asking for a waiver of bond, what's required in that? It's a lot. We're still to this day, we have probate judges that have been in office for 30 years are still learning. This is an ever learning class of court. So I teach them as we go and they're really hands-on, but we get something pretty much every week that we've never seen before.
You testified last week that you had the probate judge from Gwinnett County actually come out and do a training for you and your staff, right?
Yes, he did.
Judge
Ballard, yes.
And that was in the spring of 2021, correct?
I don't know the exact date, but it would have been my first year. Yes.
Okay, and your clerks, or at least Ms. Basic would have been present for that training?
Yes, she should have. Yes.
Did you ever receive a phone call or email correspondence from the petitioner or her attorney inquiring on the status of the order in this case?
I don't receive phone calls. The first day I came in office, my phone was ringing. Apparently attorneys used to call the prior judge. I've never answered the phone. I don't have communications with any parties, and that's kind of how it works. So I haven't received any calls from any petitioners or attorney.
Judge, I want to show you what I've marked as secret 69.
Okay.
An email from Bonnie Basic to Ms. Jaquita written Friday, July 9th of 2021 at 10:03 a.m.
Okay.
Can you look at that email and let me know if you recognize it?
I don't recognize it because I wasn't a party to this email, but
Have you ever seen that email?
I received it when I asked for the emails.
Well, that was going to be my question for Ms. Veal, because you've distinguished this from 68, and maybe you're going to explore this with some witness. It's not in 68, as far as you know?
68 indicates that this email is not.
Is 68 also known as AT01 from Mr. Tate? Yes. Thank you.
Yes, I believe this was provided as well. Yes.
I've noticed it.
No objection.
69 is admitted.
Thank you for putting Bates numbers on there, Mr. Tate.
You got one thing right.
Even a blind hog finds an acorn every now and
Who's your staff?
then. Yes,
His tool.
yes.
Right, Judge Peterson, this is that email, and again, you noted that you were not on it,
Yes,
but you are familiar with it because you said that it was contained within the emails that you got from IS?
yes.
Okay.
And I believe I made it a part of, I should have put it on the spreadsheet as well. If I would have received it from IS.
Okay, well, let me have the spreadsheet and go to July 9th of 2020.
It's not on there, but I see the response to it, so it must not have been sent. Mhm. It must not have been sent to me. Because I reviewed everything that I received.
Just testified that it was.
I believe I sent it. I don't know if I received, I've seen this email somewhere. I don't know if it was from what my attorneys provided to me that you provided, but I've seen this email. When I was making my spreadsheet, I did wonder what the email before that was, because Jaquita sent proof of the objection.
So we agree that this email is not on your spreadsheet.
Yes,
Okay. But we see that on Friday, July 9th of 2021, which would have been the Friday before, right before the objection was due. On the 11th, we see that Ms. Fasick is reaching out to Ms. Richmond or Ms. Mercado to inquire about where her objection was
correct.
at your direction.
Yes,
Okay. And so you all had not gotten any objection from her at this point, right?
we received an objection from her on I believe June 11th. I mentioned this last week. We received an objection from her. I put it in the timeline. It was sent to the probate court judge fax. That is an email. So it was notarized, and she indicated that to Bonnie that she was mailing it off and mailing her money orders. So I knew that the court was awaiting the objection from New York.
But you said that you received that to the probate court judge fax on June 11th. Why would you then have directed Bonnie on July 9th to reach out to her? Because you all had not gotten the objection yet.
We haven't gotten it in the mail. We haven't gotten the payment and the original.
I'm curious, why is that your concern? If it doesn't come in, it doesn't come in, and that litigant has missed a deadline and the world keeps spinning.
She's indicated in a prior email to Bonnie that she mailed it off. And the court is aware that there was an objection, that we have the actual objection, we just don't have the payment for it. So
It's just the photocopied, okay, I'm remembering this from last time, okay.
yeah, so it wasn't that she didn't have an objection. She had an objection, she objected, but because we're not e-file, we require paper copies and we require the payments as well.
So your testimony is that as of Friday and July 9th, you had not received the paper copy, the original, nor had you received the filing fees.
Right, we still haven't received it in the mail.
Never received the original,
We never received the original.
and you never received the filing fees?
We did receive the filing fees on the phone. She took a payment over the phone.
Okay.
How does that work? Meaning, Ms. Mercado would have provided a credit card number? Or
Yeah.
something?
Yes, she did. I don't know if Bonnie called her. She called into Bonnie and she took the payment over the phone. And I advised that I would allow the objection, the emailed objection, because the original was lost.
When you say you advised that you would allow the email in lieu of the original,
Yes,
who did you advise that to?
Bonnie, my chief clerk.
for her to communicate that to Ms. Mercado?
So I told Bonnie to communicate she needed a payment over the phone. We haven't received the original, so it's lost. Obviously, you've intended and you made the movements to object in time, and you could prove it. She sent receipts of the money order. So I said I would allow the emailed objection and I would allow you to take the payment over the phone. We've taken payments over the phone for other things, but I allowed it on this case as well.
Okay, and during the course of all of this communication with Ms. Mercado, which is shown in exhibit number 68, discussion about the objection and where is it in the payments, and you need to send these payments. You didn't ever notify the opposing parties in this case, correct?
I'm not sure what happened. Usually that's usually Bonnie's job to do. I don't know what she did in this case.
Did you tell her, hey, you need to reach out to Miss Polly and let her know that we've gotten this email copy of an objection and I'm fine with it and we're going to accept it?
I don't know I don't tell her specific things about specific cases necessarily, but I would generally tell her, you should notify all the parties. I don't know at what time that I told her that or made her aware or reiterated to her. I don't know.
But you advised her to tell Miss Mercado, hey, it's good, we'll accept this email. It's fine because it's lost in the mail.
I advised her to get the payment over the phone.
So showing you JQC exhibit 20. This is the copy of the objection that was sent to Miss Polly by your staff
Mm-hmm. Yes.
on Thursday, July 15th of 2021. And it shows here a photograph of Ms. Mercado's objection that she emailed to you all, and it's filed in by your office July 14th of 2021, correct?
Yes.
And that's obviously 4 days after this second objection deadline that you've provided to Ms. Mercado, correct?
Yes, that's right.
Are you aware that Ms. Polly, Ms. Richmond's attorney, never received a copy of this objection from Ms. Mercado?
You're asking, did Ms. Mercado ever serve Ms. Polly with it?
Correct.
Okay.
Wouldn't have firsthand knowledge of it other than what someone told me.
You didn't argue that at the motion to strike the caveat?
I believe it might have been in the motion. Yes.
Is that a requirement that a objector, whatever we're calling Ms. Mercado,
Mhm.
they have an obligation, one, of timely filing an objection, but also getting it to the claimant seeking the year support?
I know that's general practice, but what we've been taught in probate, because there's a lot of pro se litigants in common forms, that we're kind of lenient on that because the pro se litigants are not aware or made aware of that. So as long as, sometimes we'll step in, and when we determine that the service hasn't been made, we'll serve the parties.
You, again, we talked about this last week and the hearing panel has your order, but you eventually denied the petitioner's motion to strike the caveat and found that it was timely and legally sufficient.
I did.
And your finding that it was timely was based on the fact that you received it via probate judge fax email on June 11th.
Yes.
Correct. Despite the fact that the uniform rules of the probate court required that in order for documents to be filed they have to be accompanied by filing fees.
Yeah, I believe you asked me that last week, but yes,
So the uniform probate court rules didn't matter.
they matter. And, you know, again, there's judicial discretion that utilize here. The caveator showed where she sent the money orders. Nobody just makes a money order out to a place for amount and doesn't intend to send it. So she had the objection. She could prove she did the money order. So yes, I allowed it. And even if we didn't take her payment to July 14th, I ruled that it was timely. Absolutely. I wasn't gonna disregard her objection on technicalities based on the mail.
Do you understand the importance of filing dates?
I believe you asked me that last week. Yes, I do.
Okay, and they're important because there needs to be a date in the record. For example, in this case on which this is the date that the court filed in this objection.
Yes,
Okay, but here this filing date didn't matter because you had gotten it via email previously.
you want me to answer the question again? I've advised that we received it before, and I wasn't going to disallow her objection and any right to her father's estate based on the technicality when she could prove that her objection and her money was sent timely.
And do you find that to be fair to the other party who is relying on the filing dates, which would be the effective date?
I think so. I do. And I also think it's fair that all parties get served proper notice. In this case, I don't believe Steve Richmond Jr. ever got proper notice.
So does that process of you trying to track interested parties down, does it just extend indefinitely?
What do you mean? I'm sorry.
I mean, at what point do you stop trying to track these parties down? I mean, after you put the notice out in the newspaper, which is what is required for parties that are outside of the state, how long do you continue to try to reach them after they haven't responded?
The notice in the newspaper was not for the heirs. The notice in the newspaper are for creditors. So usually, especially in petitions for year support, there are creditors. When they're trying to get a house, you have the mortgage lender has to get notice, different things, but they're also supposed to get service as well. But the publication is for interested parties, not the heirs. Our legal organ is Douglas County Sentinel, and it only has certain people that can see it. We can't expect people that live in New York to get notice of a Douglas County filing in New York.
I'm moving on to complaint 2022-097. Your Honor, are we going to take a break this one?
We were just sorting through whether that would be when you were done asking Judge Peterson questions or a transition like this. What's your best estimate of how much would this be? There's a final segment about backdating. Is that what 097 is about?
Yes.
Okay. Is that an exploration that's more than 15, 20 minutes?
I have this, and then I've got the HOA town hall meeting.
Okay.
Together, I think 20-25 minutes.
Don't break now. Okay, why don't we break now? We're sort of halfway through the morning. It's 10:35 on my bat phone. So why don't we be back at 10:45 to move into is it 21097? I know it ended in 097. 22. Okay, great. We'll do that. Thank you.
I'll make the motion.
Okay, that all right.
This is that three. Yeah. Mhm.
Do what now? Oh, yeah, that's fine. That's fine.
Testifying.
Fine.
Okay.
That's fine. I think when we met, I didn't have any objection. It's fine.
So you all can be seated. if you're still standing. So, Womble, you ready? Great. Ms. Veal, when you're ready, and the more you could be, is that microphone? That may be the official Veal microphone, but folks who are not in here who are trying to follow are hearing Judge Peterson very well and Mr. Hyde, but you not so much. So I don't know if the microphone that's over by the exhibits, because you like to stand there too, if that's on, that would work. Thanks.
Your Honor, I've had copies of the timeline that we referenced several times that were made. And at this time, I'm going to move to tender it as Exhibit 70. And I've got copies for the panel as well.
And this would be the Excel spreadsheet that Judge Peterson prepared. And I think it's what Mr. Tate was referring to when we were last together. And it has not verbatim necessarily, but summaries of some of the email traffic. Okay. Any objection to Director 70? Another thing you don't have to put in?
That's exactly right.
Okay, admitted.
And I'm trying, there may be some confusion about that, but I'm trying to not duplicate, clog the record.
Okay.
And for my questioning now is in reference to complaint 22097. We have agreed to stipulate to the admissibility of exhibits 36 through 47.
Okay, I think 46 is already in, but it can come in again. Mr. Tate, is that right? 30 directors 36 through 47, regardless of what happened with 46, they are all admissible.
I do not have any objection. That's
Okay.
correct, Judge.
Great, they are all in. Thank you for streamlining that.
Judge Peterson, I want to direct your attention to a petition for letters of administration that was filed with your court back on September 17th of 2021. And I'm going to show you at least the cover page of that petition up on the document screen. It's exhibit 36. It's in reference to the estate of Bruce Charles Gordon. Are you familiar with this petition?
Yes.
Okay. And not in the context of this specific hearing, but I know it has come up in other settings. There's been discussion about this estate number, specifically 21E0416. That is actually not the correct estate number, right? Case number, if you will.
I believe it's not.
Okay. I'm going to show you exhibit number 37. This has estate number or case number 21E0420. Do you have any reason to believe that that is not the correct case number?
No.
Okay. Who assigns the case numbers when people come in and file these kind of petitions in your court?
Our new case management system, CJT.
Okay. And so was that case management system utilized to generate this case number?
Probably not. I don't know. I don't process at the front counter, so I don't know how that number got there. But that case number, I believe I looked it up after the fact and it's associated with another case.
Okay. So there was just an error in assigning a case number that was already assigned to another case to this one on the front end. Is that your understanding?
It appears, yes.
Letters of administration. Can you tell us just very generally what the purpose of filing a petition for letters of administration in probate court is?
Letters of administration is filed when there's no will. So the estate, someone from the estate, usually nominated by the heirs, petition to the court to be the administrator of the estate to be able to gather all the assets and distribute them to the heirs.
Okay, and in this circumstance, that would have been a Miss Ashley Jones that petitioned your court to be the administrator of Mr. Gordon, her father's estate.
I believe so. The first line is just who's petitioning on another line would say who they're asking to be nominated. So yes, so under number 5, she's petitioning to be administrator.
Okay, we've got number 5 there on page number 2.
Yes,
And within these petitions, people identify the personal property that was left behind when the decedent passed, and that was done here, correct?
according to them, yes, that's what she verified.
Okay. When you receive letters of administration, there are times that the other heirs agree on the selection of the individual who is going to administer the estate, correct?
Yes,
Okay. And that is called a unanimous selection, correct?
well, I'm not necessarily sure what you're asking. When we get, so a lot of times the petition will indicate they've been selected by the heirs, but we look at these selection by heirs forms. Yes.
And that's attached here, correct?
Let me see. Can you move up to the bottom of the? I can't see the bottom of your yes, that's attached.
Okay.
Yes, that's Ashley Jones, and I don't know who the heirs were listed, but yes, I would usually look for that.
Okay. And so I'm showing you, I'm on page 6 here,
Mhm.
and then,
So these are a series of the same form signed by different heirs saying, we're good with Ms. Jones being appointed the administrator.
yes.
Okay.
So all of the heirs agree, they're good with Ms. Jones being the administrator.
I would have to look at the petition and see who they listed as the heirs. Can you, if you could put that page on, I could see. Right at the front page. So they listed Ashley, Eric, and Jason. Okay, and so I would have to see who made the selections. There's Ashley, Jason, Eric, yes.
All right, so when we have a selection by the heirs of one person to serve as the administrator, the next thing generally that happens is that there would be notice published in the organ, the legal organ, which you mentioned earlier. I'm showing you exhibit number 41. And that was done here, correct?
Yes,
This affidavit of publication is submitted to the probate court from the legal organ after publication has been completed, right?
yes,
Right, and the last date that publication in this matter would have run is November 11th of 21.
that's what I'm saying.
All right, and you've got a signature here from them certifying that publication has been completed on November 11th of 21.
Yes,
Right. So after November 11th of 2021, when publication is complete and the creditors or anybody else interested would have had time to object and they did not, the thing remaining for you as the probate court to do is to issue an order appointing an administrator, correct?
yes, if everything was complete on the case, then yes, once it's comes to me, that would be if I saw no issue, then I would issue an order.
What would you be concerned about or looking for in a scenario like this? If you see that there is I'm gonna use the wrong term, but a waiver or an election by all the named heirs,
Mhm.
yet we want Ashley Jones to do it. And there's this proof of publication.
Mhm.
Have they pretty much checked all the boxes, or in your experience, hey, I gotta confirm these 6 other things?
Well, I think the reason I say this is because I think I just saw the director post a notice that I issued to them, and I might have, I read it and I think I had an issue with the case. So when she asked me what the case number was, that was an issue.
Oh, meaning that first intake sheet had a probate case number that didn't match the other.
So if she could go back to it, it was an order and notice. And I believe that the selection of heirs forms, what I glanced, so this is what I'm thinking I saw. The selection of heirs forms were notarized by the attorney for the petitioner. And that's usually a conflict of interest. I don't allow it. So I usually request that there be a third party do notarize the forms for their other heirs. So I think that's what happened. If you can go back to the order and notice, I would have a true answer for you.
Sure. So the petition was filed September 17th of 21. I'm now showing you exhibit 37 pursuant to your request. This was filed September 22nd. So a few days after the petition. Is that the order and notice you were referencing?
Okay, this was for the verification. So that was issued. Okay. Yeah, that's the order and notice. So if that was complete and the publication was run, then I wouldn't have an issue for signing the orders thereafter.
But these are examples of things that you would detect and say, you need to fix this.
Yeah.
We're gonna move forward.
Yes,
But you did move forward. And
Yes.
then there was publication that was completed November 11th.
it appears. Yes.
Right.
That was the last run date.
Okay, so the only thing left for you to do would have been to issue an order appointing an administrator.
Yes, once I got to the case.
You've said that a few times, once you got to the case or once the case got to you.
Yes.
After this affidavit has been sent to you all by the legal organ and they've said, publication is completed, this is done, it's
Mhm.
ready for you to sign an order. I mean, where is the file at in your office?
Well, there's several parts of my office. You got the front clerk's office, you have a chief clerk that's beside me, you have my chambers. The file could be, I think Bonnie may have, I don't know at the time, she would be more knowledgeable, but I think she has a publication drawer that she's awaiting publications. Generally, when she gets the files back that are ready, she'll put them all in my office. There's a lot of files, a lot of work, so I get to them as soon as I can.
Did you get this file on your desk in November of 21?
I would have gotten, whenever I signed the order is when I would have, and I don't have that date in front of me.
So your testimony is whatever date you wrote onto the order, right above your signature on the order, that would have been when you got the file on your desk for review?
No, that would have been when I got to, I don't know the exact dates when files get to, and it's not my desk, it's my office. There's a lot of files. Let me be clear. I want everybody to understand, we do a lot of work, like filings and petitions, we probably have over 5,000 in a year. And that's just the low end. And that's just petitions. This is not even the other matters that we handle. So I'm the only judge in my office, despite other offices that have other associate judges. It's just me. So yes, when I can get to it, I get to it. So they usually have an order. So they usually put it in order by whenever when it was ready. And then once I get to it, that's when I sign the order.
Okay. Do you know whether that was done in this case?
I'm sure I signed an order.
I'm showing you exhibit 42.
Okay.
Is this the order you're referencing?
I believe so, yes.
And so January 18th of 2022, that would have been the date that the file either got to you or the date that you reviewed the file and signed off on it.
And that's the order granting, appointing the admin. Yes, that would have been it. That's the date.
So the process in your office, when you sign an order,
Mhm.
is it then filed in?
What are you asking?
Is it filed in at the time that you sign the order, on the date that you sign the order?
At the time, I didn't know what the process was. Found out later that they were doing something that they were not necessarily supposed to be doing. But usually it's supposed to be filed in when they receive it or review it. There's
I'm sorry to interrupt, but when you say at the time, so we're now a year into your administration, because this is January 2022.
right.
Okay.
So when I say at the time, usually I sign an order and then I might sign 40 cases, 20 cases in a day or however, and then I'll put them in Bonnie, or I'll give them to Bonnie and put them in her office. Whenever she gets to them, I wasn't aware how she was filing them in. But I know there's been some situations where I would schedule a hearing and I'm supposed to give at least 10 days notice. And then she'll tell me, I'm sorry, Judge, I just didn't get to that file. So you have to reset the hearing. So there's been instances like that but we have a better system now. But I'm saying then we were not. We were learning, we were figuring it out.
Okay, so you didn't have a conversation with Bonnie or anyone on your staff that, hey, when I sign an order and date it, it needs to be filed in. At that time?
I was thinking that I would never assume that was not happening.
Okay, so you were unaware for an entire year that essentially the practice was to make this date match whatever date you wrote on an order.
I learned that after you all filed your complaint against me. Yes.
Okay, and so it was after that point that you corrected this practice.
Absolutely. Absolutely.
When someone, how does your office notify individuals that you have signed an order and that it's time for them to come in and take their oath in the circumstance?
Some clerks, I don't know who calls or who does what, but generally there might be an email or a call made. Sometimes the people call in and they might tell them it's available.
And that communication to the individual, hey, it's time for you to come in to take your oath, that should happen at or around the time you signed your order, right?
No. Again, we're talking about then. At that time is going to be when Bonnie got to it. She was the only person processing after I signed. Now I have widened the process and allowed others to assist her because she was just backed up. So she may not get to it exactly when I sign. So now I have a different system where my orders are filed in on the day that I sign the orders.
Do you know whether you were in your office on January 18th of 2022?
I was.
Okay. And were you in the office the rest of that week?
No,
You were in New Orleans?
I believe so.
So you're in the office January 18th of 22. And that's when you signed.
Switching it back.
the order?
Yes.
It's back. I switched it back.
And you said you would have then put it on Bonnie's desk.
I would have. Yes. So I don't know. Let me be back then. I don't know if I would have signed it and Bonnie had a basket in my office, or did I take them to her office? I'm not aware, but basically they were collected and given to Bonnie, or she got them from my office.
Have you reviewed the other documents associated with this case, in particular, the instructions to the administrators, Exhibit 43, and the oath, Exhibit 44, and the letters of administration, Exhibit 45?
Have I reviewed them? Not necessarily, no. I would have reviewed the letters of administration because when I signed, anytime I sign orders, I go ahead and put a signature for the letter. So whenever they come in, the clerks are at the date. So they don't issue the letters until after the oath is taken.
I'm sorry, in advance of this hearing, did you review the documents associated with this case?
I'm answering your question. I would have reviewed the letters that I signed because I signed them.
Did you review the instructions, the oath, or your order?
Or the what, I'm sorry?
Your order
I generally don't review the oath and the instruction.
in preparation for
Isn't
this
generally,
case?
it's for.
Oh,
preparing
no, I'm
for
sorry.
today.
I did not. I'm sorry. No, I did not.
You didn't look at these documents which directly relate to the formal charges in this case.
No, I didn't review. Like I said, I believe the thing within question was the order. So yeah, I reviewed what I signed.
Showing you JQC exhibit number 43. This is the instructions to the administrator, which was filed in January 24th of 2022.
Okay,
And the instructions are instructions given by whoever the clerk is that is administering the oath to the individual taking the oath, and that individual signs them, correct?
yes,
All right. Showing you the oath that was taken, that's exhibit number 44. That was signed and dated by your clerk, Jacqueline Caldwell, on January 24th of 2022.
yes,
And filed in on that date, correct?
yes,
Okay. So do we agree that the date that Ms. Jones came in to take the oath into your office was January 24th of 22?
yes.
Okay. And then the letters of administration. Looks like it was dated by Ms. Caldwell, January 24th of 22, but signed by you. Is that correct?
Yes,
This document is filed on January 24th of 2022 as well.
yes.
All right, I want you to explain for us, we've got two different filing stamps here, and I want the hearing panel to be clear. This filing stamp that also has a time on it, that's the electronic filing stamp, correct? Where you put the document in and it makes a loud noise,
I think so. Yes,
and you all keep that up at the front of your office?
yes. I think all the stamps are kept at the front.
But the one that Ms. Veal just asked you about is sort of like the power stapler or the time card. You put it in,
Yes.
it goes ka-chunk
Yes.
loudly. Stamp.
Yes,
All right, and then on your order appointing the administrator, this stamp, that's different from the electronic loud stamp that Judge McBurney was just referencing.
you talking about this one?
That one's different, correct?
It's different. Yeah,
That is a manual, like a hand filing stamp, correct?
yes.
And you said that one stays up the front of your office?
I believe so. I wouldn't, I guess. I think now, yeah, I believe so. I don't know. I don't know where they keep them. I don't stamp, but I know Bonnie may have a stamp and Shanika may. So if they do, then there will be some in the back as well. But they're supposed to, generally the clerks up front do it, but if they're assisting, they would have stamps.
We see that stamp was used on your order appointing administrator and also on the instructions. Do you agree?
Yeah, yes,
Okay. And then the other two documents, the oath and the letters, the electronic stamp was used with those two.
yes,
You agree that your order appointing administrator is the only one that is filed in, making the effective date of your order January 18th of 2022.
I'm sorry.
Do you agree that your order appointing administrator is the only document of the four that was filed in on this date, January 18th of 2022?
That's what it's stamped to say, yes.
Everything else was filed in on January 24th of 2022 when Ms. Jones came in to take her oath.
It
correct?
appears, yes.
Okay. And I understand that you are now aware, but I just want to be clear that at the time that this occurred, so in January of 2022, you were not aware that your clerks were manually adjusting backward the filing stamp to make the date match whatever date you wrote on the order.
I was not, no,
You had never seen that happening in your office?
never.
Judge, would you consider that appropriate or inappropriate, or it doesn't matter?
It's not appropriate. I didn't know it was going on. I wouldn't have thought to think it was going on. So once I was alerted to it by the JQC, I talked to my clerk and asked them what they were doing. And the only person there who could have told them was prior staff from the prior administration, and that's how they were trained. And so I had to retrain them on this issue.
Were you aware that prior to January 18th of 2020, that Ms. Jones' attorney, Miranda Jordan, had called your office several times to inquire on the status of the order?
I'm not aware.
Right. Were you at the time aware?
What do you mean on that day? I don't take calls, so I wouldn't have been aware of any calls.
But you'd be aware if your staff said, hey, the lawyer in the Bruce Charles Gordon estate case has been calling, wondering what's going on.
They would say that, but generally they give me files. So they would put files on my desk if that was the case. So they don't usually say, hey, these are the conversations. They say, Judge, here's the files you need to review.
Would your staff tell a party that the file was on your desk for signature if it was not?
Yes, at that time they would have.
Your staff would have told a party calling to inquire, hey, has the judge signed this order? It's been since November that it was ready. Your staff would have said it's on her desk for signature if it wasn't?
That's nothing I instructed them, but the reason I'm saying they would have is because I've heard a phone call that was submitted by you all, and that's what was told. So that's what she told them. Now they don't say things like that, but I think that was an easy way, but based on the caseload that they have, that was a way to just get the party off the phone. If they didn't see a disposition necessarily in CJT, then they would move on, say it's waiting for the judge's signature.
So that was essentially just a line to put people off.
Well, I believe in this instance, it was checked on the system, and the system appeared to not reveal a disposition, and it generally doesn't, especially if the disposition date we usually do is when letters are signed. Sometimes the orders are signed. She didn't see a disposition, apparently. I'm just going off what I heard, so I don't really have firsthand knowledge of these conversations.
The probate judges have a requirement in the code, the Georgia code, not the code judicial conduct, to rule within a certain amount of time, like Superior Court judges do.
I don't know. I don't think it's a certain time,
Number of days.
no, there's not a number of days, definitely. And around this time, like I said, 2021, when I came into office, that was amidst COVID, and we had an increasing number of estate petitions because there was a lot of deaths. So obviously it was way more than expected, as well as we had a lot of clerks out because of COVID. So we were operating on what we had. So it was just a heavy volume.
But the only thing left to do on this case between November and January, it was just for you to sign the order. I mean, it was just a signature on the order.
That would have been the only thing, but the case has to get to me. Again, I want to make it very clear that the caseload is very high, and I'm the only person in my court that can sign orders, unlike other probate courts. But I did ask for legal, and those requests for staff attorneys or other budgetary items have been obstructed somehow. So again, was doing the best I can with myself as the judge only one signing every order in this court.
You were served with a petition for a writ of mandamus in reference to this case, correct?
I don't know if I was personally served. I know I got the petition. I don't recall if I was given it or a clerk gave it to me or how it happened, but I recall the service.
That's not something that sticks out to you, regardless of how you got it, that you were served with a petition for writ of mandamus?
I get served a lot. People at the probate in all type of matters that don't even concern the probate. So there's a lot of times it comes to me, you know, my clerks will say, hey, this was dropped off, and I get it, and then I just send it to the county attorney.
So a mandamus wouldn't send off a red flag to you as being more extraordinary than some of the other stuff you get?
Not necessarily, because I've never been served a mandamus, so everything I get probably would be a red flag. So even things I wasn't interested, like that wasn't concerning the probate, I still send it off. It's still of importance. So everything has been of equal importance.
A mandamus, aren't you being sued in your official capacity with?
Yes, and yes, that's what this was. Yes, yes, that's what this matter was.
I'm going to show you the sheriff's entry of service. Perhaps this will help you recall whether you were personally served. And we heard from Lieutenant Graham last week.
Mhm.
Were you able to see that?
I do see it. Yes.
Okay, yeah, I have this day served the defendant Christina J. Peterson personally with a copy of the within action and summons.
Okay.
See that?
I see it. Yes.
On January 24th of 2022.
Yes, I see that.
Okay, and then we see down here that this was filed in by the sheriff's office on January 24th at 9:40 a.m.
I see that. I wouldn't have any notice or knowledge of this document or preparation.
Sure. Do you recall being personally served by Lieutenant Graham with this mandamus on January 24th of 22?
I don't.
40 in the morning? You don't?
I don't specifically know.
Do you recall thinking, I know you said you send this stuff to the county attorney, but did you look at the petition for the writ of mandamus to figure out what it was about?
When I got my hands on it, I did.
Right. And you determined that it was about your failure to issue an order in this matter, correct?
Yes, when I read it.
Well, when did you read it?
I don't recall. Whenever I don't recall when I was served and when I looked at it. I don't recall. This was 2 years ago.
Judge, are you often served with papers by a sheriff's deputy?
No, generally they serve my office. So yes, but so there's service, yes, of materials, but there's like, it comes in, there's various service.
My question is, are you often personally served with documents by a sheriff's deputy?
Not generally, no,
This particular incident doesn't stick out in your mind?
it doesn't.
It seems like you don't recall a good amount of these issues, which are more recent than many of the other issues that we've discussed during this proceeding. Do you recall pulling the file thinking, oh my gosh, I'm being sued for not issuing an order. I need to pull the file and look and see what the status is?
No,
You don't recall doing that?
no.
What,
If anything, if I saw it, I would have generally looked into CJT to see what's going on with it.
but you don't know if you did that in this instance?
I'm sure I did. I don't specifically recall, but I'm pretty sure I would have.
At what point did you figure out, hey, an order hasn't been issued in this case yet? Let me do something about it.
When I reviewed the information, the order had already been signed.
When you reviewed what information?
When I reviewed the information on CJT, the order had been signed.
So at the time you were served the writ of mandamus, you found that you had already signed the order.
When I reviewed the writ of mandamus, yes, there was an order already signed in this case, on the 18th.
So that would have been on or after January 24th of 2022.
I'm sorry, did I say the wrong day? I said January 18th. I think I might have said,
The question, the dates are sort of blended together here. The question is, when you finally learned what the mandamus was about, that would have been the 24th or later, would have been the date that Lieutenant Graham has testified, she handed you the lawsuit, or later than that. That's when you would have found out.
yes,
Someone's fussing about this case. Let me look in the system. At least 6 days earlier,
Right.
I signed the order that they're saying they need.
yes.
Right, and what did you do when you figured out, wow, that order was signed on January 18th?
I didn't have to do anything. Apparently it had already been, I think Bonnie had emailed, or I'm just going by what I know, what I've heard. But by that time, Bonnie emailed whoever she has to email, the petitioner or the attorney, to say it's available. She had already done that.
Did you go in and say to Bonnie, hey, I'm being sued for not issuing an order, and I signed that order on January 18th?
No,
Where is it?
no,
Did you have any conversations with
I did
Bonnie?
not. No,
You, how close is Bonnie's office to yours?
it's right next door.
Okay. And so if you have to walk past Bonnie's office to get to yours, correct?
No, I'm the first office.
But she's right next door to you.
Yes,
And so your testimony is that it just so happened that Bonnie had already emailed the lawyer or notified the lawyer that the order was ready.
yes. From what my understanding, I don't have firsthand, I don't engage in those communications.
I'm going to show you exhibit 47. Have you seen this email from Ms. Fazek to Ms. Jordan, who was the attorney in the case?
I believe I might have saw it with your JQC disclosures.
Okay, so Monday, January 24th, 2022 at 11:13 a.m. Your chief clerk notified the attorney that had filed a petition for writ of mandamus against you, that you had signed the order on the above reference case.
I'm sorry, what was the question?
The notification went to the attorney on January 24th at 11:13 a.m., correct?
That's what it appears.
So it's just a coincidence that Bonnie notified her within, 2 hours of you being served with the petition for the writ of mandamus?
I don't know what it is. I just know that I did what I did, and it is what it is.
And your testimony is you and Bonnie had no conversations about
We did not.
mandamus.
We did not.
All right, I am going to move on to the final complaint 22275. Judge Peterson, how long have you lived in your current neighborhood?
Since 2015, I believe.
Okay, and what's the name of your neighborhood?
Silver Creek Ranch.
Silver Creek Ranch?
Yes.
And there's a requirement that individuals who reside in your neighborhood are be members of the HOA, right?
Yes, mandatory members.
Back on March 31st of 22, you had at that time 2 lawsuits pending against your HOA.
Yes, I believe so.
There was one that you had filed back in 2018 that was still pending trial at that time. Does that sound accurate?
Yes.
Okay, and then there was a second one, 21 CB 01198 that you had filed on July 13th of 2021 against your HOA, correct?
20, yes, there was a 21 case and an 18 case, yes.
My interest for our purposes right now is the 21 case, so filed in July of 21. On March 31st of 2022, that matter also still pending.
I believe so.
Your complaint against the HOA in that matter, in that lawsuit, in part was that they had improperly conducted the most recent election, correct?
Yes, that they invalidated my nominations. They didn't allow me to vote, yes. And they didn't have a sufficient election because of that, yes.
Were you running, or when you say nomination, were you running to get on the board or whatever it would be, or you had nominated someone and your choice somehow
Yes.
wasn't handled correctly?
I nominated 4 people and they were not placed on the ballot.
That issue was subject of your 2021 lawsuit.
Yes, I believe so, yes.
Okay, and within your 2021 lawsuit, one of the remedies that you sought an interlocutory injunction, and then you sought to have the HOA compelled to hold a special election, correct?
That was, believe that was part of the injunction.
Okay.
Yeah,
But my point is the relief you were seeking was that they be forced to hold a special election, or they be required to hold a special election.
I was seeking both. I was seeking to have to damages and trial on the matters, and I was seeking an injunctive relief. I believe that was count 2 or 3. I don't have the complaint in front of me, but I believe that was one of the counts.
Did you have a lawyer or you were representing yourself?
I was representing myself.
The HOA had a lawyer at that time, correct?
I believe a lawyer was appointed in that case, yes.
What do you mean by
Uh,
sounds like a criminal case?
I'm sorry, under the insurance, they have insurance, so I believe the insurance provided the HOA with an attorney.
And that firm was at Lazega and Johansson.
I believe so.
So they were representing the interest of the HOA in that firm, and you knew that on March 31st of 22.
Yeah, they were representing who I understood to be the HOA. Yes. Then that's the when I say HOA, that would be the board of directors for the HOA.
So was that lawyer only representing the board of directors or all the members of the HOA? Obviously, other than you.
Well, how it's in the lawsuit, how it's explained to the members by the attorneys generally is they're representing the board of directors.
Is that who you sued? The board of directors?
Well, I had to name the HOA, but I believe I specifically named who the board of directors. I generally name who the board of directors is in the lawsuits.
Do you recall naming them to be Consuelo Hall, Quentin Wiggles, and Emmanuel Saint?
Yes, I believe I'm not sure that last name is correct on Emmanuel, but yes,
Right, and that would have been, you named them at the time you filed this July 13th of 21?
that's right.
That's three names, and you said you nominated four. Were you nominating four for three positions, or did you miss a board member?
No, we were supposed to be voting on an entire board. So I was nominating 4 just to be voted on the board. So we were replacing, it was supposed to be an annual election. We were replacing all board members. That wasn't allowed.
How many board members are there?
3, supposed to be 3.
So why would you nominate four? One of the people you nominated couldn't win.
Well, no. So this is the procedure and process identified by the HOA. They wanted us to submit nominations and they'll put all the names on the ballot. So the HOA, the members would pick 3 from all the named people.
Okay, so you were nominating someone who couldn't win.
Yes, I was allowing the HOA the members to select out of the 4 names that I presented who they wanted.
The status of the 21 lawsuit back on March 31st of 22 was that you had filed a motion seeking your injunction. And the HOA had filed a response opposing your request, correct?
Yes, that probably happened.
And there had not been a hearing on either of those motions on March 31st of 22.
I don't recall.
You know what judge the case was in front of?
Emerson, I believe.
You were a party to a lawsuit that was presided over by David Emerson.
Yes,
Did you ever file a motion to recuse him?
no. Not in that matter. As you saying after I became a judge.
So what matters did you file a motion?
Well, there was a previous matter. I didn't file the motion, but this is before I became a judge. There was a matter that he spoke of, Judge Emerson, while he was on the bench of the dispute, the family matter, domestic dispute, and the other attorney filed a motion to recuse him because of his behavior in that case against us. And he denied that motion.
That was a domestic case when you were a lawyer.
That's right.
Correct? That's the one he referenced when he was
That's right.
speaking about how he formed his opinion about you.
That's right. I believe so.
So, but this lawsuit that you filed in 2021, Judge Emerson never presided over it or made any decisions in this case, correct?
Okay, so maybe it was the 2018 case. He was the judge over one of them. So I believe it was if you're saying it's not this one, then it was the 2018 that he was the judge over, yes.
2018, before you were a judge in that circuit.
Yes, but it's still pending to this day. So he was,
And he recused from that case once you became a judge in the circuit, correct?
I believe at some point, all of the judges were recused of all. After a while, all of the judges were recused.
So that had more to do with judges not hearing cases in the same circuit of other judges.
Yeah.
Had nothing to do with any alleged bias or animosity between the two.
Right.
So in fact, your answer earlier that Judge David Emerson was assigned or presided over this case, that is inaccurate. It's actually Judge Sutton, correct?
No,
And then Judge Brantley.
It was we don't need to dive deep. It was originally Judge Emerson or McLean. It was the Douglas judge, but they have to have recused
yes,
once you became a judge.
that's right. That's right.
And so then it sounds like it was a Judge Sutton and ultimately Judge Brandt.
That's right.
Okay, do you agree with me that there had not been a hearing on your request for an injunction and your request to compel the HOA to hold a special election at the time that you attended the HOA town hall meeting?
Right. I believe there hasn't been.
So all of those, your requests were outstanding and the HOA had opposed them.
Yes, the attorneys. Mhm.
At the time of the town hall meeting on March 31st of 22, the board consisted of Derek Houston, Quentin Wiggles, and Consueler Hall, correct?
No. To my understanding, the board consisted of who I named in my lawsuit. We never had an election.
On May 31st of 2022, the board that was running that town hall meeting was Derek Houston, who was named as the president at the time, correct?
No, he was not named. You can, and you're asking me a question, I'm going to answer it how I understand it. He was never elected. There was no election held. He was holding himself out as the president. That is a fact, but he was not elected, duly elected to be president of the HOA. And Consuela Hall no longer lived in our neighborhood. She had moved out, and our bylaws specifically state that you have to be a resident.
So I don't want us to litigate that case. Who were the three people who held themselves out to be the board of directors of the HOA at the March 31st, 2022 meeting?
It was only two people. It was Derek Houston and it was Quentin Wiggles.
Okay.
Judge Peterson, during the course of that meeting, I believe it was during the Q&A portion, you began to ask questions of the people who were holding themselves out to be the HOA board at the time, correct?
Yes,
Specifically, you asked them more than once to hold a special election.
yes.
Have you reviewed the video that was captured during that portion of the HOA meeting?
I believe if it was submitted by JQC, I did.
Or you play it. It's not in. Any objection, Mr. Tate, to this being, it's in the sense that it's already been made part of the record, but for this proceeding, it's not yet.
I know, what? Can I just have one second?
Sure.
I think I believe when we had our hearing, I submitted it, so I
You
don't.
did, it's just, this is a different hearing.
Yes, right, yeah. So
Okay,
I don't-
it's admitted. And also before you start playing, do we see Wiggles or Houston on the screen right now?
No,
Okay.
Your Honor, we have prepared transcripts here that we're about to play. We provided a copy of our transcript to Mr. Tate.
That was very nice.
Ma-
I do,
thank you.
I do need to make an objection about the transcript. And, you know, we've had the, you know, our office tried to transcribe the others. I just want you to know there's some dispute over what was said here, and we have a witness who will be coming, who was standing next to Judge Peterson when she said certain things.
Okay, I don't want you to get into
And
that.
I don't want to, I just want you to be, I hope it helps you follow along, but I don't want to commit myself to that as being a verbatim transcript, because there will be testimony that shows that, frankly, the thing she's accused of saying certain slurs has been characterized by the JQC was not in fact what she said.
This will be an aid.
May I publish the video of this?
Please.
Yeah, do we have a copy of do you have a copy for me?
tried to get on the meeting and were not allowed access. You also mentioned lawsuits. I'm the one who's doing half of my neighbors, they didn't get people to let their vote. Now, my question to you is, well, I know personally, I submitted nomination for certain.
There an audio control up there?
I'm trying to make it louder. It's turning yellow as I press this button, but why don't you press play again? The other one was so loud, I tried turning it down. We're being yelled at.
That were not. A lot of people were not able to get on that meeting. I believe it was hosted by ACF. It was not an annual meeting, and it was invited as a bylaw. You said y'all have 2 board members right now. Our bylaw says you cannot be allowed to.
We actually have 3 because we still have Consuela that her home is not sold yet, number 1. Number 2, I just want to address your points.
Okay, you just announced to the.
Well, that's what's here right now. She's selling her house, but it is not sold as of yet.
For how to make. It's not even-
It's still in the- So technically, if you want technicality, but if someone moves out and dominate, which is the other board member, has moved out as well.
Yeah.
So, and I'm gonna address this.
I didn't get my question. Okay, so what I'm asking is, because, again, the lawsuit is being filed, and again, anybody who has information was denied access, give it to me if you want to serve it, but nevertheless, you can make it right, because you are now acting board. You have the ability to call a special election, to give the homeowner the opportunity to come, congregate, nominate, and elect their own board. You have that opportunity. I respect what you're doing, but it wasn't done right. So you, if you are acting board, call a special election, put notice out to everybody and let them get vote. That's what I'm advocating for in my lawsuit. And that's all we want to continue on advocating for. So my request at this day, at this time of this day, people before Mr. Houston and for the who are not here, will you call a special election?
Can you pause it?
So at this point in time, I do not have an answer.
So Judge Peterson, just so I'm understanding this, you're basically talking to represented defendants about the lawsuit, calling for witnesses and suggesting a course of conduct in connection with the lawsuit you brought against represented individuals. What am I missing?
Well, because they said they were represented, I was not under the.
They didn't say anything about being represented right here. I didn't hear Mr. Houston say that at all. You brought a lawsuit before this. By now it's a year old.
Right.
And you seem to know that Lozega and Johansson was representing the people you had sued. So
From,
I just want to make sure I'm understanding the dynamic. I'm not asking you,
Yeah.
did you think it was a good idea? But you're talking to represented litigants right now about the lawsuit. Yes or no?
it was my understanding at the time that I was not talking to represented litigants. When I filed the lawsuit, there was an acting board of directors. Lozega and Johansson never advised me that there was a change in that representation or a new board. When we get to this meeting, there's a new person representing. Quentin Wiggles never spoke. So the only person talking was this Derek Houston that the community never voted for, never elected, never talked to, don't know who he is. So I took his word on whatever he wants to hold himself out to, and I'm talking to him to ask him, well, obviously, you've put yourself in this situation to control this HOA. Can you call a special election? It was my understanding that he was not represented. I was never updated on the representation or who the board was at the time.
Were any of the HOA's lawyers in that facility?
No.
Could you refresh my recollection? Who were named as defendants?
Consuela Hall, Emmanuel, I think his son Saint, and Quentin Wiggles.
And Quentin Wiggles was there,
He was there. He wasn't speaking. He was just there.
but you're directing your comments to the folks who are there representing the HOA.
Allegedly representing.
I didn't ask you a question. I asked Judge Peterson, she's answered.
I was
Under oath.
I was hoping to reaffirm an objection here.
Oh, okay.
Because I think this specifically goes to the heart of the objection I raised regarding the First Amendment. And
Okay, and that's preserved.
I just want to, that's all I need to know, because since this was brought into complete focus, particularly based on your question, just wanted to make sure that was there.
Okay, noted. And that is always looming in the background, that there will be articulated at a certain point that Judge Peterson is free to say the things she wants pursuant to the First Amendment. And we'll work through what being a judge has to do in perhaps curtailing some of the freedom you might otherwise have. And it doesn't sound that there's any dispute that that's Judge Peterson that we're looking at right there. At that time, she's a judge. She also happened to be a litigant. And my question was, were you speaking to represented litigants? She has answered in the way she thinks is appropriate, and we're processing that. Back to you, Ms. Veal.
I'm gonna put it to you. I'm gonna tell you what was told to me by our legal firm, which is the Vega and Johansson.
Just in case there was any question about Ms. Dagan and Johansson.
Vote went out in June. You had to follow vote either online or by paper ballot. There was no quorum. Quorum is 2/3 of the total of our subdivision. 2/3 of 235, right? Then a second vote went out, so it's 2/3 of the 2/3. And that was not met as well. So I can read to you. Want to go there?
No, we don't.
Okay, Bob, let me go.
Okay, well.
You asked one question.
Tell me what a
I can only go by our legal, it's not 30. I understand.
The probate judge knows what she's talking about. Listen to her. She got 2 pending lawsuits against us right now.
So what I'm saying is, no, listen, so
Oh, seriously.
if you can't get formed, if you deny access to people to the.
But Christina, come on now. This man taking the liberty to step up and do a free job as a homeowner of this community, and you keep tearing this community up. Because when we come to this, we came here to praise this man for speaking up to volunteer. No, you want to keep keeping up mess. You want to keep keeping up mess. You want to keep keeping up mess.
We ain't come over here to that. We came over here to hear about something positive.
Don't say that.
I know. We're not getting here over there. So we wasn't, we came over here to know what's going on in the community. If you're suing, and you're getting money or you're taking something from this community, I don't think you should be speaking out like that. Don't take that from somebody who ain't got nothing. Seriously. That's the way I feel. Okay, that's the way I feel. That's a man. This is the man. That's the man.
The HOA if they follow the law. How about that?
Alright, so now-
You're gonna put it in my favor.
We ain't got nothing. Ain't nobody there. We struggle in the neighborhood for all of that. Somebody see.
You're gonna continue to be, not have everything, you don't follow the law.
What's wrong with it?
You're gonna follow the law.
You're going to follow the law. Do what the Supreme Court tells you to do. How about you pay attention to that? How about you pay attention to that? Why you stole the $70,000 from your plaintiffs? Give them their money. Give them their money. Give them their money. We're in the same place you right here at this meeting, right? Trying to see how you could come up again out the homeowners, right? You got 2 pending lawsuits right now. You.
Don't give him no energy. Don't give him no energy. Don't give him no energy. Don't give him nothing. Don't give him the energy. Let God fight this. Yeah. Let God. He got it.
I heard, hold on. I was talking to people that have a vote in, and we didn't have enough people voting. That's why I'm here.
You think what I tell us about the how we did over here before? Every time. Every time.
But I'm not.
Every single thing is not gonna change. Not gonna change.
People don't vote, people don't elect. There's no.
That really is the
That's why at the Reconvening. This group of citizens here that want
You gotta have some order though.
do this community and they can do anything, they get blindsided by this.
But now we have new people in here. We're better. Exactly.
I'm Dana Pope. I live just up the street. I just want to change the vibe here.
There you
And just to let everybody know that, in May, the second Tuesday, I think in May, the county, the zoning committee is having a meeting there. Of course, you see all these warehouses that are now coming up in our area, like wildfire. And we're probably gonna start looking like Fulton Industrial sooner or later. I mean, I moved here 25 years ago because of the holiness of the community. Everybody, you know, had that country vibe. I'm from Louisiana. I wave at everybody. If I'm outside, I'm gonna wave at you. So it's me. So don't be like, who's the strange, crazy lady? It's me. I'm country. So, and I'm tired of seeing all these warehouses going up. Country ball. And people are coming in with all their money. They're dumping it and they're leaving it. They don't care about us. They don't care about the community. They don't care about all these trucks that are potentially causing accidents and things of that nature. So if y'all are free, the meeting is gonna be on Zoom. It's gonna be the last Zoom meeting I think they'll probably have, and then I think they're moving back to in person. Yeah, it'll be at the town hall at the courthouse. So if y'all are interested in trying to stop more developers coming in and ruining our community and making it all industrial, please come to attend. Yeah, I'm sitting in this car. And this all done county well, because I'm tired of seeing these because we've got 3 on lead trees coming up. Yeah, and I understand they're putting housing
They just put more on Westport. And the builder claims, oh, we
Yeah,
can't
that's
take
a house.
abandonment from Westport because it's too expensive to rebuild. So you trying to tell me that you go excavate a whole area with trees and redo the land, and it's cheaper to do that than to take an old building that's already in existence? We don't want you. I'm sorry, we don't want you. So if y'all are interested in trying to keep our community a community and keeping it homely and keeping it a little bit of country, a little bit of city, please come on out to the meeting. I'll be on Zoom that night too, to speak my mind. So.
Thank you, Dana. Yeah. It's supposed to be, I heard it's supposed to be residential. Whatever it is.
I do not know, and you know, question I should have asked when I went down because it's.
All we gotta do is call the county planning. I'll find it.
But I tell you what, if I go down there, I will.
All you gotta do is call.
Slip my mind, I meant to ask that.
It's residential though.
Get that information as well, instead of the election. You're also residential, so I don't know. The other question?
Thank you.
Judge Peterson, during the exchange where you were telling to use your words, the individuals that were holding themselves out to be the HOA board members, when you told them they were going to follow the law, and if you come in my courtroom, what were you going to tell them would happen in your courtroom?
That was directed to the person recording. That's the one who was hollering and who announced that this is the probate judge. That wasn't the board. So what was the question?
So what was going to happen when if you were directing it toward Miss Tammy Tatum, is what you're testifying to? What was going to happen to her when she came into your courtroom?
Nothing was going to happen. What I was saying is, she was saying, the premise was, I have to go back to it, but it was something about, she was saying something about following the law. And yes, that's what I uphold, is the law as well. So the law, as I understand it, the law that I apply, it's going to be held. It's not going to be based on race, creed, politics, anything. It's making rulings on the law.
Speaking of recordings, it looked at one point like you had your phone up. Do you have a recording of that exchange?
No, I don't.
Did you have it and you don't anymore?
No, I just held it up to, hopefully, I thought it was gonna make her put hers down, but it didn't. So I just held my phone up.
I don't have anything further at this time.
Mr. Tate, tell me your preference. It's noon, so we could break for lunch. We could get partway through because we broke fairly recently. If you want to start a direct exam, do you plan on doing any direct exam?
I do plan on doing a direct. I do plan on doing a direct exam, and I plan on going back through all the things, hopefully not to plow the same ground, but to point out differences about that. I would just as soon break for lunch and it seems like it's a natural place to sort of do that.
It is.
But I'm happy to do whatever works with you.
No, we'll break now. You can get organized some over, not that you aren't already, but it's now your turn. And we'll appreciate you being as precise in your revisiting of those areas. We got a couple tillings of certain topics because we revisited some things today that we had covered last week. But I don't mean in any way to suggest you're limited in your direct, other than caveat. In your case in chief, if you call, Judge Peterson will probably be somewhat restrictive if you are then revisiting what you chose to cover now. So you've got that luxury of, I'm going to touch these things now, and I may keep some powder dry for if you choose to call Judge Peterson in your case in chief.
I'm sure I'll forget something, but hopefully it will be something that I've forgotten to do as opposed to something that I did before. But hopefully I won't have forgotten what I did before. I'll put it that way.
Well, we will remember what you did before, so we'll help keep those guardrails up. So, Mr. Chamberlain. He likes it when you do that. We're good?
Yeah.
Okay. Let's try to be back by 1:15. And poor Judge Peterson will still be on the stand, but it will be for a direct examination from Mr. Tate. Thanks, everyone.
1:15.
Judge,
Show you something.
Thanks.
Okay, great, thank you.
448 court state, 7.
got fed. That doesn't quite sound fair. Here. I haven't noticed. Been, Clerical, we got a courtroom that, it's a bigger courtroom, it's probably about this size. And it's, get it cooled down, you have to run the air on high, but when you're running the air on high, you can't hear a thing. You know, the witness, you could hear that part, you never hear. So they try to get it down to about 60 degrees and so it slowly go back up, you know. And then turn it back on later. Yeah. It's a lot. I'm gonna show you sort of what I'm gonna do here. Okay. Perfect. So I'm on. Okay. But so what I'm gonna do is I'm going back to the charges. Probably use yeah, so I'll probably use those, get those to come up, and then at the end of each section. But that's basically what I'm doing. Hey, how are you, man? You all right? Doing great. Doing great. You know?
And we use those 18 items.
Yeah.
Okay.
So is that the easiest thing for you?
And, so each of those sections, your 18 numbers always start at zeros.
Okay.
Yeah, we're in marriage license.
I got you. I got you.
If you're sorry,
I got you. I got you.
Period. Yeah. Water bottle.
Yeah.
I need to be like the rest of my team, like an adult and, you know.
Always put remodel.
What is that bottle like? Then I'll just bring my cup tomorrow. I said it was supposed to rain this morning and now it's. I just felt like a lightning notification.
Good afternoon, everyone. Come be seated. Please. Womble, you ready? You have an okay lunch? Eat in or out? Where'd you go? All right. Excellent. Well, good. Okay. Well, we're back on the record after our lunch break in the Judge Peterson matter. Ms. Veal announced just before lunch that she had completed her cross-examination of Judge Peterson. So now, Mr. Tate, it's your opportunity, should you want to conduct a direct examination of your client.
I will avail myself of that opportunity with your honor's permission.
You have it.
Thank you. Judge Peterson, you're still under oath, and I want to start out by asking you a question. Is that too loud?
Oh, let me turn the volume down too. I had turned it up for that video.
I'm a little louder and more boisterous than Director Veal, so.
Okay, well, we've got your volume under control now.
All right, thank you. I want to ask you a simple, but I think interesting question to start out with. Why in the world did you want to be probate court judge? What led you to want to do that?
Oh, my. Well, I was very active in the community once I got to Douglas County in 2015. When I left the DA's office, I stayed active in the community affairs. I was active in my HOA. I was active with the foster parents and DFACs, and I was active with the political parties. So I just stayed active. And then honestly, when the position, I ran for office in 2018, I didn't win there. When this one, Solicitor General, yes. Then when this one, this election came, I learned that the then probate judge was retiring, and the constituents, you know, they mentioned I should run. I never told them I would, but I decided to get in there to
Never told who that you would.
anyone.
Anyone.
Yeah,
Yes.
people would tell me, you know, you should do it, you should run for this and you should do that. But I never advised or informed anyone until I actually qualified. But I just felt it would be a good placement. I do well at, you know, administering, in my opinion, administering justice. I like fairness. I serve as an impartial juror, and I thought it would be a good fit for me.
Okay. And your election, along with a population change in Douglas County, which I'm guessing had occurred before, but your election spurred a change in what the probate court would be, correct?
Yes. To my surprise, I was not aware of it, but when I ran for office and I won, I was notified that my court was now going to be an Article 6 probate court. So there's a lot of different operations than what was from the prior administration.
Okay. And if I could lead just a bit here, an Article 6, yes, an Article 6 court, you can try jury trials and probate matters, correct?
Yes, yes.
And it's a pretty different animal from the non-Article 6 probate court.
Yes, it's much more formal. The court, not saying other probates, non-Article 6 are not formal, but I know ours was operating in a non-formal or informal capacity. It's much more formal. We have to be in the courtroom. We have jury trial authority. We have, if we're appealed, it's appealed to the Court of Appeals, different things like that. We have our full jurisdiction of the probate. Before the Article 6, certain matters would go to Superior Court.
Okay. And so when you became the probate judge, were there, you know, a lot of times, you know, when Judge McBurney or Judge Lopez, they succeeded whoever, they had basically the same job that their predecessor had. Did you have to make some institutional changes?
Absolutely.
In addition to just taking over from where your predecessor was?
A lot of changes, a lot.
To give us a small sampling of those.
Well, when you get in the door, like I said, I tried to do as much as I could before I got there, but it's not much you can do before I'm sworn in and actually in the seat. So before I got there, I looked at basically who the staff was, because different from the other judges, probates, I have to be responsible for a staff. So I'm responsible for everything they do. If they're doing wrong, it comes back to me, so what I looked at is their files, their personnel files to see who they are. When I came and met everybody, when I got to the court, like I said, I met everybody. I saw what they were bringing to the table. I'd made a choice not to terminate anyone at that point. And I allowed people, I just started asserting my expectations for them. And basically there were different expectations in the prior administration. So a lot of them resigned. Basically I required us when I went, like I said, as I'm learning the law and learning processes and procedures, I'll update them on these things. And a lot of people say, we've never done it that way. And a lot of people were not amenable to change. The only one that really was my chief clerk, who I made chief clerk, Bonnie Fasek.
Okay, and so Bonnie Fasek ended up being the only holdover you had from the prior office, is that
Yes.
correct?
Yes.
Okay, what role did these changes have in your request to the county commission for different funding and for higher pay?
Well, when I came in, and this is before I got in office in 2020, I was engaged in the budget process because I realized that they do their budget a year ahead, obviously. So Hamrick requested a budget and he's requesting his current budget. What I realized is his budget, he only had like $100,000 in operating expenses. I did my research and I contacted other probate judges in other jurisdictions. I believe I did Macon, I did Cobb County, different jurisdictions. They sent me their budget and what they do and what they're required because they're Article 6 courts. And I compiled a number and what I would need. And I determined how much money I would need for my budget, which means operating expenses. So those operating expenses were requested to the BOC. And then I also requested the salary difference because we are Article 6 and most probates are paid there's been some jurisdictions who have passed legislation where they get maybe 90 to 95% of the Superior Court judge's compensation. So basically I was coming in with that argument where now we're Article 6. I have the same qualifications as the other judges, state court and Superior Court. It's a different court. So I was asking for that. So that was the request made in 2020.
Okay.
Do you practice any law now?
I cannot, no.
Well, the code allows probate judges to practice law as long as it's not probate law. Don't they?
I wasn't aware of that law, but I don't practice. I wouldn't feel comfortable practicing.
I think you're correct.
I wouldn't, no.
So,
One sec, I have a couple
sure.
questions. Well,
Sure.
Judge Peterson, probate court became an Article 6 court when you assumed that position because you were a lawyer or because Douglas County's population? I know that there are several things that can change how a probate court works. The size of the county in terms of
Right.
head count, but also the qualifications of the judge. Which
Mm.
was it?
The legislative requirement that it changed is the population. So once the population hit, I believe it went from 96 to 90,000. Hamrick was grandfathered in, but once the next election came, whatever person in that position must have been an attorney with a heightened qualification.
You're grandfathered in if you're already there.
So it's population that triggers Article 6. Article 6 requires an attorney.
Yes,
So if you had not been an attorney, you could not have run for Hamrick's position.
That's
He was
right.
Retiring and vacating what was now an office that required an attorney.
that's right. You had to be an attorney and you had to practice for at least 7 years.
Okay, now you mentioned that an Article 6 probate court is different from whatever article it used to be,
Mhm.
Article 5. You can have jury trials and this and that. But the day-to-day work that a probate court does, trusts, wills, estates, guardianships, gun licenses, maybe weddings,
Yes.
whatnot, marriages, is that all that different? There might be more volume because the county is bigger now, but are there things you do apart from jury trials
Mhm.
that Judge Hamrick couldn't have done? And if so, where, if I were a Douglas County resident, would I have gone to get it done?
Perhaps, well, before Article 6, the court didn't have the trust jurisdiction, so they had to go to Superior.
Okay.
Yeah, so now it comes to me. And if they do file it in Superior Court, even though we have concurrent jurisdiction, they send it to probate.
But it was, I'm sorry, it was trust is the main thing that got added to your menu of services. When I say yours, the probate court's menu of services, when the court converted to an Article 6.
Yes, that's one of the matters. I don't have the full list in front of me, but yes, that's.
If you're thinking about big ones, it would be trust.
Yes.
Okay.
So does the Superior Court have concurrent jurisdiction with the probate court in your county?
On some matters.
Okay, I thought the chief Superior Court judge said he didn't do any probate work at all.
He said that, but on some matters,
and again, I'm going to lead, Ms. Veal may want to, but it's also true, is it not, that the non-Article 6 probate courts,
Object to the ongoing leading questions.
Okay.
the article, prior to being an Article 6 court, you couldn't hold a jury trial, and you indicated that the appeal would go to the Superior Court. Do you know if that was a de novo appeal or not?
yeah, it was.
It was an all-new trial,
That's right.
and now you say it would go to the Court of Appeals.
Yes,
So any trial or any record that was made of that, you would do that, correct?
yes, I would submit the record.
Okay. So I want to, you sent me a text or email this week with this letter on it.
Got you. Using the document camera?
Yes.
Okay. Ms. Veal, this is something you've had a chance to see now?
I do, and I have an objection.
You have an objection?
I-
Okay, so let's take it off I'll leave the objector on.
Sure.
Are we numbering this?
I am planning on numbering it, and
And are you going with respondent or Peterson when we're
I
referring?
think I'm going to go with Peterson, because I always get confused when
Okay. Peterson is clearer. So this would be Peterson. Pick your number.
I'm going to give it Peterson 29.
Okay. What
And
is?
there's another document, and I think I would make them separate exhibits, which I'm going to call Peterson 30, which I will go into as well.
Got it. Do you have concerns, Ms. Veal, about Peterson 30 as well? That looks like the certificate of appreciation from the Chief Justice for having hit a certain clearance rate. What are your concerns about Peterson 29 and 30?
I will lead with relevance. And then there's a letter in there, so hearsay. Here is my overarching concern. I received those documents on Tuesday. Not seen them before, but as I'm sure Your Honor is aware, the manner in which these numbers are submitted to the AOC is they are just all self-reported. And so if we're going to get into, and it doesn't relate specifically to anything, it just says, great job on your clearance rate for 2022. I would like the opportunity to explore the source of those numbers, how they came up with the clearance rate, all of those things. And again, perhaps this is more appropriate for mitigation, but I don't know how it is relevant to any of the charges before the hearing panel currently.
Okay, threshold question, Mr. Tate. Is there a date on the letter from Chief Justice Boggs?
There is.
When would Judge Peterson have received it?
It's dated September 6th, which I believe was our second day of trial here. I don't have a date stamp coming in, but this just happened. Yes, this is not something that I've been holding back to sandbag someone with or something like that.
Okay, so it's recently discovered because it was recently authored. And is the letter from Chief Justice Boggs something that he sends to each recipient of such a certificate? Or is this something that your client asked him to write, almost like a letter of recommendation saying, I think you've got a super clearance rate?
It's something that they send out to it comes from the, and the certificate's also signed by Judge Leonard, who is the chair of the, I didn't know what this was. JWAC, exactly. You know what I'm talking about here.
Previous chair was Judge Emerson.
Ah,
World. So what's the relevance?
Well, the relevance is that they have accused Judge Peterson of being inept in office. And in particularly, I think that the allegation is, oh, you took so long with this, you took so long with that. And there are obviously a couple of cases that have that there, but it's very relevant to her overall performance.
So Ms. Veal, I'm gonna allow it in. I do think it's relevant. I also find, unless you learn otherwise, and we can revisit this, that this isn't something that Judge Peterson belatedly provided to Mr. Tate. However, I think you're free to argue about the weight we should give it. And just full disclosure, I used to serve on JWAC. So I'm familiar with the clearance rate calculations and origins of data, et cetera. And I'm certainly going to share that with my colleagues, should this be something that becomes a discussion point for us. So I hear your concerns. I think they go to the weight we would give it rather than the admissibility.
And Your Honor, I would just like to, reserve the opportunity to, if I would like to have somebody come in here and explain a little bit more about this, or explain the clearance rate for the year prior in her court. I would like the opportunity to do that.
Sure.
Thank you.
Back to you, Mr. Tate.
Thank you, Your Honor.
So that was Peterson 29 and 30.
That's correct. And I'm going to mark them if I could take just a minute before. I'm going to write Peterson. I'm actually going to write it on the back, Judge, so that I don't, and then we get a sticker, we can do that. But I'll make the letter Peterson 29, and I will make the certificate Peterson 30. And I'll start, Judge, by asking you, did you, can you see this letter?
Yes,
And were you expecting to get this letter? Was this something you knew about? Or-
I didn't know this existed.
Okay. And the letter says that it's congratulating you on a remarkable achievement, and it is from, as Judge McBurney noted, the JWAC, the Judicial Workload Assessment Committee. Is that correct?
Yes,
And it says the Clearance Rate Excellence Award recognizes the top 10% of the courts in each class of courts that demonstrate exceptional performance in maintaining their clearance rates as a key indicator of the court's ability to effectively manage its caseload. Clearance rates are calculated by dividing the number of disposed of cases by the number of filed cases and expressing the results as a percentage.
yes,
Cases not disposed of in a timely manner contribute to backlog of cases awaiting disposition. A clearance rate of 100% or higher demonstrates a court's ability to resolve at least as many cases as were filed each year, correct?
yes,
And then show you what's been marked as Peterson 30, and that's the actual certificate that you got, correct?
it is.
Are you proud of that?
I am. When I came in office, and one of the things I said, I had a 90-day plan. It was about 30 items that I needed to fix in that court that I immediately realized. And one of them was the case management software. So when I was asking for my budget, and Judge Emerson had written a letter to the Board of Commissioners, he wrote a handwritten case count that was provided to him by the chief clerk in the probate. So when I got in there, I said, why are y'all writing handwritten case counts?
Objection, non-responsive.
I asked her why she was proud of it, and she's telling me, I think.
Okay. I don't know that we need to get into Judge Emerson.
Well,
Okay.
I know you
I'm not trying to,
Okay.
I'm not trying to kick Judge Emerson further.
Okay. Let's talk about why.
But the case count, just tell us about.
I'll
the
tell you
case.
about, okay, so the case count was handwritten. So with the icon system, they didn't have an accurate reporting of the cases, the active cases, the disposed of cases. That's what I found an issue with that system. Moreover, with that system, we didn't make our records publicly available.
Okay.
So with transitioning to CJT in that year of 2021, it allowed me to start to determine what we had and start resolving, keeping track of our caseload.
Did you also receive the Association of, Georgia Association of Black County Officials Award?
Yes, probate judge of the year, I did.
What year was that?
My first year, 2021.
Have you received any other awards or commendations like this since you've been in office?
Yes, but I had, because of, yeah, I did. I received a honor that was pulled once all this stuff went on the news with JQC. But yeah, I had an honor of the top 40 under 40 as well.
All right. So let's talk about how you got there.
Mhm.
You told us why you wanted to run for probate judge. You told us about where you are right now with this office. You qualified in what month of 2020?
March,
And then the election was held.
June.
when? And how many you had only an opponent in the Democratic primary?
Yes,
And who was that opponent?
Leonard Danley.
And what was that campaign like?
Well, we didn't get to do much because we were kind of in the house for COVID after, some time. So it wasn't much interaction. We had a Zoom type of debate. We did that. That was pretty much the extent, basically you had to run off of your name, the work you did in the community at that time.
Okay, now you won the election in what month of 2020?
June.
Okay. And then although there was technically a November election, you knew you would win that because there were no other
Right.
no other people qualified for that, correct?
Yes.
When you ran for Solicitor General, was that against an incumbent or was that an open seat like this?
It was an incumbent with 3 other two, including me, two additional challengers.
Okay, and then when did you receive your first complaint from the Judicial Qualifications Commission?
The day I was walking to swear in
And
December of 2020.
that's when the commission actually sent it to you, not when it was filed, correct?
Yeah, I've noticed the complaints I've received are always on times that are supposed to be happy moments for me. It's been that way.
So you're getting ready to go take the office and you get a letter from the Judicial Qualifications Commission saying you've had a complaint filed against you.
An
correct?
email, yes.
And is that the email that relates to what we generally have called the social media
Yes,
stuff?
yes.
Okay, so I want to go through some of this. If you could pull up number 1, it's marked as Exhibit 1, but I think it's JQC 1 or I don't know, Directors 1. I'm not sure what we're calling it.
But you're asking your colleague.
I am, yes. He's pulling it up. I'm trying to stay as far away from technology as I can.
Okay.
So is this one of the complained about
Post.
social media posts?
Yes.
And when did you post that?
It would have been on or after my birthday,
Okay, and your birthday?
August 26th.
Okay. And somebody, I can't remember who, used the word irony about this earlier and pointed to the emojis there. What was the purpose of the emojis?
To show that it was a joke without saying I'm joking. I post a lot of funny things and this sarcastic things. So when I said, anybody feel like sharing their quarantine, well, do this. And it was like to express it was a joke. So quarantine, well, like I said, it was not a thing at that time. So I thought it was funny. People that follow me thought it was funny. Well,
let's stop just a minute. You say you post things that are funny and
Yes.
ironic. Tell us just a little bit about your background as a actress, singer, that kind of thing.
I've been acting for quite some time. I've done, professional plays. I've done some more volunteer basis plays, like with the Atlanta Bar Association for their Bard show. I would post things on my page, videos, funny videos. I would post different things. Recently, within the last year or so, I've taken some comedy classes. I'm friends with a lot of comedians. I have close comedian friends, so I'm always closely associated with
So-
comedy.
So here's my question. With this post, were you trying to actually get people to send you money?
No, I was not. That wasn't the intention.
Did you have any type of bad faith or desires for personal gain out of that?
I didn't. Honestly, I was just really celebrating life. At that time, I had just came out of COVID and was good, happy to be alive, actually.
Okay, and did anybody send you any money that had a pending probate matter in the Douglas County probate court?
No, this was before I became a judge, but no, only people that sent me money are two family friends and a colleague.
Okay.
But
and
we knew that I don't think they saw the post. They already have my information.
Can you tell me whether or not any of those who sent you money even live in Douglas County?
Nobody, none of them lived in Douglas County.
Okay, all right, let's go on to number 2 here. Is this the heading for your Instagram page?
It was at some point.
All right, and you have judge-elect up there. Why did you put that there?
Perhaps because it must have been sometime after, I'm assuming, after June, because I would have been elect.
And have you ever found anything in the canons you've reviewed the canons Code of Judicial Conduct,
As
correct?
much as I could.
Have you found anything that in your mind prevents you from calling yourself judge-elect if you've won an election and you're about to be sworn in?
No, not in the canons. I would get complaints from the JQC and I would try to understand what the issue was, but I never could determine based on the code.
Okay. All right. So let's go to number 4. This is the post about the Rose Bar. Tell them what kind of event this was supposed to be.
It's a professionals event. It's the guy who puts it together.
Tell us his name.
His name is Marquise Williams. And he puts these events together. They're professionals. He's had other judges host these events. He has attorneys, realtors, different things like that. And when I say host, I mean just basically, this is basically what I did and just notifying people that you'll be there.
Did you actually put this flyer together?
I didn't.
Who put it together?
I believe somebody from Mr. Williams.
Okay. And again, this was prior to the time you actually took office?
Yes.
And after the time you had won the election?
Well, I think this was, I don't know when it happened, but I'm thinking, I don't know the date because it doesn't say it, but I recall it happening before I might have qualified.
Okay.
So I'm not really sure, but I know it was before I took office for sure.
Okay, but it may have even been before you qualified.
Yes.
Okay, now, had you,
Judge to be, did you write that on? I don't know how this works.
Yes, I wrote that. I was asked about it a while ago, but remember I spoke about my aspirations in speaking life and affirmation. So if you look at all of my posts on Instagram, they always have hashtags and they'll always have things that don't necessarily point to something in particular, but it might be an affirmation.
I think I heard you say other judges have posted BAE events. What other judges have hosted BAE events?
Not BAE, but specifically the Black professionals, the events. There was a event hosted by Jackie Peterson, and he was going by ATL judge at the time.
Anyone else?
That's the only judge. I might have seen others there, but not on a flyer. I distinctly recall him. There's been other attorneys as well, but
Sure.
Which judge did you say did this? I missed it.
well, I don't know his status, but he was ATL judge on Instagram, Jackie Peterson.
so had you gone to these Black professional networking events prior to the one that's advertised here?
Yes.
Okay, I want you to listen very carefully because I want to ask you some important questions about this event.
Okay,
Were you paid to go to this event?
no,
Did you get any personal benefit out of going to this event other than just the opportunity to meet other people?
no,
Did you promote this event for money, not just your going, but your, the fact that you retweeted this or reposted this? Did you get any compensation? We have these things
No.
called influencers now. Are you
Oh.
being paid to be an influencer to get people to go?
no,
Are you familiar with Rotary clubs, Kiwanis clubs, social clubs like that?
yes.
Can you tell me if this differs other than in just maybe the optics of it, what takes place at those?
It's the same. It's about the same. The socializing, people talking. Sometimes you have people drinking. They might have an adult beverage because they're adults. They might be eating because a lot of them is in restaurants. So, like I said, up on my reading of the code when I was reading through, I thought it was acceptable because there is commentary in the code that states we can be a part of and initiate gatherings and things like that.
Is it your understanding then that the investigative panel's concern is more the photograph or the words? Or I guess I'm missing that.
That was the question. That was the question for me when I originally got it. I thought it was maybe the photo because it wasn't clear on what I was being charged with, especially the first post. I wasn't even aware of the Cash App situation. I thought they were talking about the photo. I thought they were talking about the photo here, but I really don't see, honestly, with this one, I don't really see much issue with the photo, but
Well, you would agree that Ruth Bader Ginsburg didn't have a photo like that.
oh yeah, sure. I agree that.
Say, President of the bar.
True, I agree. And that's why when I met with IP at the first meeting, I wanted to know and try to understand what the issue was. And I made it specifically, like I said, when I mentioned cultural differences, I wasn't talking about like necessarily race, but age wise and what we do and things like that. So I wanted to get an understanding, but I didn't know what the issue was with this per se.
My grandmother used to quote an actor or singer named Tennessee Ernie Ford, who said a woman who would tell her age would tell anything. But we are telling the truth here. So I do want to know what your age is, because I perceive you're of a generation that uses more of these types of communications than my generation.
I'm 38. I just turned 38.
I want to go on to exhibit number 6 here, if we could. Let me, while he's changing that, let me ask you this. What the Black and Educated, BAE,
Yes.
is that a common phrase?
For this, I never heard it before Marquise Williams used it, but he uses that to bring together professionals. I haven't heard it coined before, but I'm sure it has been.
Okay. So exhibit number 6, which is up here now, is that a similar invitation?
Yes, this was another event, apparently.
Okay, and you posted this on your Instagram or reposted it on your Instagram,
Yes.
correct?
Yes.
But are you the actual author of it in terms of having put the verbiage there?
I put the see you Wednesday, come party with me,
Okay,
that part.
but the information about where it is, what it is, that it's got an R&B vibe, dinner, wine, cocktails, and professional people. Did you write any of that?
No, I didn't.
Who wrote that?
Either Marquise Williams or his party. So I'm sorry, his team.
Okay, and it has what the specials will be there. The appetizers, $12, $8 for a glass of wine. It sounds like they're going to have a DJ.
Yes.
Did you get any profit from this?
No.
Did you advance any personal interest by going to this event or by posting it on your social media?
No. I lost money. We had to pay for valet and stuff when we go. So I actually lost money.
Okay.
Do you know, you could
Go ahead.
turn your mic.
No, go ahead. No, go ahead.
Do you know how well Tribeca did or didn't do, thanks to you inviting people to come party with Judge-elect CJ?
Well, I'm going to tell you for that particular event, there was nobody that was there that I had never seen before. There was nobody new. So he has an established, Marquise Williams has an established following. So everybody who was there has always been there.
So that's a no, you don't know.
No. Right.
Judge, do you still to this day not understand how lending the prestige of your office to this advertisement might run afoul of the judicial canons?
Lending the prestige. So I'm looking into clarification, and yes, I don't believe I've made any postings specifically now that I've had further clarity of what's being complained of. But this right here, such as this is how much the food costs, and it could make that appearance. I get that, but I'm still confused because there are other things that I have done, like sing on a microphone, and the DJ asked me, "Hey, can you tell them what you do in probate?" And I say it, and then that's a violation of the canons. That's where it confuses me as to which portion of what I have done is a problem.
Well, I understand that's maybe a separate issue. I'm just focused on these advertisements that identify you as a judge. And
Mhm.
it says up here, Judge-elect CJ, and down here it says Judge at Official Christina J edition.
Mhm.
So the prestige of your office is being lent to this event to
Private.
entice others to come or for whatever purpose. But can you understand now how this might run afoul of the code?
I can understand, and that's why I would be more,
Judicious?
yeah. But what I want to say is like I understand, but it's a lot of that I need clarity on because of the different complaints that have come in, and they're always talking, there's something different that they're talking about. I just didn't get full clarity. I remember, I think Mr. Hyde asked about a judge saying they were running a private school or teaching, and there was an answer. So it would have given me a little clarity on what we're talking about, but I have no interest. I think if I've done anything thereafter, I haven't put like, I can't post appetizers, I can't copy and paste. I do more to read what I'm actually posting.
Would you do this again? Would you put this out tomorrow?
Not this, no, not the appetizer situation. But like I said, as I review the code, I have read that we can initiate and facilitate professional events and things like that bring about awareness to the judiciary and professionalism. I saw that in the code. It's a commentary.
We can agree that this is not that. This is not promoting the judiciary or the legal profession or anything about the
I would ask for clarification whether you're talking about the post or the event.
the posts or the event either.
The event, yes, I would say it was bringing about, it was a professionals event. They're bringing everyone together. Yeah, I was the one who was, being the person on the flyer to say, hey, this is who's going to be here. What my reading of the code said, it was appropriate based on the commentary, but
Right. And you said, because the commentary seems to state that as long as you're promoting the profession, promoting the judiciary, promoting the legal profession, that makes sense. What about this is doing that?
the event, it wasn't so I understand what you're saying. You're asking for you're saying that the writing, the verbiage on this wasn't, but the event actually was.
This is what you forwarded. I mean, the event could have been purely religious, prayer session at Tribeca, but what you forwarded, come party with me, is sophisticated, sexy cocktail. Here's what it'll cost you, chic buckhead restaurant. I don't see anything right here that says, and we're going to talk about the law. We're going to talk about your First Amendment rights as a judge. But we may be missing it.
No, we wasn't talking about that. I think it was more of a gathering of professional people. Like I said, this was a copy and paste. I never do copy and paste anymore, since it has been brought to my attention. So and then if there's a flyer that's created with my likeness, I also make sure I review it and approve it. And hopefully, if I don't approve it, it doesn't get posted.
I want to touch on something that Commissioner Lopez meant, or an answer to Commissioner Lopez's question. You said, oh, well, you know, a lot of these posts, people have complained about a lot of these posts. How many different types of complaints about posts of some type or another have you received? Do you know?
No,
Did you receive a complaint about a post on the Facebook page of the Douglas County Probate Court where you and
yes.
your staff were all wearing the same color dress?
Yes, so I posted a post on my Facebook probate page of myself, my chief clerk, and my judicial assistant at the time. When I posted that picture, you know, people made comments, and then there were comments made, good and bad. My clerks asked me to remove the post because they were being harassed and intimidated, and they felt threatened. I took the post down, and I got a complaint from the JQC that I removed the post.
I'm curious, given how besieged you describe yourself feeling because of this endless stream of JQC complaints that only show up on happy days for you, many of which seem to flow from you doing things with social media, why you didn't just decide, you know what, I haven't figured out the rules with social media, I'm just gonna back off. Like, why would these things keep happening? What was your thought process that, well, I'm gonna do social media anyway, I'm gonna be on flyers, I'm gonna promote this, I'm gonna do something here or there. Why not take a step back from social media until you felt more grounded in what the rules of the road were for judges, which are clearly different from non-judges?
Well, I didn't believe that the rules that were applying to me applied to all judges. I really questioned a lot of the charges. Again, as the one they were investigating me on for removing a picture of myself and my clerks. I didn't understand why that would be charged. Another charge that I got was I terminated an employee. I was charged for that. So there was
When you say charge, I'm sorry to interrupt you. I was talking about the complaints.
Yes.
Which is not a charge. That's first of all, not something that the JQC does. It's something the JQC receives and responds to. And so they would bring to you if they felt there was some substance to it. Here's a concern. And so my question was, it wasn't about charges, it was about complaints. Given the way you've described it, I don't know the number of complaints you've received, but you have portrayed a scenario where basically if we pick a happy moment in your life, you know there's a JQC complaint coming, not because of the happy moment, but that's when it arrives. And a whole lot of them seem to have to do with you and social media. So just go back to my question. Why didn't you finally decide, look, I'm just not going to tangle with social media right now, whether the JQC has it wrong or the people who are complaining against me, or whether heaven forbid it's the judge who got it wrong, but I'm going to take a step back from social media until either you get the clarity you said you were looking for, or you consult with a lawyer who can give you some advice.
Well, I did consult with my lawyer, and so I came up with the realization that some changes I needed to be made, but again, there was not clarity. Why didn't I stop posting? Because I felt like, one, that the JQC was trying to silence me and, you know, deny me of my right to speak. I also thought that they were trying to prohibit me from doing singing and acting. And when I say, so when we were talking about, when I got complaints about the post about my singing and acting, I was under the understanding that they just had an issue with me acting and singing. I didn't know it was, oh, you posted the flyer on your page, because there was times the flyer would be posted on my personal page and didn't mention me being a judge.
So I don't want you to divulge privileged information. I don't know when you started consulting with an attorney. Did you ever have a conversation with an attorney sharing some of these areas of confusion you had? Why would the JQC not want me to sing? Because I suspect, again, I don't want you to divulge confidences, any attorney who understood just the basics of the Code of Judicial Conduct would say, it's not about you singing. You can sing all you want. It's not about you singing. But this has persisted during your answers to questions from Director Beal and now from Mr. Tate and from us. Like, why wouldn't they want me to sing? Like you, I couldn't find in the Code of Judicial Conduct a prohibition against singing.
Yeah.
It's not there. And so I'm struggling with your claim. I just didn't understand why they didn't want me to sing. If you're actually consulting with a lawyer who would tell you real quickly, that's not the issue. So you still aren't sure.
Based on the behavior and what I've had to endure, that's how I felt. That's how I still feel. I believe that anything I do, you saw the 404, and that's why I'm speaking of what I've seen, the 404B evidence where I was just singing and there was no flyer posted. It was supposed to.
Question that someone asked, like introduce yourself.
Yeah. So that was supposed to be inappropriate. So I'm like, so what's the inappropriate portion? Me singing? Well, I'm confused.
Well, and the next area I want to ask you about, I think is maybe sort of timely about that. We have referred to this video that you posted on Instagram as the quote, homeless sexual video.
Mhm.
And very first thing I want to ask you about that is, when did you record it?
I believe around 2018. That's when I was posted a similar video, and that's still present. So
Okay, so you posted it, and I know there's an argument that, well, you didn't take it down or whatever else when you qualified to run for judge, but you recorded it and first posted it some 2 years before you were ever even a judicial candidate, correct?
yes, I didn't see it. I don't believe it was made available when I became a judge. What I've seen here, I haven't seen it, but I've seen somebody else post it. It was made available on someone else's page.
So, and after you became a judge, somebody went back through your media and posted it on theirs?
Or they may have already had it. I don't know what they did. I can't.
Okay, but it reemerged at some point there?
Yes.
Okay, now, what was your intent when you recorded that back in 2017?
Well, I believe it was 18, but
18, I'm sorry.
it was funny. It was one of the things I was doing around that time was like kind of like word of the days. And it was like jokes surrounded by words of the days. So I did that was one of the word of the day. And basically I'll just make a little funny skit based on that. Okay.
And what was the purpose of that, to insult anyone of any race, creed, color, sexual origin?
No, absolutely. No, absolutely not.
And so we've been asked about getting an actual transcript because it was loud and we couldn't all hear really well. But can you capsulize for the panel here sort of what the joke was supposed to be about?
Well, this term I learned, I thought I made it up, but I didn't. I've heard other people use it, and they also use the term hobosexual. They refer to it as someone who kind of acts like they're in love with somebody or fall in love with somebody for the sake of having somewhere to stay, like for the necessity of being taken care of. So it could be woman or man, whoever, but it's basically they're just there because they don't have anywhere to go.
Okay. And you have taken that down, correct?
Absolutely, yeah.
And with regard to the other issues, you are no longer reposting flyers or things like that, correct?
No, I'm not. I haven't been really hosting any events or doing anything, or no, I haven't. Now, if you're talking about flyers for plays, that's different.
Okay. And so you have posted some flyers for plays that you appear in,
Yes.
correct?
Yes.
Okay. All right. So you take office, you get this complaint the first day you're there, before you're even sworn in. And then in March of that year is when Judge Emerson files his complaint. Correct?
That's, yes, I know he's done several.
And the
but-
one, I'm sorry.
Yeah, he's done several, so I don't know which one is the first, but he has direct contact with the JQC.
And so when you got this complaint by Judge Emerson, the first thing, was it about anything you had done as a judge?
No,
How long back did that complaint reach?
2018. So 2 years, 3 years before I became a judge.
Okay. And so how did that make you feel?
I was very upset. I responded, I believe this is before I had an attorney because I was fresh into office. And I did respond via letter to the JQC and I said, you know, I asked them who filed it. And I said, this is just more of the harassment that I've been experiencing from Judge Emerson. And he knows that the JQC doesn't have jurisdiction over this matter. I was under the belief they didn't have jurisdiction. And oh, look at me, something, first time for everything. But I did, right. But what I did say also was that he has firsthand knowledge of the filings in the Superior Court that have been dismissed with prejudice. Also, there was a filing with the state bar that was also dismissed. So he's known all of these other things that's been trying to attack me on this matter that have not worked. And for him to submit that, it just seemed malicious.
And just so we're oriented, these are all allegations relating to the $70,000
Yes.
settlement.
Yes.
And the letter that he wrote to the governing authority about not paying you what you, where is that in relation to your swearing in day?
Before.
Oh.
Yes, it was like a 7-page letter. And it wasn't just for my salary. It was for everything I was asking in my court. I needed additional staff. I needed a fiduciary compliance clerk, something like that. The things I was asking specifically for more money for certain things that I learned that I need as Article 6, he was disputing everything. So he listed headlines about.
We've asked for the letter, we haven't seen it yet.
Yeah, I have it. I gave it to my attorney.
So again, I want to confirm the timeline to make sure it's on the record. Your testimony was that Judge Emerson wrote the letter to the county commission before you were ever sworn in.
Yes, it was, they do budget around October.
And then in March 31st, I think it was, of 2021, within 3 months of you taking office, he filed a complaint about you as a lawyer in 2018 that had been dismissed by the bar, correct?
That's right. And then even before that, after he wrote that letter to the board, he went on Fox 5 and talked to Randy Travis about how my request was inappropriate. And Randy Travis asked a good question.
We don't need
Well,
to
yeah.
say there.
Okay.
Yeah. But Judge Emerson, you saw an interview.
I saw it.
That Judge Emerson gave to Randy Travis. Don't tell me what was said.
Yes,
correct?
I understand it was initiated by
And-
Judge Emerson.
And Randy Travis at Fox 5 has continued since the interview with Judge Emerson to look at everything you've done.
Yes,
Or not done.
Randy Travis actually alerted me to my formal charges. He had them before I was ever served. So
Okay.
they were sent directly to him.
Okay, and then after you go into office, you testified, I think, that you asked for a meeting with Judge Emerson.
Absolutely.
And how did you ask him for it by email, or did you call his office, or what happened?
I believe I contacted his clerk because that's usually how you go through to reach him. And I believe the clerk set it up, his clerk, and sometime thereafter, it was canceled.
Okay, and did you ever have a one-on-one meeting with him?
I've never talked to him one-on-one in person.
All right, so then we get to I want to talk a bit about the wedding at the courthouse, but before I get to the wedding at the courthouse, I want to talk just a minute about some of the changes that you requested.
Mhm.
You needed a courtroom. Right.
Yes, I did.
And where were you given a courtroom?
I was ultimately given a courtroom on the 4th floor,
And what floor is your office on?
on the 3rd floor.
Okay, and so can you, like most judges I know, walk out of your office down a secure hallway into the courtroom?
No, but there used to be a probate court for that, but it was given to state court because
Okay,
obviously Hamrick wasn't utilizing a courtroom.
okay, and did you request were you given a sheriff's deputy for your courtroom?
No, not initially. I was told by Captain Wilson that we're not required to give you a deputy.
Okay, I'm looking for a letter and it may take me just a moment here.
This is why you have a trial partner.
That's right. I want to go to section 4. Aiken and Tate AT 003. This is out of my exhibits. It's a letter from Judge Peterson to Sheriff Pounds.
Are you sure that's the right number, Mr. Tate? 003 is a blank piece of paper in my copy.
So each one of these starts new. Each one of the sections starts new. So if you go to 4003, I think you'll see it.
Okay. I didn't know math was going to be on this case.
This is for.
You're like me, Mr. Todd. I'm on the right floor for the courtroom. I'm just there on the wrong day. Yes, it is. Blow that up for me just a little bit.
My law clerk provided it.
So this is a letter that I guess you wrote this after or in response to being locked out of the courthouse, correct?
Yes,
But you cite in that letter in the 3rd paragraph, OCGA 15-6-10.
yes.
Do you see that? Could you
Yeah.
just read that aloud, please?
OCGA 15-16-10A2 gives the sheriff a duty, quote, to attend by himself or his deputy upon all sessions of the Superior Court of the county and also upon sessions of the probate court whenever required by the judge thereof. And while the courts are in session, never to leave same without the presence of himself or his deputy or both if required, end quote. No provision is made for bailiffs in probate court. And that's a 1969 opinion of the Attorney General number 6910.
So an opinion, you not only cite the statute, but an opinion of the Georgia Attorney General there.
Yes.
Correct. Now, is that the first time that you had called this law to his attention, or had you previously called it to his attention?
I previously called it to the attention, but I've also, I tried to go through the level of, the order. So if I've tried to talk to your assigned Captain Wilson, who's over the courthouse. I made that request to him. It was
And the next paragraph, you say, when I initially requested a deputy for my court sessions, your designee, Captain Trent Wilson, advised that it was not required. Once I gave him the law, he is assigned a bailiff only and not a deputy. The law requires that a deputy be provided. Please adhere to the code section above. Was this the conversation you had with Captain Wilson, was it prior to the courthouse wedding
yes,
situation?
yes.
All right. So was there a time that you had to fill out, where you made email, you had to make email requests if you wanted a deputy?
For court, yes,
Court. And then if you were going to do a wedding, you made event requests?
yes.
So on the day, and I'm trying not to go back through every detail of the wedding. This might be one of the most examined weddings, in the history of jurisprudence. But before you took your party into the courthouse, what did Sheriff Pounds tell you over the telephone about going into the courthouse with them?
I was advised that it was secure because his pastor deputy was there.
Okay. And the pastor deputy you're talking about is Mr. Deputy Clayton, who testified here the other day?
Yes.
All right. And I want to look at section 1 in my exhibits and 30. And I want you to look at the pictures here. You've watched the whole video too, haven't you?
Yes,
These
I
are
did.
stills from this. Well, they're not up yet, but. Yes. Okay, that's fine. It's fine. You had pictures.
We understand. what
You-
you're
you
referring
understand.
to. We do.
How many more people had Deputy Clayton already taken into the courthouse than the 2 adults, 2 children that walked in with you?
About 10.
Okay. Again, I'm trying to clarify this, not go back through the wedding, but did you testify? Is it your testimony that when Wilson, I can't remember if it's Captain or Deputy Wilson, told you you can't go in if there's no deputies there, if we don't have security there, that you were willing to have the wedding
Outside.
outside?
I was. And they were too. When I got there and talked to my couple, they were willing to, except when we saw the people being let in, then they had an issue with it.
So
And
what was the one deciding factor for you deciding to go on into the courthouse with these 4 people?
well, once the daughter translated to the parents, we're gonna do it outside and they agreed. Then when we see extra parties coming in, they were like, there's a wedding. What are you doing? What's happening? Why are we being treated differently? So at that point, I felt compelled to contact the sheriff.
Okay. And the sheriff said,
Yes.
if the deputy's there, you can go on.
And I didn't know the deputy's name at the time. I've seen him before, so I just explained to him who it was. I said, it's a deputy here. He's doing a wedding. And he said, oh, that's my pastor deputy. It's secure. It's secure. The courthouse is secure.
Okay. And you've seen the video, but did you actually in person witness him taking the individuals in?
Some numbers, yes. I was actually I met him at the door and I seen him.
Did he screen anyone who went in?
No, he actually had there's a cut off portion where people don't walk through. He actually had it taken off so they can walk through that area without getting screened.
Okay. And as far as why the deputies weren't there at the time, we know that there was in fact a request for deputies to be there the day you were going to conduct the wedding. True?
They were supposed to be there. There was a request for them to be there.
Regardless of the time,
Yes.
we got the time wrong. Regardless of the time, do you know of anyone involved in this who has disputed the fact that you asked for a wedding? You put in an event form for a wedding that day.
No,
So the time was the only thing that was screwed up about it.
allegedly. I still haven't seen the request.
Well, that was my next.
Pay those debts. You at the parties or the sheriff pays them? How's that work?
So I did look at some emails, old emails, and I did send an email to Captain Wilson telling him about the weddings and my intent. And I asked him, I said, do you need me to pay for the deputies after hours? Because it would seem appropriate. Because, you know, but he responded to me over the phone and he said, no, that's what the sheriff's overtime budget is for. So I was always advised I didn't have to provide for it. Just I would request it on the sheet.
Is that because you were a judge, do you know, or was it because that's the way I wanted to go out there and marry somebody?
I think it was no, I think, oh, you talking about the after hours request? I think you had to be some type of a county. It probably was for county officials to utilize. They didn't really give me the full policy. They just told me if I needed to request it. I don't know if a civilian unrelated to the courthouse could request.
Okay. Are you performing weddings in the courthouse when it's closed anymore?
Outside.
Outside, but not inside?
Right.
Okay. As I understand it, nobody's doing that anymore, correct?
I haven't seen anyone doing it after hours.
Okay. Let's move on for a second to the contempt on the marriage certificate. Okay.
Okay.
And I think this was asked in different pieces and I'm probably asking it second time, but if you had that to do today, would you do the same thing that you did then?
I would not. I would do what I'm doing now, to be more clear. If I had any issues with the pleadings or anything prior to, I would schedule a contempt hearing. But in this matter, where I felt it was a direct contempt, I would have probably given her an opportunity. I would have said, hey, I'm going to send you out. We can reschedule. Give me this document, the official document, and I'll see if I can issue this amendment.
Well, I thought Commissioner Lopez asked a very good question about that. And I'm trying not to mix these things, but you do have a budget to pay for lawyers.
Yeah.
And certainly it's been called an indigent fund, but it's not necessarily an indigent.
It's a
fund.
legal fund.
And if you had to do that, if you had a contempt issue now, would you utilize that legal fund if the person was otherwise unrepresented?
Yes. So usually when I schedule contempt hearings, everybody that's come has had an attorney or they were an attorney.
Okay. And have you, since this event, because Judge McBurney was asking about consulting a lawyer about this or about that or the other, but since this event, have you jailed anyone for contempt?
I have not. I've held someone in contempt, but they had to pay a fine. I didn't jail them.
Okay. Now, did you know the person that you held in contempt?
Personally?
Yes. Did you have any personal relationship with them?
No.
And the reason I'm asking that, you can understand perhaps why if there's somebody you're out to get and you use your powers as a judge to get them, that would be bad. So I want to know, did you have any personal relationship with any party or any potential grudge or prior bad feelings, anything when you did the contempt?
No.
In fact, I'm going to go ahead and ask this about all of the in-court matters that you had.
Mm-hmm.
The petition for a year's support, the request for letters of administration, and I think the third one would be this contempt. In any of those where you made judicial decisions, sitting as a judge, did you have any relationship with any of those parties that were involved outside of them being litigants before you?
No.
And can you think of any reason that anyone would say you were out to get one of them, to help one of them, to slow walk a case, to keep somebody in it that shouldn't be in it?
Any other reason other than somebody just trying to advocate for their client? I mean, that's I know in the your support situation, you want to keep a caveat out. You want to not serve the interested parties, but that's my duty to make sure it's done. So
Okay.
That would be the reason, just to advocate for your client, but.
Okay. Now, I want to make an assumption about the contempt for just a minute. Okay? And the assumption I want you to make is you got it wrong. You made some error of law in the way that you conducted that procedure. Okay?
Okay.
So it's very important, I think, for you to tell me and to tell this panel what steps you took to try to make, if any, to try to make sure you didn't get the law wrong before you held anyone in contempt.
I reviewed the code, the probate code in regards to contempt. I've attempted to reach out to the listserv, other probate judges to inquire. I make calls as well to probate judges to inquire. A lot of them, not much information was received on it. So I noticed that our code, the probate code, is kind of, it adds an additional piece that the normal Superior Court code doesn't have. So it appears there's an extended type of contempt power. But I just researched the law and tried to reach out to my peers.
And you did all this before you held anyone in contempt, correct?
Yes, I wanted to those are the things I wanted to review. So I determined the different types and things like that. But I knew generally about direct criminal contempt from being in court and seeing others held in contempt.
I do want to clarify that. So I think when we were talking about the contempts that you held the young lady in, you hadn't done any research before you did that. As I think is what you told me last time.
Are you talking about the contempt, the PJ matter?
Yeah, the PJ matter.
Yes. No, I said I did before the first. So she was the second person I've ever held in contempt. The first person before I've ever held anyone in contempt, that's when I did the research on contempt matters.
And what was the approximate time difference? That's one reason I asked you that question, because I wanted to clarify. And I'm gonna ask you again. You researched before you held the first person in contempt. You did not go back and look before the incident with PJ, correct?
Right, because I thought I had a good grasp on my understanding of direct contempt. But no, I didn't go back.
And how close were those two events in time?
When do we have the date on PJ? I know the first matter was kind of when I first got in office, because this one, the first matter was.
So
PJ would have been in August of 21.
Okay, the first one would have been around, I'm going to say February, because I had a couple of cases there, in crazy cases. This one was an administrator who defrauded the court, and he said he was an heir to an estate, and he was actually not, and the whole estate was awarded to him, and he's wasted all the resources, and then we had to have a hearing and things like that.
Did he go to jail?
Yes, he was held in contempt because he was in direct contempt as well. But he went to jail, and that's the one that the DA's office, I forwarded over to the DA, and the DA picked up and indicted him. He was required to bring documents, accounting to court. He was given several times to do it, and he came to court, and he was, I felt like he was in direct contempt of the court.
But this person, not PJ.
Yes.
You actually gave a few times to fix the situation before you said, I'm holding you.
I issued a letter. Basically a notice. So he lived out of state, so he was issued a notice. And I believe the notice said he needed to have something to come to court when he came to court.
He knew walking in, you maybe should have known walking in. If I don't have what the judge asked for, I could be sideways with the judge.
Yes. And I'm honestly, if I'm a recall, I believe that we had another hearing prior to where he came and I allowed him to appear via Zoom. And that, I believe he didn't have the items he needed. And then I issued an order saying, give the items, and I need you to be here personally because these people want you here, you're evading court. So that's one that he came to the court and Yeah, he basically said, I don't have anything and I'm not planning on giving the court anything in regards to this estate.
That seems a little different from PJ.
It seemed now, but from what I got in the moment in the PJ matter, I was under the impression that she was defrauding the court as well. And that was my present impression at the time.
And again, I think you said you would handle that differently.
Absolutely, yes.
Objection asked and answered.
Sustained.
Let's talk about the year support matter for just a second. And I want to talk about it, not specifics, but from a sort of 30,000 feet view. What was it that you thought ought to happen in that case with regard to the petition for year support and the caveat? And what were your concerns and what were you trying to do?
Well, in all cases, so since I became the judge, I have had to make a lot of corrections about estates that have been taken advantage of. We didn't get sufficient service, and then the heirs would come in later and say, where's my grandmother's estate? So in order to ensure that this doesn't happen, I make sure we get service. It's very important because the interested parties have to get service, especially on a year support, because the law states in a year support, if anything that the spouse or the minor child asks for, which could be the entire estate, if there is no objection, then it shall be granted. So that's why I make sure that we have sufficient service.
Okay. I'm going to ask if you would to put up OCGA. I think it's the third link that I sent you there, if you would. Yes, 5311.5. Blow that up for us just a little bit. Are you familiar with this statute?
Yes.
And it's I think it's actually one sentence. I'm going to just read it quickly into the record. On the motion of any party in interest or on its own motion, the probate court may direct any additional service of citation or other notice or extend the time to respond with respect to any proceeding covered by this chapter, as the judge may determine to be proper in the interest of due process and reasonable opportunity for any party in interest or interest to be heard. Did I read that correctly?
Yes, that's OCGA 5311.5.
And so based on that statutory law, what do you see your job as, what you need to do as a probate judge in a case like this year's estate?
Like I said, the parties can request all the estate, in essence, leave the heirs out of any inheritance from their deceased relatives. So it's very important to make sure that I have service on those heirs. And I don't resort immediately to publication because we all know nobody sees publication. So I make sure if I do certified mail, I want to see a signature from that person. If I do personal service, I want to make sure it's been perfected. And if I don't get it, I'll try again, try something else.
All right. So Ms. Veal, during her cross-examination of you, she referenced two other statutes, which are immediately before and after that. One is 5311.3, if you would pull that up. And if you'll look at subsection A there, it talks about a party in interest who is a resident. And I think one of the distinctions that was being made was the difference between a resident or non-resident, correct?
Yes.
All right. So if you would just read along with me, it says, except as otherwise prescribed by law, or directed by the probate judge, a party in interest who is a resident of this state is entitled to personal service of any petition and citations for proceedings that are subject to the provisions of this chapter. So it sets forth requirements of personal service, but it also allows you to vary from those. Is that your interpretation of that?
Yes,
And that's for a resident, correct?
yes,
In this case, we're talking about a non-resident, so we'll look at the other statute, OCGA 53-11-5.
4.
I'm sorry. And it says, except as otherwise prescribed by law or directed by the probate judge pursuant to 53-11-5, the provisions of this code section shall apply in cases when a person to be served with notice of a proceeding covered by this chapter has a known current residence address outside of the state or whose current residence address is unknown. Did I read that correctly?
Yes,
And so would you agree that the non-resident, as Ms. Veal pointed out, but which I don't think the probate lawyer testified the other day, but the out-of-state doesn't require the restricted registration, restricted receipt, correct?
it doesn't appear. It requires it.
Okay, and I think you said you'd had some training about that. Was your training
Yes,
that you should do that?
yes, that's the training that we have been taught in probate counsel trainings.
And can you tell me whether or not you believe you have the authority to order that it's restricted receipt pursuant to 53-11-4, which incorporates 53-11-5?
I do. And I think it's honestly necessary to make sure there's service has been sufficiently perfected.
Okay.
So just so I'm clear on this, it sure looks like from 53-11-5, you have the authority to do what you did. My understanding of your testimony on cross-examination, that you actually didn't know about 53-11-4, and you were operating under the misapprehension that you were obligated to do the registered receipt. I'm calling that shorthand.
Mhm.
It's clear you had the authority to do that.
Yes.
But just so I'm processing this all correctly, your sense, maybe it was from training, doesn't really matter where it's from, you thought that it would have been improper for you to accept as sufficient notice the Jose card because it wasn't Jaquita, I think was her name. So
Right.
you signed. It turns out that 53-11-5 says you were in the clear doing it exactly how you did it, but that wasn't your understanding of the law when you were processing all this.
My understanding was it was required, as well as, so when we taught in training, it was required restricted delivery.
And that was the training you got when you first became a probate judge.
It was one of the trainings. I go to most of the trainings, so I can't, they're all jumbling together now, but
So when we had the lawyer that was involved with that the other day on the witness stand, I think I understand what happened, but I want to ask you from your perspective. It's true that there was a card that came back signed by Jaquita, signed by Jose, not by Jaquita,
Mhm.
correct?
Right.
And is it also true that there was some way for the lawyer who testified the other day to see that there had actually been service without knowing who signed the card, that there would have been a receipt returned?
I believe she asked my office and provided the certified mail, a receipt, and it has the tracking number. So she pulled it on USPS and saw it just said delivered. It didn't say how.
So it showed delivered, but it didn't show how.
Right.
And so is it or is it not your belief that she would have thought, hey, we got good service, maybe even because of the statutory confusion, when in fact you were moving it for another reason that wasn't apparent to her?
Right. And I think that's general how it's operated in Superior Court as well. I mean, it's the proof of mailing is sufficient. So, but that's not how I operate, and it's operated in probate.
You practiced in Superior Court, State Court under the Civil Practice Act, not the probate code, correct?
Yes, I have.
And so, those of us who do civil work or judge civil work, we know that there's a deadline, and if you don't meet that deadline, you're out of luck.
Right.
Have you found that to be different in probate work?
If you don't meet the deadline and you were served, then that would be an issue that I can show service. If you don't meet the deadline and I can't show service, then generally I will extend service pursuant to the statute and give additional notice.
Okay. I believe Ms. Veal has already put into evidence.
It's coming up.
Exhibit 70. And
This is the timeline created in Excel, whatever, by Judge Peterson.
yes, it is. And you had those pulled from the IT
Yes,
folks, correct?
yes, I did.
Then these were the actual emails, which are pull that up, number 68, correct?
Yes, that was the emails that were sent over by IT.
I want to put some letters that you saw up there from this, and I want to be very careful to keep these separate. So I'm looking at AT 048, page AT 048 of that,
Okay,
and down at the bottom. Who is this email from to?
from Jaquita to Bonnie.
Okay, and it says, hello, my name's Jaquita Mercado. I received a message that you were trying to contact me regarding my deceased father's estate. I'm usually available about 1:30 Eastern time. If you'd like to call, I'll also try to call you. Anything unusual about that? In your practice there?
No,
Or
Why would Ms. Basic be trying to contact Ms. Mercado?
I don't have any idea about that and who or how, what, why. But I know that Bonnie thereafter served Miss Jaquita for service.
I would remind the court that I think the probate lawyer said they called.
So I don't forget that, but Judge Peterson had said there's nothing out of the ordinary about that exchange, but Judge Peterson didn't know who had called whom. And so here is an unrepresented individual, pro se individual, who's being actively contacted by her staff. And I'm just wondering if that was normal, because what we've been hearing is we have a million cases. We can't reach out to everyone. It's their issue if they aren't able to meet deadlines or whatnot. So I just was curious if it seemed odd to you, Judge Peterson, that your staff had been reaching out to a litigant. It didn't seem like there was much outreach to the other side of this litigation, and yet someone was, by the appearance of this email, seeking to correspond with Ms. Mercado.
I'm not involved in those communications, but at some point I knew that, and I don't know who Bonnie talked to, but I know that I indicated that there was not service on Jaquita. So generally when I make that indication, Bonnie is trying to get service. I don't know how that was done. I don't know how Jaquita contacted Bonnie and who contacted Jaquita to contact Bonnie, but
do you know if Bonnie had even tried to contact Jaquita as opposed to Jaquita calling because the lawyer involved left a message, the probate court's trying to serve you or get in contact with you?
Well, generally, when I notify Bonnie that we don't have good service, I tell Bonnie to contact the petitioner, or if the petitioner has a lawyer, the lawyer, and they say, can we get a new address or a better address? And that would be how that would happen.
Okay, that makes sense. And you told us that before. Okay.
Yeah. So, and I'm just going to quickly run through these because I think they're sort of instructive. So then there's a message that says, I called, left you a message. Thank you very much.
I don't see that.
I'm sorry. Yeah,
Okay.
I called, left you a message. Thank you very much. That's from Bonnie, correct?
I can't see the top.
Write it down more.
No, that's from Jaquita.
Okay. And then Bonnie writes back and says, you can call me, and leaves the number there. Is that correct?
I think you're reading them out of order. I think the bottom is the original message, the first message in this chain. Please let me know how I can pay by my credit card.
Okay.
And then Bonnie says you can call her to pay. And then she's tried to call Bonnie to pay for the.
This was after this was after you had received a facsimile copy of the caveat, correct?
Yes.
I just want to show you one other, which is, this is an email from Bonnie to Jaquita, correct?
Yes, it appears, yes.
And this is where she lets her know that you didn't receive the email that you said you could use the emailed objection, but you still had to pay the fee and tell her what that is, correct?
Right.
Okay.
Where do those fees go?
General fund. So the fees are defined by the legislation. So they're specified in the legislation.
They go into the
County general. Yes, and then there's certain allocations for, like, so the petitions, there are certain allocations for probate, judge retirement. Yeah, different things, ADR, things like that, in accordance with the code.
Like the record, but placed it up, I took it out, found it back.
It at least looked like you tried to.
I want to move on and talk about the petition for the letters of administration.
Before you do that, you're getting a note.
Thank you. Yeah, good. You appointed an attorney from the legal fund that you had in the year support case, correct?
Yes.
And I know, because we've looked at the order, it looked like you were appointing a guardian, and the orders were all messed up, correct?
Yes, they were.
And that was a mistake.
Yes.
And what I want you to do is tell me first why you were appointing the attorney. Were you trying to favor one side or the other?
I was not. In the hearing that we had, the attorney for the petitioner asked for discovery. And when we were in the hearing, the caveator indicated she didn't know what discovery was and basically wouldn't know how to respond. So to facilitate getting those responses to her and not delaying this case even further, it was my intention at that time to appoint an attorney to assist her with getting the responses to the petitioner's attorney.
And are you permitted under the county regulations to use the fund for that?
Yes, I am.
And tell the panel, if you would, why you believe that.
Well, I asked for it. And that was one of the things I requested from the Board of Commissioners before I took office. And I made my intentions clear on what I needed available for my court. Another thing that has been done for years in our court was obviously in the regular petition filings, there is a portion that goes to indigent fund. I realized over the years, all of this money has been going into an indigent fund and no counsel has been provided to any party outside of guardianship. So I said, well, we should be stocked up on legal fees. So I would like to utilize it for legal expenses if necessary.
Okay. I have just a minute to clarify.
Handwriting.
Yes. Yeah, there's one other thing. There was, when you recused on the year's support, you requested that Judge, it would have been Judge Emerson, since he's the chief judge, assign somebody else to that, and he assigned Judge McLean, correct?
What year was this?
It's the
I think it was after Judge Emerson retired.
well, in any event, it went, I don't want to get bogged down in that, went to Judge McLean.
It went,
correct?
I think he was.
Judge
chief-
McLean's who got assigned to it.
Yes, he was chief judge.
Okay.
So Judge McLean's duty is either to hear the matter or transfer it to another probate.
Okay, and so would it be correct that the case still stayed in probate court, just a different judge heard it?
That's right. It's still a probate case.
And is that related to or not related to the fact that non-Article 6 courts, the Superior Court has de novo appellate jurisdiction, whereas they don't in Article 6 courts?
It makes a difference.
Okay. And so deciding the year's support, if there was or wasn't a year's support, would it have been correct that the file, whatever's decided about that, to handle the estate, to close it out for bonds or whatever uncontested matters, that would have still gone back to the probate court?
I'm gonna object to one of the questions, compound.
Oh, I followed it. Did you follow it?
I did.
You can answer it.
Yes. Okay. Yes. So if there is a order signed and there's still outstanding matters, it would come back to the probate court for, and say reporting, things like that. Yes.
Okay. And the reason I'm asking that was because it seemed to be some allegation that you were hiding part of the file or you didn't send the whole file. And I wanted to know if that issue played into it.
Well, the reason I did is because I consult usually before I do anything that I really don't. Like this instance, I didn't know what portion of the file to send, but I was advised by other probates and the council to send the outstanding matters, which would have been the year support and the caveat. Every other matter had been ruled on. I made the ruling on the motion to strike. The motion to recuse was moot as I voluntarily recused myself.
Okay. Let's talk for a minute about your computer system. And when you came into the probate court, what type of system did you have?
It was Icon.
And was that what state court, Superior Court, others had?
Yes,
Okay, and you wanted to change that?
absolutely. We had no way of tracking our case count. I noticed that a lot of the fees were improper according to the code. So the code specifies how much the petitions are supposed to be, and it was just, they had to input it. So our clerks and the judge, I don't know who, but in the probate, they were inputting the fees, and sometimes those fees were not correct.
Okay.
And so I just wanted a more streamlined process with CJT is hosted by, they host the majority of the 159 probates. So, and they're also the software that will be entering us into e-filing. So I felt like it was necessary.
Okay. So did you meet with any resistance from that?
Absolutely.
And will tell me from whom, tell me from whom you received resistance for changing it from Icon to CJT. I think I got that right. Is that-
Judge Emerson, IT under the direction of Judge Emerson. And there was some brief obstruction or resistance from one of the commissioners at the time, Henry Mitchell, under the direction of Judge Emerson.
If you and Judge Emerson aren't chatting, how is his objection communicated to you?
They would add him to our email chains. So the first time I was alerted was when I actually, before I knew the power, the power as the constitutional officer, and I didn't have to go through the county to get approval. I did try to go through the county to get approval. So I talked to the technology committee, which consists of Henry Mitchell, Commissioner Mitchell. I believe Emerson might have some connection to that, but that was obstruction. They were trying to say, well, where are you going to get the money from and all of these things. So I was met with that obstruction. But then when I consulted with COAC, the Constitutional Officers Association of Georgia, and the Probate Council, and learned my authority, I decided to move forward. So then I put in the requisition. I negotiated with CJT so I could pay for it within my budget without having to ask for any additional money from the BOC. I input my budget on New World to request the distributing to the money to the CJT. I was advised via email that Emerson was holding up the approval of my funds being released to CJT to pay for it.
Do you know why, be it Judge Emerson or the IT folks, or whoever else, what their objection was to that?
That
I mean, put yourself, don't tell me why it's wrong just now. Just tell me what you understood their objection to be.
At the time, it was just obstruction of everything I was trying to do. It wasn't about, it's just they wanted to run it the way they wanted to run. They wanted to run my court or oversee my court and run it the way they wanted to run it. And if it was different, if I was changing things,
Okay.
it was an issue.
So, and when did you make this decision, consult with the constitutional officers and decide you would make the requisition and move forward? When was that?
It was around March 2021. So like I said, I had a 90-day plan. I had really made the decision before March, but I actually put in the requisition in March. And then I was met with pushback. So in order to approve a requisition, I got to get approval from the county clerk, who is under the Board of Commissioners, purchasing, finance director, and IT, because it's a software. Everybody approved except IT. And then I was alerted by IT that Emerson had an issue.
Why does the county clerk have to be involved?
It's the final approval for whatever reason. Maybe so the Board of Commissioners, ultimately the Board of Commissioners aware, but it's their policy. It's like when I approve, there's all these lines of people that have to approve.
So the dispute about getting I don't know whether to use the term data or information, but getting whatever you needed from Icon transferred over to CJT, when that came up, was that at or around the time that the Emerson JQC complaint was filed?
Yes.
Okay. And it was after the letter to the commission? It was
Yes.
after that was before you took office, so it was certainly after that.
Yes.
Correct?
Yes.
And was it before or after the issue with the courthouse?
Around the same, all of this was around the same time.
All at the same time. By the way, did you never, and I think I'm just going to quickly move through it. You never talked with Judge Emerson before you were locked out of the courthouse, correct?
No.
He never called you to tell you that was going to happen.
No, and I sent emails even when I was locked out, and I sent him an email. I never got a response until later when he told me that, sent that blanket letter of why.
And that was several days after you had,
Yes.
your access, your after hours access had already been terminated.
Yes,
correct?
it was.
You say sent an email. Was that the email where you said he should retire, his time is done, or that was different? Email?
I sent a different email. I sent two. I sent one that said, hey, I'm at the courthouse and I'm wondering why I can't get in. And I copied him, sheriff, all of these people. They didn't respond. And I sent a follow-up. Hey, I'm just following up on this. Didn't get a response. And then several days later, I got his email it was an email. He testified it was a letter, but it was an email, and he copied Trent Wilson and sheriff saying, hey, here's bombs and all that email. And then that's when I responded and said, hey, that didn't even happen.
And the email that he sent you, and I think it's in the record, or it will be in the record, but that's the one where he quotes CNN about different threats to courthouse and whatever else.
Yes.
And at the time he sent that to you, you had let 4 people in, correct?
Yes.
Your Honor, I'm going to object to leading the witness.
How many people had you let in?
I let in 4 people up on.
How many people did Deputy Clayton let in?
Yeah, Mr. Tate, I was gonna
13 or
say,
14
yeah.
and-
Well, no, 30 times, so we don't know. Talking about total, all total.
But she wouldn't know that. So she would know the day she was there, and we heard 13 or 14.
So in the email back about, I'm flashing back to the Icon CJT transfer there. You threatened to file a lawsuit if they didn't assist you with that, correct?
I usually give a notice of intent to sue. I don't necessarily terminology. I don't use the terminology as threatened, but I do give them a notice of intent. It's never my wanting to do it. I would want to just be able to do my job.
Right. But did you feel there was anything wrong with resorting to the courts to decide whether or not you had the power to do that if you needed to?
I have a constitutional right to the courts. It's in the Constitution. And I also made the same notice of intent when they did not allow me to utilize my budget to pay for CJT. So there was some similar terminology there.
Okay.
And then it was ultimately released. My money.
Let's move on. I'm trying to go through these as quickly as I can, but the petition for the letters of administration, do you know what happened that, and I'm not talking about the date, we'll talk about the date stamp in a minute, but apparently, well, is it correct or incorrect that you had actually signed the order, but that somehow the lawyer hadn't been notified or it hadn't been stamped in?
I believe that's what happened. Yes, I believe there might have been a delay to when Bonnie got to it.
Okay. And again, did you ever purposefully delay that in any way?
I don't purposely delay any of my cases. It's my intention to resolve them and move them as quick as possible.
Is there anything in the uniform rules or otherwise that gives the probate judge a mandate in which to issue an order or a ruling by a date certain? I've asked that earlier, because Superior Court judges have a very specific timeline.
I don't, not to my knowledge, not in my reading of the rules, no.
I think the Superior Court judges is based on population as well.
Yeah, but
Not aware of anything with that. Do you remember what the start to finish time was on the letters of administration?
I believe after the publication, from what I understand, was November. And then I signed it in January. We went through the holidays of Thanksgiving. We went through the holidays of Christmas and New Year's, and then back in January.
And again, what year was this?
2021 was when it was filed. 2020, in January of 2022 is when it was signed.
And so this is during the COVID era.
Yes,
as well.
absolutely. We had a lot of cases, and a lot of my clerks were out with COVID as well as for the holidays.
Given COVID and given that there was a mix up in your office, was that an extraordinarily long time for that case to pen?
No, it was really good. That was really before we're improving every day, but like this was I'd say from the time that we got affidavit back to me signing, less than 60 days with several holidays in between, I say that was very good. I don't just do these petitions. So it's very important that you understand these are not the only things I do. I have hearings. I have,
Let me just ask you about orders then, because I think
Okay.
this, a judge is not a judge is not a judge. You have different volumes on, but like, on any given day, approximately how many orders or other files or whatever do you have there to look through?
it depends on if I have court or not. If I have court, that usually occupies most of my day.
How often do you have court?
Um,
Thinking about our probate judge. And how often she's in court, as in there's a hearing versus handling all the other stuff.
well, she has, I think, associate judges and hearing officers. I do it all myself.
Okay.
So I'm in court, at that time, it was 3 to 4 days a week.
But you don't hear littering, game and fish, what I would consider traditional probate judge
No,
adversarial, okay.
right.
When you're in court 3 or 4 days a week, are you 9 to 5 in court, or it may be 9 to 10 on one day because it was a quick calendar or was only one matter, in which case you'd have 7 additional hours to attend to paperwork?
It varies. So that sometimes I schedule 5 matters and sometimes hearings run over. We've had to run into the next day, or sometimes I schedule 4. We get them all done in the day. I do remember that particular year though. I had a week off because I was actually in trial. And yeah, so that was a week that I couldn't do wasn't available for any probate work. So that was in November. That was the week after Thanksgiving in 2021.
Is your clerk a lawyer?
No, nobody's a lawyer in the office but me.
Or I should say,
No,
do you appoint, when you're away, do you appoint someone to sit for you? If you got hit by a bread truck right now, who would be the probate judge? You'd have somebody.
no,
associate judge.
I would have my computer at the hospital. Yeah. Just, mhm.
Okay.
And so when I'm away, I take my computer and I'm still handling matters. So even if I'm on vacation, I'm handling matters.
And you don't issue arrest or search warrants generally.
No,
Is it true that the criminal jurisdiction vested in some non-Article 6, and I guess in Bartow, some Article 6 probate courts is in state court there?
yes, we have a state court. They've gotten that jurisdiction.
I think we're the largest county without a state court in Bartow. Okay. If I could go through, I've got a couple of more areas. If I could go through them and then take a break, maybe if we're going to take our afternoon break, I think it'll let me come back and finish up pretty quickly. I want to talk to you about this document visit where people from the JQC came looking for things at your office. Were you there that day?
I was in training. They usually come when they know I'm in training.
Okay. Was that after I was representing you?
Was that what?
Was that after I was representing you?
I don't know.
Okay.
I don't recall.
They know you were in training.
Oh, they know everything. Oh, they know
You're
everything.
better than me.
They follow my life pretty well. So they know when I'm in training, on vacation, they know everything.
That be because you're so active on social media?
No, I don't post when I'm on. I do not tell people when I'm gone or where I'm gone, but especially in training either. So, but that's public knowledge that, probate counsel when they're hosting, and usually JQC is there to train a class, or they are doing an ethics portion if there is a training. So usually they'll have that knowledge.
When the JQC comes up, does your office call you?
Sometimes, especially if they don't have the information or the resources to help them, they'll try to see if I can assist or what needs to happen.
You say sometime, I'm just curious, you make it sound like it's a once a month JQC shows up to kick the tires.
Oh, we were getting pretty much hit every twice to 3 times a month, and they would come in often flashing their badges. So I get calls. I've gotten several calls. It's been more than 5.
Your testimony is that 2 or 3 times a month, someone from the JQC would physically, personally show up at the probate court of Douglas County and flash badges.
No. I mean, when I said we get hit, I meant with complaints. I would get complaints, letters,
And
notifications.
these people are complaining about
Right.
it, the JQC is forwarding it. But
Right.
you also said that they're in my office all the time.
I said-
My staff is calling me.
I've been called at least 5 times.
They've come to your office 5 times.
Yes.
But the they is not the hearing panel, it's the investigative panel, the directors people, right? When you say.
Oh, no, not the hearing panel. Yes. Yes. And when I say people are complaining, a lot of times JQC was initiating their own complaints. So when I say the investigative panel or the director, they were self-initiated to my understanding.
Which they're allowed to do, right?
Sure, I'm sure.
We'll stipulate that none of the hearing panel have shown up at Judge Peterson's office. When you came back, you wrote a letter, I believe, about that, didn't you?
To whom?
To the JQC,
When I came back?
telling them you'd help them get the documents, correct?
Oh, I believe there was a email or it was something. I was given there was a investigator that came to my office. And I don't know if he left a card or asked me to call him or something, but somehow I got in contact with him.
Have you tried to be responsive is what I'm,
I did.
do you want a break now or do you want me to try to?
Oh, well, how much longer? I thought you said you were gonna cover a couple of things.
Well, I've covered one of the 2 and I've got sort of one left and then I'm
So do your one more and we can break. You can see if there's anything you missed.
okay, that'd be good. That'd be good. I want to talk about the homeowners association thing now.
Okay.
And in particular, I want to ask you, well, first off, if I understand correctly, you're certainly a member of the bar, correct?
Yes, I am.
And you had filed the lawsuit, but you were also a plaintiff in that case. Is that correct?
Yes.
And this meeting that you went to, and I don't think anybody would say it was a private meeting because we've seen the video and it seems that it was quite raucous at times. But in fact, on the director's exhibit, I think it called it a town hall meeting.
That's what they called it.
Okay. And so,
Just so I'm sorry, so I'm clear, it says that on the director's meeting. Is that what Mr. Houston called it? Was a town hall meeting, or that's a label that you're suggesting that the director has put on?
That's what the email that was sent out from Silver Creek Ranch email. So I don't know who said it, but that's what it was called.
But there's an origin for it.
Yes.
This isn't a term that the director has coined.
Right.
Someone who either was improperly elected or not, or whatnot, associated with your homeowners association labeled it a town hall.
Yes.
and we say it was a town hall meeting too. And we've all thrown that term around just now, but what's just in a vacuum, what's your understanding of what a town hall meeting is supposed to be?
You're able to come and communicate your issues, concerns, questions to whoever's supposed to be in charge, whoever's holding themselves out. In my case, whoever holding themselves out as the board, you're just communicating and not necessarily speaking directly to the people holding themselves out, but other people in your community. This is really the only time we can gather and meet with other members of the HOA.
And so were you entitled to attend the homeowners association meeting?
Yes.
And why were you entitled to attend the homeowners association meeting?
I'm a mandatory member.
And as a mandatory member, do you have rights and obligations relating to the governing authority?
Yes, I have the right, I have an obligation to ensure that I'm in compliance with all of the governing documents, but I also have a right to make sure that the HOA is operating in compliance with the governing documents.
Okay. And did you, when you went to this meeting, were the other people that were there, were they also constituents, I'll say, of the homeowners board?
What do you mean
Well,
constituent?
if they were people who were supposedly entitled to vote for, or
Oh, yeah, they were
vote
all
for-
most members. So I don't know if anyone was not a member, but everybody was mostly members there.
And would you characterize this, tell me whether or not you would characterize it as a governance type meeting?
I would say so.
Okay. Now, if you would pull up for me the link I have about the State Bar Handbook, please. And you can, the text on the right is what I'm really looking at, not the index on the left. So if you have to move it over or can move it over, that's certainly fine. So did you go there to try to negotiate some settlement with the homeowners association?
I didn't. I didn't even really want to bring up litigation. It was brought up by other parties. And so I had to address it, but no, I wasn't definitely. So
I want to read what Judge McBurney asked you about earlier. But he didn't quote the rule, but the rule says a lawyer who's representing a client in a matter shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter unless the lawyer has consent of the other lawyer is authorized to do so by law or court order. You're familiar with that?
Yes.
Did you believe you were violating that when you went to the to your homeowners association meeting?
Absolutely not.
And in addition to being a lawyer, you were a party to that litigation, if I understand correct.
Yes.
I want you.
I'm sorry, can I ask why you believe you weren't violating this rule?
Well, and to be clear, the question was by attending. I don't think attending is a problem, but I'll bet you that Judge Lopez is about some of the things you said, how they were possibly not violative of Rule 4.2.
Well,
The easy question was being there.
Well, if I could ask one more question before Judge Lopez, I would appreciate it because I think it might shed some light on that. And I want to look at comment 1 under the rule and the last 2 sentences of that, which says a lawyer having independent justification or legal authorization for communicating with a represented person is permitted to do so. Communications authorized by law include, for example, the right of a party to a controversy with a government entity speak with the government officials about that matter.
Had you ever read comment 1 to Rule 4.2, Judge Peterson?
I'm sure I have. Wasn't fresh on my mind, but we had to read it in law school.
What does the first sentence you've highlighted mean? The second sentence I don't see as relevant necessarily, but
Is that for me? Is that for me or for the witness? Yeah. So a lawyer having independent justification, she had independent justification for attending the homeowners meeting because she was a member of the homeowners association.
I don't think we're quibbling about her attendance.
Well,
Attendance, we have no issue with. It's the talking to a represented entity about the litigation at issue.
well, that's where my answer to Mr. Hyde's question about the second sentence says, because the first word there is not attendance, it's communications. And it says communications authorized by law include, for example, meaning it's not exclusively a government entity, but the right of a party to a controversy with a government entity to speak with the government officials about that.
Well,
And
you don't need to argue with that, and that maybe is for closing argument.
Yes.
Judge
And
Lopez may now have the follow-up questions he had for.
And I
Judge
apologize for,
No.
but I just felt like it was important to put that out there ahead of time.
I'm good.
Well, did you believe that you had a right as an individual, not as a lawyer, to attend your meeting? Did you believe you had any independent justification for that?
Yes, absolutely. And really, when I attended in my personal capacity. Yes.
Okay.
I also
Go ahead. Sorry, go ahead.
No,
Did-
I'm
I also did not believe that the people that were holding themselves out to the board were official representatives of the homeowners association. And the reason why I believe that is because in my prior lawsuit, in which there was a similar issue in how I make the terminology, I'm using it loosely, hijacked the board. I received a ruling from the judge that their behavior was improper. They were not duly elected and they were not duly authorized to represent the HOA.
Well, and that now has spurred a new question. If you truly believe that these folks did not have any authority and were not represented parties, why would you offer them the opportunity to dismiss your lawsuit if they recalled a new election? If they are not the duly authorized board, because I would assume only the duly authorized board could call a new election, but you've offered in exchange for dismissal of the lawsuit, as far as I can tell from the video and the transcript we saw, you said if you call a new election, I'll dismiss the lawsuit.
So my communications and really what I've learned with the HOA, it's about who has access to do it. Obviously, it's been determined that they have access to the mailing list and things like that. So I'm speaking to whoever wants to hold themselves out. Even when I did the prior lawsuit and the judge ruled in our favor, the judge also ruled that the people who were not authorized to serve, they had to send out the notices because they had the access to the HOA's information.
Judge, I don't think you can have it both ways. They're either authorized to do something or they're not.
Right, they're not.
And if you don't recognize their authority, then I'm not sure I'm having a hard time understanding why you would offer them the opportunity to have the case dismissed in exchange for the dismissal of the lawsuit.
You were negotiating the case with represented parties in the context of an HOA meeting. I don't know how you spin it otherwise.
Well, I'm not. I think it's like somebody with a shareholder derivative suit going to the shareholders meeting.
You get to argue that at the appropriate time.
So,
Well, let me ask.
but I'm not intending to argue that they weren't opposing parties or anything like that. That's why I'm bringing that up.
Let me ask you a new question. When you made that offer, were you making that offer as the attorney for the plaintiffs, or under what capacity were you making that offer?
Well, it's just me. It was just me in the lawsuit. So there was not multiple plaintiffs. But the only reason I mentioned it is because there was some commentary about you're suing the HOA. And my response was, well, it's not my intent. It's never been my intent to sue the HOA. I just want to make sure we're following the law and doing things right. So I wanted to express to my members, the members of the HOA, that we just want, and you didn't get to see the first part of the meeting, but there were people complaining about not being able to vote, not voting for these people holding themselves out. So I'm saying, hey, I understand you were not representing yourself as the board when I filed the lawsuit, whoever you are, however you got here. If you can make this right, I would be willing to dismiss the lawsuit against the HOA because that's not beneficial to anybody in our HOA.
Right. And let me go back to my question. In what capacity were you making that offer? Were you making that capacity as the lawyer for yourself? Or what capacity?
Well, it wasn't.
Individual?
Yes, it was as
Or as the lawyer, or as both?
it was more so, when I was speaking, I was more so speaking as a homeowner in the HOA. Like I said, they brought up the lawsuit and they were and that was being talked about. So I wanted my members to understand it's not the lawsuit. That's not what I'm interested in. I'm not interested in litigation. I'm interested in abiding by the bylaws. I'm interested in an election and making sure everybody's voice is heard and they have a right to vote. So that was because I'm serving in the same capacity and I have the capacity to dismiss my own lawsuit. That's what I was saying.
Have a break now and then
If you're done talking about the HOA meeting.
I think so. I mean, I may have some, Mr. Chamberlain may remind me of something that I've left
Been
out.
writing furiously on his yellow notepad.
I will read both sides of the sheets of paper to make
All right,
sure.
it's a little before 3:30. Let's be back by 3:40 for whatever remains. But are we gonna have enough time to cover your witness who needs to go today, Ms. Field? Because if we need to give Mr. Tate a longer break, in other words, after our break, we take up your witness, we can do that. Judge Peterson has gotten expert at having her testimony interrupted.
I have a witness that I have to call before the one that is leaving tomorrow morning on the plane.
Okay,
They're both going to be short.
then we'll be able to fit them in if Mr. Tate, it doesn't sound like you. I don't know that you could have a whole lot more for this first round of direct, because of course you can do this again.
Yeah.
Okay,
And I've tried to hone to the.
all right, 10 minutes, please.
Thanks.
here. You guys aren't safe. The bailiff's not here. That way, okay. We'll get you that.
No, you're doing it.
All right, please be seated. Judge Peterson, you ready for now one last trip to the witness stand? You're getting your steps in. All right, Ms. Wombley, ready? Great. We're back on the record after our afternoon break. We have Judge Peterson on the stand for a handful of additional questions from Mr. Tate.
First thing, Judge Peterson, you heard me mention when we put the transcript in, that I hadn't seen the transcript from the homeowners meeting at that point in time. And I said, we may not agree with everything was said. There were two instances I was talking about, and I want to ask you about those. At some point, I don't know if it was in one of the failed motions for interim suspension or whatnot, but there seemed to be an allegation that you called someone a witch in that tape. Did you ever call anyone a witch?
No, I did not.
Did you say anything that might be misinterpreted as that?
Oh, well, I was wondering where the JQC got that from her. But when I looked at the video, when I was saying you wish, after Tammy Tatum accused me of stealing money, I said, you wish. I said it several times because I know she has firsthand knowledge that that's a lie.
Okay. And did you ever call anyone low class?
I did not. I said she's in the low place.
And what did you intend to convey by that phrase, low place?
Well, my experience with Tammy Tatum from that day and before in my dealings with her, she's been very mean, evil, aggressive, just blatantly make up lies. And I can understand her frustration because the original lawsuit is the one that I removed her that was holding herself out as the board. And we corrected a lot of mistakes that she did. So from then on, she has been really attacking me, not physically, but
So she was removed in the first lawsuit?
she was. And that's how she knows that the settlement was not supposed to be distributed evenly or equally with my clients.
In any of the, I want to ask you sort of a broad and two broad and sweeping questions here, and there'll be my last questions. But any of the actions that you took on the bench, which I mean acting as a judge, decisions you made based on law and facts, applying the law to the facts, did you ever rule in any way that had pertinent law that was clear and well settled, telling you could not do what you were doing or that you should not do what you were doing?
Not to my knowledge. If I would have known the law, if it was clear and pertinent, I wouldn't have done it.
And then finally, for other things that you're accused of doing while you've been a judge, but while you have not been acting in a judicial capacity, ruling on a case, applying the law to facts, have you ever undertaken any of those for personal profit, for revenge, or for anything that might, in a general sense, be characterized as bad faith?
No, not to my understanding. I've never done anything in bad faith. I try to do the right thing. That's what I generally do. And I pride myself on that.
That's all the questions I have. Thank you.
Thank you, Mr. Tate. Do you have any recross, Ms. Veal? And before we get, do you want to do that or do recross?
No, go ahead.
If you have it, do you have any recross?
I do.
Let's do it.
Judge Peterson, you brought up several things that as the director of this agency, I have an obligation to now address. You took a lot of time to explain that all the things that are different now that Douglas County has in Article 6 probate court. And one of those things you mentioned was jury trials. You've had none since you've been the probate judge, correct?
None yet. I have three active jury trial requests. Yes.
You have presided over 0 jury trials.
At this time, yes, I have 3 pending.
I think I laid it up there on the.
Your clearance rate certificate. Clearance rate excellence. The figures that were submitted to the Administrative Office of the Courts in reference to your clearance rates, who provided the AOC with those?
My chief clerk from our CJT. So the numbers that are coming off of, the numbers they're requesting are direct reports from CJT. They make them directly available on my new system.
Ms. Fazek provided those numbers to AOC, correct?
Yeah, that was, I believe that was 2020. What year was that? That's for 2022.
Calendar year 2022.
Yeah.
Okay. What figures did she actually send them? What figures did she track? Because I heard you mention that you've had 5,000 things filed in your court and you're very, very busy.
Yes.
The number used to calculate clearance rate is not that 5,000 figure, correct?
I don't know what they used to calculate it. What was reported is what was available in the CJT system. So whatever they requested and however they view it, I don't know how this agency does it, but this is just what I was sent. But the 5,000 is the matters, at least, that we handle in my court.
Okay, but you don't know how this rate is calculated or anything like that?
No, but I'm very proud of the accomplishment.
Okay, well, what was, according to the figures that you submitted for 2022, Ms. Fazek, what was the clearance rate for 2022?
What was the clearance? I'm reading off the paper. So we report on that reporting. I know it's reporting for petitions. There's a separate reporting for marriage license, weapons carry license, how many were denied, things like that. I'm going to assume since it's clearance rate, it would be regarding the petitions.
Okay.
The petition filings, which would include wills, estates, guardianships, conservatorships, and any motions and their things filed with that.
But you don't, as you sit here today, we've gotten these documents. You don't know what your clearance rate was.
Yeah, I have access to my report. Absolutely.
So what was it?
I can pull it,
Okay.
but I don't have it on me.
This letter says it was 100%. Is that correct?
Yes, it does.
And is it true that last year your clearance rate was 52%?
What? How would it be? How would I know that? How would it be 52%?
For, I'm sorry, 2021, 52%.
Oh, I don't know. See, 2021, we were on the icon system and there was not accurate reporting on the file. So there was a lot of things that was guessing. I was looking back and I looked at an email that I was asking Judge Emerson, how do you even pull the numbers from icon? So I know once we transitioned over to CJT, we can more accurately see what we were working with.
So Judge Emerson actually helped you to compile your numbers from icon so that you could get those numbers to the AOC, correct?
No, I don't recall that. I haven't had any conversations or communications with him. I don't recall when looking back, seeing an email where he told me how to do it. But we haven't had any verbal communications.
Well, are you aware that anything he did try to assist you in that?
In that, I'm not, in that matter, not necessarily, no. I know I've looked at old,
Necessarily doesn't mean yes or no.
I don't recall him getting it. I believe I just went on the icon system and pulled what was available, not necessarily knowing if that was, it's just what the court had access to at that time. But remember, when I'm in 2021 and we're reporting numbers from 2020, and I wouldn't have had any dealings with that. So yeah. And then in 2022, we would have been reporting 2021 numbers, and those numbers were half Icon, and then converted over to CJT.
Okay. You mentioned during direct just now again that the only individuals you got money from on Cash App as a result of your post were 2 family friends and a colleague, correct?
No. I didn't say as a result of the post. I said on my birthday or around my birthday. Those are the gifts I got. I didn't say it was a result of the post.
Do you remember last week when you indicated that you'd bring us your Cash App records?
You didn't ask me that. You said, do I have them? I said, yes.
Okay. And do you recall me asking you to provide them?
No, I
Okay.
don't.
Okay. And you don't have them here today?
It's on my phone, yes.
Okay. Will you provide them?
I have to consult, I have to consult with my attorney, but sure.
Why wouldn't you provide them?
Well, I feel like JQC is pretty adamant in knowing what they're talking about. So I feel like they should be able to prove it honestly. But what I said was what I said. That's the money that came in, the people that I already know.
So why wouldn't you provide the Cash App information upon request from the director?
It's not that I wouldn't provide it. I definitely will provide it, but I'm understanding that these proceedings that they've made claims against me, they have to prove those claims. It's not that I have to disprove the allegation. So I just really would not like to be held in a position in which I'm guilty until I can prove my innocence. I feel like they have the burden to prove guilt.
What does that have to do with whether you'd provide discoverable information?
You're asking a question. I'm just going off of all these proceedings and how we've been interacting with each other. I'm just not compelled to give the JQC hearing panel or director who I feel has a personal vendetta, anything. And that's just personal how I felt. I felt like how I'm supposed to be as a judge, and I'm supposed to be impartial, and I'm supposed to be these certain ways. I believe that standard is not upheld with not your panel, but what I've seen interacting with the panel, with the investigative panel and the director, as well as they don't hold the same other judges to the same standards. So it's kind of where you cannot respect them because you feel like they are personally out to get you. And that's my personal feelings about it.
Do you understand that my job is to investigate and prosecute allegations of judicial misconduct?
No, I understand. What I understood of the agency and what I was hoping that the agency would be is more so of a body that would be available to judges, that if they had any questions about ethics, they would be able to reach out and understand so they can be guided in what's proper and improper. It doesn't appear that it should be a prosecutorial agency that practices selective policing or discrimination. And I feel like that has been applied to me in these cases. Just even in this trial, I've been accused of not cooperating with other judges, but you had another judge on the stand saying, I didn't want to talk to her, and that's acceptable. So there seems to be a double standard, and it's very disheartening, if you want me to be honest.
All right, you have injected into this proceeding on more than one occasion discrimination, and you have insinuated that somehow much of this has to do with your race, and you just use
No.
discrimination.
Oh, I didn't say race. No, I'm sorry. I didn't mean to infer that. I don't know what the cause is. And when I say discrimination, I mean discriminatory policing, which means if I have an issue or any party has an issue with a judge that you favor, the JQC I'm speaking of, those complaints get dropped, even if they're clear, blatant violations of the code. But me, I'm seeing the assertions and the misrepresentations of things I said to make it appear egregious. And that seems to be selective and discriminatory policing by your agency.
What judge do you know has had the volume of complaints that you have had filed against them?
Well,
I'm gonna object, Judge, because one, volume of complaints is not relevant.
Your client has driven the conversation to this point. She needs to answer the question.
I don't know any, but I also don't know any judge that has been elected in a partisan race in a county such as mine, where there is a group of people who are trying to override the will of the voters. And it hasn't just happened to me. It's happened to other elected officials. The same things occurring with me has happened with our coroner. It's also has happened with our commissioners.
It's not responsive to my question, as has been every day of this proceeding.
So less on the speech side. The question was, who are the judges who are doing things similar to what you've described, who are getting away with it? And there are all these complaints, similar volume of complaints, and yet the JQC says, you know what, we're just not going to worry about it.
Well, I know
You said in effect that that's what happened.
that is, and I'm,
You're being treated differently. You're faced with however many complaints it's been.
yes.
For it to be discriminatory, some other judge or judges have received a similar number of complaints and they're treated differently. So the very simple question was, oh, who are those judges? And then you start talking about a coroner.
Oh, no. Well, the other judges, in particular, Judge Emerson, I've made complaints about him. There's been community members who've made complaints about him. And those complaints were, in essence, I've been made aware of those complaints. JQC has dismissed them without even speaking to the complainer, but the alleged violation was in direct violation of the law.
You still haven't answered the question. What judge has had the volume of complaints that you have had with the JQC?
I'm going to hope none, because this has been a concerted effort to attack me, and I'm going to hope that no one else has to go through what I had to go through. So I'm going to say, I'm going to hope none, but I don't have direct knowledge of what you all receive in your office.
You continue to reference a complaint that you filed against Judge Emerson, which was dismissed, and that is one complaint that you filed against Judge Emerson, correct?
Yes, and I just didn't mention that one. I mentioned from another constituent who filed a complaint against Judge Emerson. It was dismissed, and she contacted the director about her discord about it being dismissed. She said she was going to the media and she was threatened by him that if she goes, he will pursue legal action against her. I saw the emails.
Okay, what, you said the director sent
At the time,
an email that said, what?
there was a correspondence that she filed a complaint. The complaint was dismissed. She submitted her discontent with the complaint being dismissed because it was in clear violation of the law. At that time, the allegation was that Judge Emerson had.
I'm not asking you what the
Okay.
allegation is, okay? Please answer my question. You made a statement that the director sent an email to somebody, I think
Yes.
it's your friend that's on the Democratic Party, right?
Oh,
Is that
I
who it was?
don't necessarily have friends, but yes, her name is Ingrid Landis
And
Daly.
you said the director sent her some written correspondence.
That's right.
Correct? That said, if she went to the media, he would.
There was some type of threat. If she threatened to go to the media because he's dismissing her complaint without cause, he didn't even contact her, or no one contacted her in regards to her complaint. It was just dismissed. She said she would go to the media. And then there was a response by the, at that time, director, that if she went, there will be some type of consequence.
And you said you've seen this email, correct?
Yeah, it was at the time. It was done maybe 2021, maybe 20.
But when I just referred to her as your friend, you seem to disagree.
Colleague,
Excuse me?
colleague.
Okay, that showed you her email from the then director.
Right, colleague, because one of the issues that were being addressed, it was not just only the personal, what they call witch hunts against me, it was other Black women elected officials that were being targeted in my county as well.
Well, let's talk about that. There are actually several other Black judges in Douglas County, correct?
Yes, they are.
Judge Cynthia Adams, for example, was appointed and ran in an election and won before you got onto the bench. She's a Superior Court judge, correct?
Right, in a nonpartisan race.
One of your juvenile court judges is a Black female, correct?
Yes, she's appointed.
Okay, and then one of your magistrate court judges, Black female?
Appointed.
Okay. And you have a new Black female Superior Court judge, Judge Warren,
Appointed.
correct?
All of those nonpartisan.
Yeah,
So what?
yeah.
Well, I get it. I'm definitely don't mean to offend anyone, but this is my reality. This is my truth. In my county, there's a heavy discontent with partisan officials. So yes, if you were appointed by the governor, you're clear. But when you're talking about Democratic electeds in my county, generally, unless you have some type of favor with certain portions of the community, then you will be a target of these attacks.
I thought you had no opposition in supposedly highly partisan situation. Your only opposition was in the Democratic primary. There was not a Republican opponent.
Right. I'm not talking about people running. I'm talking about people in power or who've always had power in Douglas County that are yielding their power to this day. That's my truth.
You just testified that you remain confused about what about your post violates the code, correct?
Yes, everything that we've talked about in regards to social media, I'm not clear.
And the JQC is to blame for that. Just
I'm
to say,
sorry?
The JQC is to blame for that.
To blame?
That's that.
I'm not necessarily saying the JQC is to blame. I'm going to say from my reading of the code, it's not clear. I haven't been able to communicate with the JQC to get clarity. And I know that the correspondence that I received in regards to social media wasn't clear. So a blame, placing it on any individual entity or person, not saying that, I'm just saying if there's clarity to get, I would be welcome to it, wherever it comes from.
Okay, you agree with me that the first notification you got from this commission related to social media complaints that were filed by citizens in your community. The complaint laid out the allegations and then cited which rules were of concern, correct?
Well, I don't know if there's citizens in my community. You would have more information on that. But you asked me about that last week and you gave it to me to see it and I advised it was not clear.
Okay, that was in December 29th of 2020.
Right.
Did you bother to read the code after you left that meeting? Because I know you said in the meeting that.
I did.
Okay.
I did.
So you read the code after?
Yes.
You're still confused?
Yes,
Okay.
because under the code, especially, like I said, it talks about different things. It talks about you able to host events, you're able to participate in events, you're able to do certain things. I didn't see that. I didn't see. And then when I read about you lending the prestige of your office for private interest, I read that such as, say somebody got arrested, like a family member, and I call and say, hey, that's my cousin, I'm the judge, release him. That's kind of how I interpreted it based on the commentary. So I just never would have figured we were talking about posting information such as what time appetizers are going to be on a special. I just didn't correlate the two.
I see. After your appearance at the February 2021 investigative panel meeting, I actually reached out to you and advised that the investigative panel wished to resolve all of your social media issues with a deferred disciplinary
For a second, stop. Don't answer the question.
Are we going into settlement discussions here?
Might not be a bad idea.
Judge, or
Your response to Mr. Tate's concern?
Your Honor, she has painted a picture that she is being discriminated against by this agency, that we are selectively policing. And in response, I need to be able to explain what we attempted to do to resolve her matters.
Mr. Tate, if it is limited only to the social media piece, I don't dispute your characterization, but I'm seeing if there's a middle ground, because as I understood where this question was going, it was early enough in the process that this was, according to Ms. Veal, an opportunity for your client to work with the investigative panel to sort out the social media concerns, which is not an uncommon approach that the investigative panel takes when a judge is struggling to navigate the sometimes unclear contours about social media. And so I think our interest would be less, what was the offer, as it was, were you maybe given some information about what the concerns were? Because your client has steadfastly maintained, I still don't understand, was it the picture or the fact that someone had a drink or this or that? If in fact the director or investigative panel engage more substantively, whether it's under the aegis of settlement or training or whatever we want to call it, that would be inconsistent with what your client has said thus far. So that's where I think we're interested, not in did someone reject.
Well, may I respond
Please.
to you, and it may take slightly at length, so I ask you to bear with me for just a moment here.
And were you representing?
No,
Judge
I was
Peterson at that
not.
point?
I was
Okay.
not. And I wish I had been in one respect, because I've resolved several of those. I think I sent one to you all where I had resolved, with regard to the social media. The issue here, though, is that Judge Peterson believes, and I think has just testified to, they're flooding the zone with complaints about me. And I would ask the court to take judicial notice of the fact, because it's within the breast of this court, that charges were filed against her by Chuck Boring, the then director, for calling to get a clarification about her role with the foster parents group that she had. And Ms. Veal, Director Veal, when she came in, she dismissed that, and I understand it.
But we're talking about the
But
social media piece.
we are talking about the social media piece, but we're talking about, we want to cross-examine Judge Peterson about, well, why didn't you just go down there and work that out? It's because when I call the JQC and Chuck Boring answers the phone, it means I get another charge against me.
Well,
So I think that's,
in fairness,
Just let them finish and then we'll hear from you.
so I think if we're going to plow that ground, we need to make sure we're plowing the whole ground about that, because there's no doubt in my mind that everybody got crosswise about this. And I think in hindsight, either I or my colleague, Ms. Veal, could go back and sort out where we could have had this train go someplace differently. And I'm happy to have that discussion, but we got to have the whole discussion.
So sort of rule of completeness concern that Mr. Tate is bringing up.
That's fine. We can go into all of it.
Do we need to, for purposes of you proving your case? I think you have been exploring areas you're entitled to based on answers we've heard. But I'm, as I try to link them to different charges, it may go to impeachment, credibility, et cetera. But I understand that you are trying to clarify some things that have been said on the record that really don't relate to what you need to prove, but may be deemed by many to be somewhat inflammatory.
Sure.
But I just don't, that may be a conversation that doesn't necessarily involve the hearing panel deciding, have you met your burden of clear and convincing evidence?
I understand that, Judge, but for the hearing panel and then ultimately the Supreme Court reviewing this matter to be left with the impression, which is all we have right now, which is what she has put out there, that the JQC did not help her. We have selectively policed. I mean, that's just not true. It is inaccurate. And so
I wouldn't have a lot of worry that we think there's selective policing going on. Folks are entitled to that view. I don't know that the hearing panel subscribes to that view. I do think you ought to be able to explore, if you think there's evidence to support it, whether Judge Peterson was given clearer guidance than she's describing. She has described it as, I basically got these letters and I was left no more informed than before about where the limits were, what I should and shouldn't do. And then there's the dark cloud that Mr. Tate adds to the equation of, I reached out for some clarification and then all of a sudden there was a formal charge. Now that's the way he's characterizing it. Not before us anymore are the allegations concerning the foster care. And so I'm particularly reluctant to go into that area, other than that it might inform us in better understanding why Judge Peterson would be reluctant to say, could you please one more time explain to me what's going on with the social media? Because she felt scarred and scared having asked about foster care, and then look what happened. So if we limit it to you exploring with Judge Peterson information she may have received, it really doesn't matter the setting for the hearing panel that would have clarified the social media. I think you should be free to do that, and we don't necessarily need to dive into some of the other stuff. If it's information you push to her, if your argument is, why didn't you ask us for more? Then I think we're going to need to hear from Mr. Tate about the whole foster care scenario, and
which happened far after the investigative panel's attempt to resolve all of these things.
oh, so Judge Peterson wouldn't have felt, wait a minute, I asked for help and then new charges were brought. She'd have to have a crystal ball to feel that way.
That's correct.
Okay. If it hadn't happened yet, that couldn't have been a deterrent to reaching out, Mr. Tate.
Well, in the first place, I do want to put on the record that the JQC object to them having a name clearer here, which is basically, I understand Ms. Field, she's pro at what she does, and she's defending that agency, and I get that. But you're not entitled to, oh, you said some bad things about me, so I'm gonna use here to get that. The second thing is, I don't know what the exact timing about this, and some of it, in fairness to me, was before I actually got in the case. But the time period that we're talking about here is very compressed, because you'll recall that she got the social media complaint the day that she was sworn in. So I think that by itself is, this is not a friendly environment, at least to navigate without a lawyer.
Okay.
To try to do that. I don't know the exact, I'd have to go back and look at.
I'm going to ask Ms. Veal a couple questions, and then we may just need to move away from this space. I think your point is well taken about the name clearing. That's not what we're here for.
I feel like I'm close to needing to send Mr. Boring a subpoena for for my portion of the case if we're going down this road. So that's one reason I want to bring it up now.
Okay, so Ms. Veal, you were about to ask, you had started to ask Judge Peterson about a February 2021 meeting that she had with the investigative panel.
Correct.
When, to your recollection, did any exchange occur between Judge Peterson and the director's office or the IP in relation to the foster parenting?
It was after that meeting.
But was it 10 minutes after or 10 months after?
Maybe 2 weeks. But the idea that because there was a charge or she had turned into a complaint, that would have happened. I would need to look at the dates, but that did not happen immediately when she reached out. And this is not about her reaching out to ask for advice. I know you've read the charges, but after inquiry of the people who were at the NJO training, the problem was that she had misrepresented.
I remember what the allegations were. They're not before us. Why don't you ask, without getting into settlement pieces of it, the question you want to ask about the February exchange that either was hopefully going to occur and didn't, or did occur Ask the question and I'll see what Mr. Tate has to say about that question. And we can explore that and we do need to move on.
Your Honor, the problem I have is that the exchange that I was about to get into encompassed some offerings of the investigative panel in the form of a resolution. And if I can't get into the resolution, I can't get into what were the pieces of that resolution which would have helped a new judge.
Okay, but it all relates to social media. That was all that was before I guess, I don't remember the timing. I guess Judge Emerson's complaint was March when he raised this issue about client funds. So that wasn't before the IP. At this point, it was simply citizen complaints about social media postings, the things we've been looking at.
Correct.
That was it.
before she appeared at the investigative panel or after?
Can I put something in the record here?
Yeah, just let Ms. Veal answer Mr. Hyde's question.
She appeared at least one investigative panel meeting. Where was that in relation to the social media complaints? It was after that, correct? She had taken office.
Correct. She was noticed for those complaints December 29th of 2020. We invited her to appear in January of 21. She asked for additional time or a different date, so she appeared in February of 21.
And that's what you want to ask her about, that meeting in February.
I wanted to ask her about the offer to her to resolve after that.
Occurred at that meeting or flowed from it. Okay.
Shortly there.
And I have the actual complaint, the original complaint that I put up here. And it shows that this call on February 8th, 2021 and March 4th, 2021, Judge Peterson failed to establish, maintain, blah, 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 by making false and misleading statements to the director. So her contact with the director, Chuck Boring, is contemporaneous with what Ms. Veal is trying to put into evidence right now.
Okay, but to Ms. Veal's point, when did that become a problem for anyone? Only when it became a formal charge. Judge Peterson had no reason to believe in February or March or April until their formal charges that her exchange with then Director Boring was problematic in any way.
You think this was a pleasant exchange on the telephone about, that he later files charges about? That's sort of, I'm sort of stunned by that.
I don't know what the exchange was like.
And I mean, maybe we should go into that. Maybe I do need to subpoena him as witness, but the point I'm trying to make to you is they were looking, whatever attitude they had toward her, which Ms. Veal wants to now put as benevolent. We were there to help you. We were going to assist you. When she called that same month, the response of the director and his attitude toward her was certainly not one of helping. He's thinking about making a charge.
So I guess you and I are remembering that charge differently. I thought the basis of the charge was whether the phone conversation or face-to-face conversation was perfectly cordial or maybe a little tense. It wasn't that Judge Peterson behaved poorly in the phone call or called me a witch or said you're an obstruction. It was, she said something that the director then believed was untrue. So it was false statements to the director or the investigative panel, not that we had a uncongenial conversation.
Okay. As far as I know, Mr. Boring was not there. Somebody else was trying to do it there. But my point is, she calls and asks about this, makes statements about something that he was not present at, and he presumes she's a liar.
Well, I don't know about the presumed part, but the allegation that she said something that wasn't 100% truthful didn't come for months after the exchange that Ms. Veal wants to explore, right? I mean, these formal charges, what's the date of the formal charges?
Well, the date of the formal charge is 9/28/20.
Okay, months.
So but before we go to that, we have to have, she's entitled to a panel meeting on each one of those. So it's not like, oh, it's a pleasant conversation in February, and we really help you, we're gonna file charges in September. That to me, I gotta tell you guys, that just kind of stuns me that anyone might believe it.
How many meetings was she invited into before she had a lawyer?
Before she had a lawyer, one,
And then after, how many?
two.
Well, This is taking longer than it needs to, but I guess, Mr. Tate, we're gonna agree to disagree. When Judge Peterson had that conversation with Mr. Boring, charges didn't flow immediately from there. If the allegation was there was something that wasn't truthful about that exchange, there presumably were additional steps taken to investigate the veracity or lack of veracity. And yes, ultimately charges were brought and they may have been discussed at an IP meeting. My point is simply, those are all weeks, if not months, after the point in time where we are. And so the concern you've got that the reason why Judge Peterson may have had an adversarial perspective with the IP is because of locking horns with Chuck Boring, who said, then I'm bringing you charges. You've got your history off because charges didn't flow for several months after. And so you may need to subpoena Chuck Boring if you think it's material to see what he has to say about, yeah, we had this exchange and I took her at her word, but of course we check things. And we talked with some people who were at that training and they said, that's not what we discussed.
I'm only going to be clear about one thing.
Okay.
If we're opening it up, my request is going to be we open it up full steam because we're going down the road of putting settlement negotiations in. We're having a name clearing here for the JQC. And it's not what's good for the goose is good for the gander.
Well, to that point, we had a name calling hearing about the JQC, and I think it's appropriate for Ms. Veal to respond to that. I've told her we've gone far enough with that. And then Ms. Veal, as I understood it, was simply trying to sort out some of these concerns, but I didn't get any guidance. It was always cryptic, that which came from the JQC. So I don't think we've opened doors quite yet. I'm not saying you can't call Chuck Boring, but I don't know what you'd explore with him at this juncture. So Ms. Veal, why don't you ask your question? Then Mr. Tate can make a record of his objection to that question. So it's all preserved and we'll see where we go.
Ms. Veal, I'll just mention it's 4:26 and I know you have 2 witnesses you need to get up and down today. So I'm not sure how long it's just for time purposes.
I think I'm going to ask at this point to break with Judge Peterson again.
We'll all be here tomorrow.
You surely will be, so I can get these other witnesses up.
Okay. Judge Peterson, if you will step down, please. I'm sorry, we didn't quite finish after all. Good. I need it. I can't believe that. There's a glare on it. Next witness.
Record calls to and Buchanan.
Ready to swear me? Go on. Sir, if you would mind, before you sit down, we're going to swear you in. And gentleman's right over here. If you could state your name and spell first and last name for the record.
My name is Dekevion Buchanan. That's spelled Dekevion. Last name Buchanan, Buchanan.
Thank you, sir.
Good afternoon, Mr. Buchanan. Will you tell us, was there a period of time within which you worked as a clerk at the Douglas County Probate Court?
Yes.
Okay, when was that?
I'm thinking from about March all the way until June of that following year.
So when you say March, are we referring to 2021?
Yes, ma'am.
Okay. So March of 21 to June of the following year, so June of 22?
Yes, ma'am. That's about right.
Okay. Direct your attention to an interaction between yourself and my prior investigator, Lance Alford, and myself that occurred on Thursday, April 22nd of 2021. Do you recall that interaction?
Yes, ma'am. Bits and pieces. Mhm.
Okay. And you were employed at the Douglas County Probate Court at that time?
Correct.
Okay. On that day, did Investigator Alford and myself appear at a window of the probate court and make a request of you for records?
Correct.
Okay. And were those marriage records?
I believe you asked for a marriage application, so yes.
Okay. And marriage certificates?
Mhm.
Is that a yes?
So yeah, so there are two different things. So the application, as you know, is a bit different from, the certificates. Anybody can request to see your certificate. Not everybody can request to see applications because it's sensitive information.
Was the request to see applications and certificates?
I can't remember, but I know for sure it was for applications.
Okay. In response to, well, let me back up. Was the request to obtain copies of those records?
I believe so, yes.
Okay. And in response to that request, what did you do?
Just basically procedure. I think that was before you identified yourself as working with the JQC. And so the procedure is, anybody, like I say, can request copies of marriage certificates as long as they pay for them. Only specific people can request copies of marriage applications because it has, like I say, sensitive information on it. So at that time, I believe I asked, I can't remember what I asked. I think I asked, if it was a marriage application that you had, or if it was for somebody else, or whatever the case may be. Then I believe you all might have gave me a name of a specific application or certificate that you wanted to see. And so at that time, I think your partner showed me his badge or whatever the case may be. And then I went through the process of, if you're obtaining a marriage application or certificate from an official capacity, as in law enforcement or something else, the policy was that you must bring in a letterhead of your request for that actual copy.
Okay. And so you mentioned my partner, so the individual that was there, he showed you a badge and identified himself.
Correct.
As being with the JQC at that time.
Correct.
Okay. Do you recall at that time leaving the front area of the office and going to a back area of the office?
Yes.
Okay. And did you leave the front area of the office and go to the back area prior to explaining the policy that you just started to talk about?
I believe at first I went back to my desk, which is that back area, and see if I could at least pull up the certificate to make sure that, we still had it or whatever the case may be. And then the second time I left the window was to go to the back to speak with my supervisor about it.
Okay. And who was that supervisor?
I think she was the judicial assistant at that time. Sandra is her name.
Were you able to pull up the record or the information when you went to your desk in an attempt to pull it up?
Yes.
Okay. But then you went to see your supervisor?
No, I believe I came back, and at that point, I told you all about the, process of the letterhead or whatever the case may be. Then after that, I think I did ask as well, like if you all were trying to, pay for the copy, or if you were going to try to get the copy through your official capacity.
Do you recall Mr. Alford when he identified himself saying that he was willing to pay whatever costs or fees were associated with the copies?
No.
Okay.
Do Meaning he didn't say it, or you just don't remember because this was a year plus ago?
I'm gonna say he didn't say it.
Right, and so your testimony is you come back and you explain the procedure, and I want to be clear that I understand what the court's policy or procedure was in this space. So what was it that you explained to us?
So I went over the procedure. It was basically that if you're going to obtain a marriage certificate or application throughout your official capacity as law enforcement or whatever the case may be, that you must bring in a letterhead, an official letterhead request that you want this copy for this reason or whatever the case may be. At that time is submitted to the judge, and then she will, see if you might be required to pay for it still, or if you would get the free copy of the whatever you're requesting.
Do you recall in response to your explanation of that policy, do you recall the request then shifting to, we would just like to view the records?
Yes,
Okay,
I believe so.
and you recall then that you left the front area of the office again?
Mhm.
Okay, you went in the back portion of the office?
Mhm.
Okay, to do what?
From what I remember, after I spoke with you all the second time, I went back again to review the documents again, just to, I guess, make sure, I had them and I would be able to get them. I think the second time when I walked away and went to the back to contact my supervisor about it to get, further help or whatever the case may be. At that time I came back, and then I can't really remember there. I think I wrote down my name and information on sticky notes for you all. And I think that was the end of the situation.
Okay, but you had identified the documents that we were requesting. and-
Yes, I
and you
believe
have
so.
them.
It will be in our computer system, yes.
Okay. And you came back to the front, and do you remember advising again on the judge's policy, which was submit your request on letterhead and explain why you need these documents?
Yes, ma'am.
And Mr. Buchanan, was it your understanding that that letter on letterhead with explanation was for the judge to determine whether you could even get the documents at all? Or was it simply to determine whether you get them for free or not?
I believe it was whether you would get them without paying for free, yes.
So if you were willing to pay, you didn't need letterhead,
Correct. But that's only for the certificate, not for the
not the
application.
application.
So to get the application, would one need a court order or how's that work?
I'm not sure. I've never had anybody try to get somebody else's application. Normally people will come in to, they'll say, hey, my marriage certificate burned or whatever, or I want the application, and then I can give it to you if it's yours. Other than that, no, you won't be able to get it.
So you recall the issue being, the issue that the records were not, or copies of the records were not being provided, nor were they able to be viewed, was about some fee or payment issue?
To my recollection, yes, it was about the whole fee portion of it is the difference.
Okay, the fee issue. So it wasn't because the JQC didn't have the right information.
The right information as
There was no issue regarding the information given to you. It wasn't incomplete or you weren't able to locate the record. That wasn't the issue.
no, ma'am, no.
Okay, because you testified that you were able to locate the records.
Yes, ma'am.
Okay. Do you recall that you explained the fee issue at that time?
I'm pretty sure I explained that issue when I explained the policy. Cause I do remember asking, well, are you, did you want to pay for it or did you not, or whatever?
Okay, and you said you're pretty sure that you would have explained it. You know, I'm just trying to, I want us to be as certain as possible.
Okay.
So my question is, did you explain to myself and Mr. Alford the fee issue?
Yes.
And the fee issue is simply, you need to get it on letterhead with an explanation. And then the judge will evaluate that to see whether you get it for free or whether you have to pay for it.
Yes.
That is, there's not a different fee issue that I missed.
No, that's the exact same. And again, you know, the application and
Because there was that issue and you were under the impression this policy needed to be followed, you didn't advise us, hey, there's a public vault where you can go down and look at these records.
I can't remember.
Mr. Buchanan, I'm going to show you exhibit 10.
Yes, ma'am.
What is exhibit?
It's my information that I put on sticky notes at the end of speaking with you all. It has my name on it. I gave you the policy just briefly. And I actually added the email address on there. And I think one of you all told me to put per the judge's orders or policy or something, if I remember correctly.
So your testimony is you did not just write that bullet point yourself, but somebody.
I believe it was, what is your partner's name? If I remember correctly?
Investigator Alford.
I believe it was him that told me to make sure I add that. I'm not 100% certain, but I believe so. Maybe about 75% sure.
But what you've outlined for right here, email on letterhead, your request and the purpose of your request to probate court facts. That is the judge's policy.
Yes, ma'am. That's the judge's policy.
Okay. Move to.
Mr. Tate, any objections to Director's 10?
Can I want to hear the witness just
Sure.
briefly about this? Yeah, I want to make sure I understood what you said about this per judge orders policy. Who told you to write that?
I believe it was Investigator Alston. I think that's what his name is.
Okay, so you didn't write that. Those aren't your words. He told you to write.
Those aren't my words, no.
Beg your pardon, say that
Those
again.
are not my words, no.
But you wrote it. I mean,
But
someone
yes,
asked you to
I
write
did.
it. It's
Yes.
your handwriting.
Correct.
Okay.
And had you talked with Judge Peterson at all about this particular visit?
No, sir. I don't believe she was in the office.
She
that
didn't
day.
know anything about it.
Yeah, no, sir. I don't believe she was in the office that day.
Okay. I would object on relevance. Go ahead.
Overruled.
That I have none.
It's admitted.
Mr. Buchanan, how did you become aware of this being the judge's policy?
It was told to us in one of our staff meetings
Okay, told to you by who?
by Judge Peterson.
And myself and Mr. Alford left the probate court that day without copies of the records and without having viewed the records, right?
Yes.
Okay. Thank you.
Mr. Tate, questions for Mr. Buchanan?
Mr. Buchanan, I'm Lester Tate. I represent Judge Peterson.
Okay.
Should have introduced myself to you before, and I apologize for not doing that. Sandra Hall was working there at the time you on this day in question that we're talking about. Is that correct?
Correct.
And she was your supervisor, is that correct?
Correct.
And do you recall going to Sandra and stating words to the effect, the JQC wants records, no records are coming up with the name they were giving him. The JQC were becoming agitated and suggesting that you were refusing to turn records up.
I'm going to say, I believe partial of that is my statement from what I can remember. I'm not
Okay.
sure if everything is correct, but yes.
You don't think Sandra would have any reason to not tell the truth about that,
Absolutely
do you?
not.
I'm confused because you just told us that you were able to find the records. It just was a question of whether you could hand them over for free or not, or what would need to be produced to justify that.
Yes, sir. So from what I
Ms. Hall's statement about no one could pull the records up, you're not agreeing with that, or you are agreeing with that and you're changing your testimony?
No, I'm not agreeing with that.
Okay.
What I remember was from the beginning, when both investigators came into the office, they requested a specific person's records, or I'm not sure if they asked for the certificate or the application. I know for sure they asked for the application. I'm not for sure whether or not the certificate.
Okay.
At that time, what I would have done was went back to my desk. I would have went to, I believe it was the Gather system, search the individual's name to see, it'll either pop back that we do have something, or it would say, there were no records found or something to that extent. Once that happens, we did have an older system because we transitioned software or whatever the case may be. And then I would go in and check a previous system.
So you did have, maybe both things are true. Maybe you did not find a record and then you later found a record. Is that what your
That
testimony
could have been
is?
the case as well, yes.
Or do you remember? I mean, I look, you're here as a witness to tell the truth as you remember it. And so
Correct.
do you remember whether or not that happened?
Do I remember whether or not I found the record? Is the question.
Well, did you ever go out and tell the folks from JQC, look, I can't seem to find this. You got a better name, you got a better, but you got I don't know what else you would look for, social security number, a date or something like that?
Yeah, no, sir.
Okay, do you deny that you told Sandra that the JQC wanted records, but no records were coming up with the name they were giving you?
I'm not sure if I told her those exact words, but something to that extent, maybe.
You did say something to that effect,
Maybe,
correct?
yes, sir.
That the JQC wanted records, but no
Wanted
records
records.
came up with the name they were giving you. Correct?
I'm gonna say yes, yeah.
Okay.
So I'm sorry, Mr. Buchanan, I'm not picking
So-
at you, but
I understand. So-
either you were able to find records, but couldn't hand them over because of a policy,
Mhm.
or you couldn't find records, in which case there's nothing to hand over because you couldn't find them. And what I took from your testimony when Ms. Veal was asking questions was, oh, I found the stuff, but they're flashing badges and this and that, and there's an application. And so I explained, put something on the letterhead, and then the judge will figure it out. Yes, records, I can't give them to you. Is that a correct distillation of what you testified to when Ms. Veal was asking questions?
Yes, sir.
Okay, now Mr. Tate's asking some questions, and he just got you to say, yep, I told Ms. Hall, couldn't find any records.
From what I remember is I did, yes, found the records. Yes. I'm not sure if I found them the first time in the first system or if it was the second system. That may be where the confusion is coming in at.
But your recollection is before you had to go out there and tell the JQC folks, hey, policy, letterhead, et cetera, you had found the records, whether it's in system 1, 2, 3, 4, or 5.
Correct.
Okay.
All right. And do you recall them becoming somewhat agitated?
Yes, sir. It became a high-tempered conversation, yes.
Did they accuse you of refusing to turn records over to them?
It was hinted, yes.
Okay. By one or both of them?
I believe officer, the male did most of the speaking, the investigator, male guy.
He was more agitated than Ms. Veal.
Correct.
And did you take from this implication that you were doing something wrong or improper being accused of doing something wrong or improper?
I absolutely second guess myself in that situation because I never want to be in the predicament where I would do something wrong to put myself or, the courtroom in jeopardy.
What, were you doing anything wrong?
To my knowledge, no.
Were you trying to hide anything?
No, sir.
Were you treating them any differently than you would any other member of the public that came in there?
No, sir.
Did you do your best to try to help and assist them when they asked you these questions?
Absolutely.
At some point, did you have a computer available in that is available to the public to look up records there?
Yes, sir. In our vault room.
And did you refer them to that computer?
I can't recall whether or not I did or didn't.
Did you talk to Sandra Hall about whether you should refer them to that computer?
I can't recall.
Did Sandra come out to observe what was going on there?
I believe so, yes.
Okay. And so she was in a position to see what was going on?
I believe she was at my desk at that time, again, in that back corner.
Okay. And then after this agitated conversation that you had with them where you feel like you're being done wrong, then you're told to write that this is per the judge's instructions on the sticky that's now been admitted into evidence, correct?
Yes, sir.
And you did it. Why? Because they told you to?
I mean, again, it wasn't, it wasn't a lie that it wasn't the judge's policy. So I didn't see any harm in writing that down as well.
Have you spoken to anybody today about, before today about your testimony, about what it would be here today?
I briefly spoke with Ms. Veal about what I remembered, as well as the chief investigator who brought the subpoena to my current position. I spoke with them about some of the things I remembered, yes.
Where are you working now, by the way?
I work in MARTA, Metropolitan Atlanta Rapid Transit Authority.
Okay, and what do you do for MARTA?
I'm a paralegal.
Okay, wonderful. And was that an in-person call, or was that in-person conversation, or was it a phone call?
So originally, I believe I was, the investigator spoke with somebody on MARTA's board of directors. Then that board of directors gave him my boss's name, which is the chief legal officer of MARTA. At that time, he came down to my office, him as well as my director, and basically told me, hey, this guy from the JQC has a subpoena for you. He's going to bring it up here to talk to you. And I said, okay. I mean, I didn't at that time think I did anything wrong or nothing like that. So, it was just kind of weird to me that, that.
So they went through the board of directors at MARTA to get you served with a subpoena?
Allegedly, yes, sir. That's what I was told.
And then came in to not just to serve you with a subpoena, but to talk to you.
Yes, sir.
Did you feel like you had any choice as to whether to talk to them or not talk to them?
I didn't feel like there was any harm in talking to him. No, sir.
Okay, fair enough. Fair enough. How soon after they came in there did they flash the badge on you?
After, let me remember correctly. I want to say they came in and they requested the information first, and then the badge was flashed when we came up to the idea of the documents.
Okay. And so I want to ask you a question about Judge Peterson. Did Judge Peterson know you were they were there that day?
To my knowledge,
I'm
no.
talking about while they were there.
Yeah, to my knowledge, no.
Okay.
Again, she wasn't in the office that day.
Did Judge Peterson say, hey, Mr. Buchanan, I want you to stonewall these folks if they come in there asking for documents? Any words to that effect?
Absolutely not. No.
What did you enjoy working for Judge Peterson?
It was a learning experience.
Okay. That's
did you
all.
leave?
Beg your pardon?
I asked him. I asked him why he left.
Oh.
Oh, for a salary increase.
That's all the questions I have. Thanks.
Ms. Veal, any redirect? No? Mr. Buchanan, thank you for your time.
Yes, sir.
Sorry if you had to wait for a little bit. We've been moving through this as we could. Next witness?
I'm sorry.
Director Saltland's offered.
Alfred, if you could, before you sit, turn towards our deputy here and get sworn in, please. You can come up, step on up in there, then you'll be able to see him better.
I do.
Thank you. And if you could state and spell your name for the record, we'll let Ms. Veal go.
Lance Alford, ALFORD.
Mr. Alford, are you the former chief investigator at the Judicial Qualifications Commission?
Yes,
And how long did you serve in that capacity?
from October of 2018 until May of 2021.
Prior to being with the JQC, how many years of law enforcement experience you have?
Approximately 22 years.
I want to direct your attention back to April 22nd of 2021. On that day, did you go to, let me back up, strike that. On that date, were you asked to assist with investigative duties at the JQC?
Yes,
Okay. And what were the things that you assisted with on that date?
I assisted the then Deputy Director Veal in going to the Douglas County Courthouse to follow up on a complaint that she reported to me having to do with Judge Peterson allowing unscreened civilians into the courthouse while performing a wedding approximately 1 week earlier, the weekend prior to that.
Okay. Did you go anywhere other than the Douglas County Courthouse on that date?
No,
What about the Douglas County Sheriff's Office?
that, yes, apologies. We did go to meet with the sheriff.
Okay.
Yes.
And which one happened first?
We met with the sheriff first,
At the Sheriff's Office?
correct?
Okay. And was that in reference to the wedding issue that you just mentioned?
Correct.
Okay. Was there anything additional we did when we were at the Sheriff's Office?
Yes, we met with the sheriff, understood what his recollection of the prior Saturday had been. And then we asked to see the security policy for the courthouse. As you relayed to me, that was something that could only be done at the courthouse, or I'm sorry, at the sheriff's office with sheriff personnel. So Sheriff Pounds actually was with us at the time we reviewed the policy.
Did you interact with anybody else at the sheriff's office that day?
Yes,
And who was that?
That was, I believe, the chief deputy of the sheriff's office, Ken Connor, I believe was his name.
Okay. And what was the purpose of the interaction with Chief Deputy Connor?
To view the security footage from the courthouse surrounding the wedding of April the 17th.
Okay. From the sheriff's office went over to the courthouse?
Correct.
Okay, and what was the purpose of going to the courthouse?
To obtain a copy of the wedding records pertaining to the wedding that Judge Peterson had conducted on the 17th at the courthouse.
All right, when you say wedding records, what specifically was being obtained or attempting to be?
We were looking for an application or whatever the clerk's office maintained that starts that process there, and then a copy of the wedding certificate or marriage certificate.
Let me ask you this. Unlike Superior Court or State Court, is the Douglas County Probate Court just one office that is the judge's office, and then all the clerks are in that office as well?
I can say that that appeared to be the case because when I subsequently met with Judge Peterson, I went through the same door I had entered to go into the clerk's office.
Okay. What happened when we entered the clerk's office that day?
We approached the gentleman who was standing there to our left at the counter. He turned out to be Mr. Buchanan, Deputy Clerk Buchanan. And I identified myself as the chief investigator for the JQC and showed him my credentials, identified you as the deputy director. And then we asked to see a marriage record of a previous recently performed marriage there.
Okay, and when you say that you identified yourself and showed your credentials, what were your credentials that you showed?
A badge that stated was the chief investigator for the Judicial Qualifications Commission, and a photo ID of that said essentially the same thing.
Okay, and during your time at the JQC as the chief investigator, was it your practice to, when you identified yourself, show people your credentials?
Certainly.
Okay.
No one knew who I was, so that would be. The credential was issued by the folks over at the Georgia Bureau of Investigation, I believe.
So you made it up?
No, sir, I didn't. I think a prior chief investigator had actually had it made.
I think you did too.
It's fishy.
And I had no credentials or badge. You had the credentials and badge, correct?
That is correct. That's also the reason I introduced you after credentialing them myself.
Okay. And the request to Mr. Buchanan at that time, the first request was what?
To obtain a copy of a marriage record, specifically this one related to the April 17th wedding, the prior Saturday.
Okay. And when you say marriage record, I want to be clear about what was requested.
We specifically requested an application to the extent there was one and the marriage license.
Okay. And what was his response?
He stepped away, Mr. Buchanan stepped away for a moment, went to somewhere at the back of the office out of our sight. And when he returned, he advised us that it was the policy of the Judge Peterson, that we would have to submit that request in writing on letterhead. And once reviewed by Judge Peterson, we would be allowed to get the records or not, whatever. It was up to Judge Peterson to make that determination.
How long was he gone when he stepped away?
He was gone several minutes, 3 or 4 minutes, 5 minutes, nothing longer than that, I don't think.
Okay. And his advising of Judge Peterson's policy, the request needed to come on letterhead and explain the reason for the request. His explanation of that policy did not occur until after he came back from being gone for a few
I am going to object to Ms. Veal leading, particularly since she really was a witness to this, and I've raised that
It's
issue
okay.
before.
Your objection is for whatever reason. good, bad, indifferent is leading. Don't lead the witness, please.
When did Mr. Buchanan, in the timeline of events, when did he advise of Judge Peterson's policy?
When he returned the first time to inform us about the requirement.
Right? I'm sorry, I missed a question. It's late in the day. Back up. When you identified yourself and showed your credentials, was there and made the request for copies of the records, was there did you offer anything additional at that time?
When requesting the records, I told him that we would pay, if there was a fee associated with that, we'd pay whatever the fee was in order to obtain the documents. It's certainly not uncommon that the courthouse charges a fee or a clerk's office charges a fee to obtain records.
Okay. And again, as far as the timeline of events, when you explained that you'd be willing to pay the fee, at what portion of the interaction was that explanation given?
That was in the original introduction and request for the record.
Okay. When Mr. Buchanan came back, did he say anything about or explain anything about a fee issue?
No, the only people who mentioned fees were us. We volunteered to pay a fee and there was never a discussion by Mr. Buchanan about a fee.
Okay. And in his explanation about Judge Peterson's policy, did that explanation include anything about fees and how they might be different for a state actor versus a non-state actor?
No. Not that I recall anyway.
Did Mr. Buchanan indicate that he was unable to pull the records at any time?
No.
So once he comes back and explains the judge's policy, did you make a subsequent request?
Yes. At that point, I requested just to view the records. Forget obtaining a copy, just let's take a look at these marriage records we're talking about, application if one existed and a marriage certificate.
Right. And what was his response to that request?
Mr. Buchanan stepped away again and went in the same direction he had gone the first time, and after several minutes returned and again stated that it was the judge's policy that we would have to follow, which is to say we had to submit the request on letterhead. And if I failed to say this earlier, we had to state the purpose for our wishing to originally obtain them and this time view them, and that upon review, we would either get the records or we wouldn't.
Did Mr. Buchanan ever advise that there was a vault where the public could go view records?
No.
Did Mr. Buchanan agree that the records that were being sought were public records?
Yes. And that actually came about because I asked the question. Of the time that I've spent with the JQC, I probably have less time in dealing with probate judges and courts than any of the other class of judge. So I wanted to be sure I wasn't asking for something we weren't entitled to. So I specifically said to Mr. Buchanan, I just want to be clear, this is a public record, is that right? And we had that discussion and he acknowledged that the record we were asking for was in fact a public record.
After being advised for a second time that the request needed to be on letterhead and provide an explanation, and what was your response at that point?
I think at that point, you and I figured we weren't going to make any further progress there. So I provided a business card to Mr. Buchanan and asked him if he would have Judge Peterson contact me. It was my understanding that she, I believe, was at a conference and so was not there that day.
Okay.
Was it your understanding that she was at a conference because you had been researching her schedule or because someone at the probate court office told you she wasn't around?
Actually, I believe it was Deputy Director Veal who told me that she was away. I think it's my recollection, when we went to that probate office, we knew she was not there. We went for that record.
An investigator offered on April 22nd of 2021. That was the week following right after the weekend wedding on April 17th.
I'm gonna object to her leading, Your Honor.
Okay. Just because of the dynamic of this scenario and you were present, I don't know that that was strictly leading, but it is late. But let's keep the questions as broad as possible.
Well, the late exception to leading.
It's not, no, it's not. I appreciate that Ms. Veal may be trying to get us to point B, but your objection is well placed and I'm sustaining it. We didn't get to the end of the question.
Was the visit to the Douglas County Probate Court Office on April 22nd of 2021, the week following the wedding weekend for which we were attempting to obtain records?
Yes, April 21, or I'm sorry, April 22 of 2021 was a Thursday following the Saturday, April the 17th.
Was there a point in the interaction where Mr. Buchanan wrote down some information on some Post-it notes?
Yes, I believe that I asked for his name. I wanted to be clear who we were receiving the instruction from. And I believe you asked him about the policy again, but nonetheless, on a Post-it note, he wrote his name and then wrote information about this being the judge's policy.
I want to show you. Those the Post-it notes that you just referenced.
Yes, I believe they are.
Did you instruct Mr. Buchanan to add this dash, this bullet point down at the bottom that says per judge orders / policy?
I did not.
Okay. Did I instruct him to add this language, tell him what to write on this signature?
I do not recall that you or I said anything about what he was to write on there other than what the instructions were.
Okay.
And his name, actually.
Had he indicated that Judge Peterson's policy was not a written policy?
Yes.
Okay.
Your Honor, we're again leading here. Did he indicate that Judge Peterson's policy was not a written policy?
It's a yes or no question. Isn't it true that he said X? I'm gonna overrule that one. Did you answer I think you said he did say that it was not a written policy.
Correct.
Okay.
Did you ask if the policy was posted anywhere?
I believe you asked if the policy was posted anywhere. And while we were standing there, he said it was not. It was not a written policy. It was not a published policy. And I don't recall seeing that on the wall in there anywhere.
You testified that you left your card for Judge Peterson. Did Judge Peterson subsequently reach out to you?
Yes.
Right. And when was that?
I did not know at the time, but she emailed me some period of time, probably within an hour after you and I were at the courthouse. I did not see the email until the following morning, though. But the email said, I understand you were at the office, essentially says, I understand you were at my office. Here's my cell phone.
Right. And what did you do when you received the email?
I actually talked to you and told you that I've been contacted by Judge Peterson and she had provided a cell phone. You were not available that day. And so you instructed me to get back with her and resolve this matter involving the records.
Okay. And did you get back with her?
Yes.
Right. Did you end up going to the Douglas County Probate Court that
Yeah.
day?
Yes,
Friday the 23rd?
I did.
Right. Did you ever, did you tell Judge Peterson that the reason that you wanted to speak with her was because of the complaint in reference to Judge Emerson?
No,
Right. Did you tell her what the purpose of your wanting to speak to her was?
I told her by telephone that we had been out the day before, which she knew. She had contacted us and that we had tried to get a wedding record and that I wanted to talk to her about that.
Okay.
She gave me a time frame to be there and I appeared at the court at that time.
Okay, and when you appeared at the court, what happened?
I was led back to her office. I spoke about our interaction the day before. I also told her that this was all about a wedding and about the people that she had let in at this wedding. And so the discussion about the wedding record became a discussion about the wedding itself and what she had done. And I actually found Judge Peterson to be very personable. She was very forthcoming and very open. And she began to tell her version of, she began to tell what had occurred in her own words the prior weekend. And so I listened to what she had to say. She provided me with several records and including the wedding marriage certificate that we had gone or I had gone out there for. And then I left the office and called you.
Did Judge Peterson explain to you what, or offer an explanation about the reason that her clerk had not provided the record the day prior?
Yes, she pointed out very quickly that the clerk had been mistaken on this policy and that was not her policy. And we were certainly entitled to the record. You mentioned earlier, you asked me about a vault. She mentioned, Judge Peterson said that they have this public vault. And we would have certainly been allowed to review the records in there. That was the first mention of a vault in my interaction with either her or Judge or Mr. Buchanan.
Did Judge Peterson tell you at any time that we didn't have sufficient information to obtain the records? And that was what the issue was?
I'm gonna object to the leading.
Overruled.
No.
Did Judge Peterson tell you that the issue was that she needed to review our requests in advance to determine whether or not we had to pay for the records? Did she indicate that was the reason we couldn't get them the day prior?
No.
How many times in your capacity as the chief investigator of the JQC, did you go to the Douglas County Probate Court?
2 times.
The one with Ms. Veal and then the one to speak with Judge Peterson.
Correct.
And the second one was by invitation from Judge Peterson.
It was by mutual agreement that I would come out to meet with her, yes.
Did you flash your badge at her when you went there?
I don't believe I had to identify myself with the credentials, at least at that time. I think I in fact remember telling someone in the clerk's office that I was who I was and that I was there to see Judge Peterson and that she knew why I was there. And she, I believe I was either escorted back or she came out to get me at that point.
That's all I have. Thank you.
Mr. Alford, before Mr. Tate goes, when you were interacting with Mr. Buchanan, so this was the first visit, asking for the things and he'd go away and come back. At any point, did he, Mr. Buchanan, come back with another clerk, deputy clerk, supervisor, anyone else? Or was your interaction always you and Ms. Veal and Mr. Buchanan?
Me and Ms. Veal and Mr. Buchanan.
Mr. Tate.
Good afternoon, Mr. Alford. My name's Lester Tate. I'm not sure we've ever met, but I represent Judge Peterson.
Yes,
Your background, you said, was in law enforcement. Is that correct?
correct.
And where did you work in law enforcement?
The Atlanta Police Department.
Did you work with Mr. Hyde?
I did.
I thought that maybe you had at one time. And you said you became the JQC investigator when?
I actually started as the investigator in early 2018,
Huh.
but by October of 2018, I was the sole, therefore the chief investigator.
Okay. Sole and chief can sometimes be synonymous, I suppose.
Yes.
And that's not a requirement that be a post-certified position, is it?
No, sir.
It just has sort of traditionally maybe had people that had some kind of law enforcement background or whatever else.
The only two people I know or three people I know who personally have had it all had law enforcement background.
Okay.
Yes.
And but you got a badge and you got a warrant card or whatever you call it to identify yourself, correct?
I'm not sure what a warrant card is, but I had a credential that said I was the chief investigator.
I think of it as those things the FBI has, it's got your picture and a seal and that kind of thing,
It is similar to that, yes, sir.
So I want to first ask you, when you went out there that day, that was not, so how many times did you go all total?
2 times.
2 times. But when you went out there that day, you went out there with Miss Veal, and prior to going, Miss Veal told you that they wanted you to go, that y'all wanted to go that day because she knew that Judge Peterson was not there, correct?
No.
She knew, what did she tell you about that? Because that's what I understood your testimony to be on direct examination.
That we went that day to obtain or to speak with the sheriff and to review the policy. She, in passing, mentioned that Judge Peterson was not there. I might have learned that once I even got there.
Okay.
But that was not the reason that we
Okay.
went, because Judge Peterson was not there.
But Miss Veal knew when you all went out there that Judge Peterson wasn't going to be there that day, correct?
That is my recollection, that I learned that from her at some point in this entire thing.
Okay. And I ask you that question because there's been questions about whether these were on purpose, these visits were, or whatever else. But your recollection is Miss Veal said Judge Peterson's not there that day.
No, that is not my recollection. In fact,
Okay.
quite the opposite. My recollection is that I learned that at some point, but we went there that day to meet with the sheriff and see and review a copy of the policy,
Okay.
the security policy.
Okay. But I'm talking about your visit to the probate court. Ms. Veal did tell you prior to going to the probate court that Judge Peterson wouldn't be there that day.
The timing on learning that, and understand, we're walking into the courthouse. That might have been a discussion literally walking into the courthouse. We're going to get the record. I don't remember exactly from the time I spoke with Ms. Veal by phone to the time she and I walked into the clerk's office. I don't remember exactly when she told me Judge Peterson was not there.
I don't know if it's probably because I'm asking bad questions. Okay. But I feel like I've gotten multiple different answers about this. So I want to put the question really clear. True or false? Ms. Veal knew that Judge Peterson was not in the office that day.
Objection, asked and answered.
Well, you can answer it, but then we got to move on from that because I think the point was made long ago.
It is my recollection that at some point before we walked in, or as we were walking into the clerk's office, that Deputy Director Veal informed me that Judge Peterson was not there that day.
Okay. Fair
That'll
enough.
be true.
That would be true.
Okay.
Investigator.
I'm happy with that. Thank you.
Investigator offered, did you require her presence to go do what you were going to do that day?
No, sir. We were looking for a marriage record.
Well, that brings me to my next point, because you said you really went out there to review a security policy and to talk to the sheriff, correct?
That's why we initially went out, correct?
Okay. And so, and the purpose, and I wrote this down, that you were what you were investigating were unscreened folks going in the courthouse, right?
For a wedding, correct?
For a wedding. That's right. So there's been a pretty big deal made about, I didn't get the wedding record. I didn't get the wedding application. I did, this is what I had to do to get this. So this is my question to you is, if there was a wedding at the courthouse and you're investigating unscreened people going in, it doesn't matter who it was that got married, does it?
Yes, it does.
And why would that matter? If it was John Doe and Jane Doe, or John Smith and Jim Smith?
Because the parties who got married are the very ones who were unscreened and came into that courthouse. We wanted to know, we wanted to identify them.
or I said, we did, I had very limited role here, but it was to identify them, their witnesses as to why they came into the courthouse and what they were told as they got to the courthouse. Were they told they were going to be inside? Were they told they weren't coming in? Were they told they were going to be screened?
Okay.
This was
And did
all
you,
about identifying them.
and I think I have everything that the JQC turned over to me. I haven't seen statements from these individuals. Did you take a statement from them?
I never spoke with them.
Okay. Even though it was important.
I was transitioning out of my role at the commission. In fact, a new investigator had already been hired and started just 2 weeks later. My role from Director Veal was to accompany her, look into this matter with the sheriff and the actual policy. Once we were there, we realized that the wedding party is who is involved here. We need that going in, I guess. But let's identify who they are. That was my role.
And so
I had
what
no
you want-
further follow-up role to participate in. That was it. So I didn't talk to anybody else beyond that, other than going back and getting the record the next day.
So you got the record within 24 hours of you appearing in the office.
That's correct.
Okay. And when you talked to the sheriff that day, did you talk to anyone other than Sheriff Pounds?
Talked to Sheriff Pounds, and then we went to see the chief deputy. I don't remember, someone else came into the office, and I don't remember if it was Captain Wilson or not, to be honest with you. But someone else did come into Sheriff Pounds' office while we were there.
And did you interview Captain Wilson?
I think Deputy Director Veal asked most of the questions there. I had a limited knowledge as to why we were there at that point anyway.
Did you know that there was an internal affairs investigation about the deputy's conduct that day?
Did I know it when?
Well, let's start today. Do you know it now?
I do know it now.
When did you become aware of that?
About 2 weeks ago.
And did you read the internal affairs investigation?
I did not.
When you were there that day, did the sheriff or the deputy or anybody else tell you that there were 13 or so people let into the courthouse that day by Deputy Clayton of the Douglas County Sheriff's Department?
I believe Sheriff Pounds mentioned that he had a deputy who was also a pastor, and that there had been, he was performing a wedding there. I don't remember if I knew how many, or if he said how many people were there, but yes, there were other people there with this deputy and his wedding party.
Okay. And you said you talked to Captain Wilson that day?
I believe that's who it was, but I'm not certain.
And you know, Deputy Clayton is Alan Clayton. Do you know that name? Was that the name that was used for the pastor deputy?
I don't recall that. I don't know that I ever knew it.
Did Captain Wilson ever tell you, and I quote, that this pastor deputy had caused a quote shit storm?
I don't recall that. But somebody in that room, and I believe it was the sheriff, mentioned that there had been this issue with this. And so now they had their own investigation they were going to have to do. There was nothing being done at that point that I knew of.
Well, looking at unscreened folks, I'm sure it's important to know who else had been in the courthouse unscreened as well,
I
correct?
imagine that.
And so were you aware that none of these 13 people that went in were screened, went through a security screening?
I wasn't aware how many they were, and I was aware that they were part of that deputy's party. I don't have any idea what arrangement was made with them or what screening may or may not have been done with them.
Did Sheriff Pounds tell you whether he had or had not had any conversation with Judge Peterson?
Yes.
And what did he say in that regard?
Sheriff,
Hearsay.
I want to know, I believe Sheriff Pounds is going to testify, so
We'll ask him.
I'd like to keep this witness available then for recall.
If you've subpoenaed him, I guess you can do that.
Well, our agreement has been that if they've subpoenaed them, our subpoenas are good. So I'm not trying to be obstreperous here, Judge, but this is an important point.
We will make arrangements. It probably wouldn't be tomorrow that you'd recall
Okay. Did you ever become aware that deputies had been performing unscreened weddings of unscreened people in the courthouse for a long time? Did you ever become aware of that?
I believe Sheriff Pounds indicated that that was not the first time this pastor deputy had performed weddings there. So yes, I guess I had some vague recollection of that.
Mr. Tate, I'm not limiting you in any way. We'll go as late as you need to go. A lot of what you're asking him about right now is already in evidence from Deputy Clayton. And so I guess I'm wondering the relevance of extracting this information from this witness when I think it's uncontradicted that Clayton did it many times. I think you got him to say maybe 100 times. And then there was the other guy, name I'm not remembering. 2 deputies at least did what your client did with no sanction until your client did it, and then it became a problem. So you can keep going in this direction if you can help us understand how hearing it through this witness is going to add to our understanding of the wedding situation. You seem unhappy with it, but
I know I am unhappy with it. I mean, I think he's the investigator for the JQC. We're late right now because we've spent a bunch of time arguing about having a name clearing hearing for the JQC. And I feel like I'm entitled to thorough and sifting cross-examination.
Right, but it needs to be relevant and not cumulative.
Well, it's not cumulative with this witness, Judge, with all due respect. It is not cumulative with this witness. I've asked this witness that question one time.
No. I don't mean with this witness. I mean in the context of the larger hearing.
Do you know of any evidence, investigator offered, that the security policy had ever been shared with Judge Peterson prior to the date of the wedding?
I do not.
Okay. Do you know of when you went to ask for the name, when you went to ask for the parties to the wedding, how did you know what the name was?
I didn't know the name.
So you arrived to ask for a wedding application and a wedding certificate without the name.
I knew the date 6 days earlier that the wedding had occurred. I don't know how many weddings they hold in probate court out in Douglas County, but I imagine it wouldn't be hard to find that one.
Do you know how long you have to file a wedding license and whatnot after a wedding takes place?
I do not.
Okay. But I just want to be clear because up to now, it has sounded like I went in, gave them a name to ask for this, but you didn't even have a name of the person that the people who had gotten married on that date by Judge Peterson when you went in there and made this request, correct?
That is correct. And I never said that I had a name. In fact, that's exactly what I was trying to find out by getting the records of the wedding that occurred in that courthouse on that day.
Okay. And how long total were you the investigator for the JQC?
From about October 2018, or from about February of 2018 until, well, I'm still an investigator with the JQC on a contract.
Okay. And so you're familiar with the canons of judicial conduct?
Yes.
You've read those?
Yes.
Okay. And is there a particular canon that you're aware of that you were investigating that relates to the security policy?
It is my understanding that the canon about must follow the law or be truthful, faithful to the law, the wording about the law, that has been ruled to include policies, procedures, and so forth.
Well,
but I'm not a lawyer. That's well above my pay grade.
I understand that. And I'm not trying to make one out of you. I'm asking what you thought might have been violated there.
That certainly would have violated that if a judge is going contrary to a courthouse security policy.
But you have no evidence, again, she had never seen that or been trained in that. Did you find any evidence that she had been trained in the security policy?
I did not, nor did I look for it.
Okay. And did you find any, would you agree that hypothetically, if the sheriff gave her permission to go into the courthouse for the purpose of performing the wedding, that was okay.
If there is a policy, I don't know that it's okay for her to violate a written policy, whether or not the sheriff gave that permission. I don't know that the sheriff is the only stakeholder in creating such a policy.
Well, you do agree you'd have to know what the policy was before you willfully violated it, wouldn't you?
That sounds reasonable.
It's just in.
What date did you give for the wedding?
April the 17th, Saturday.
Did you later look at the wedding certificate when you got it?
I looked at it only to look at the names and then
But
and make sure that it was Judge Peterson's wedding certificate.
Do you know what date was on it? Do you know if the date was actually April the 17th?
As I sit here today, I do not.
You wouldn't dispute if I told you it wasn't.
I can't speak to it one way or the other. I don't recall.
I'm not
what
sure.
that
I
was.
haven't looked at it. That's what I'm told.
Mr. Tate, anything else?
I think not, Judge.
Okay. Ms. Veal, any redirect?
Did anyone at that court ever tell you you did not have enough information to provide to them so that they could pull the records?
No, in fact, when I went back the next day and met with Judge Peterson, I had the same information, which was the date that the wedding had occurred.
Was there any difficulty pulling it up the next day?
I stayed with Judge Peterson pretty much the whole time, so if there was difficulty, I wasn't aware of it.
Somebody else pulled it up.
I believe that somebody else went and pulled it, correct? I believe another staff member.
Thank you.
Did you go into the vault with Judge Peterson when you?
Yeah, well, yes, she showed me this vault, which I would call a records room, but yes.
Did you look for the actual one in there, or had she already pulled it up?
We spoke about it when we were in her office. I think she had somebody working on it already.
Okay, but what I'm asking you here, just so I'm clear, is did you all, while you were going into the vault, did you look for it? The two of you, did you look for that particular date?
I don't recall if we did or not. She pointed out a computer system that was sitting there, but I don't recall whether we looked for it. Either of us looked for it. Seems like someone else looked for it and got it.
Did Judge Peterson tell you that the sheriff told her she could go into the courthouse if the deputy was there? Recall her telling you that?
Judge Peterson gave a version of that story that indicated that the sheriff had said if the other deputy was on site and they were being screened, or that deputy had screened his people, and she took that to mean we were good, that they were good to take her people in. Yes.
Okay, and she was polite and kind and all those good things.
To me?
too, I think you said.
Yes.
To you.
She was.
Thank you.
Contract Investigator Alfred, thank you for your time.
Yeah.
So we're gonna wrap things up for the day. The plan for tomorrow, Ms. Veal, how long do you think the remainder of your presentation will take?
It will take at least through tomorrow, Judge.
Okay. I ask because I don't want us to get to 3 o'clock and you're suddenly done, and Mr. Tate hadn't asked witnesses to be here because we thought that we wouldn't get through tomorrow. So I just don't want to leave all of us in the lurch. Yes, Mr. Tate.
What I was gonna say is, in aid and support of my colleague here, that I think we could do the directed verdict motion. If that were to happen, it doesn't sound like it's gonna happen, but I think we could.
My suggestion was going to be, if the director rested, that we go into. I don't envision a directed verdict on every count. And so we would go into, just based on the record that's been made, And so we could go into your presentation just to fill out the day and then use the natural gap we're going to have. If folks want to brief First Amendment, things like that, get things in writing on the directed verdict piece, that would just give you the luxury of time. But it sounds like that's all moot because Ms. Veal doesn't seem like she's gonna be resting tomorrow. Which is okay. I think your good faith estimate is what we need.
I'm sorry. I didn't hear.
No, I was directing that to Ms. Veal. Did you have anything more you wanted to add? I was actually talking with you, but then you had a whisper session. I just want to know if there's anything else.
Mr. Chamberlain's the one that's worked on the directed verdict argument, and he may or may not be here. His medical issues has to deal with, and I've asked him to prepare that, and I would prefer, I can do it if I have to, but I would prefer.
If he dumbs it down, then you can.
Maybe he's more persuasive than I am, Judge.
Understood. So your request would be if we do rest tomorrow, Mr. Chamberlain, you will be here tomorrow or you will not be here tomorrow?
I plan on being.
Okay, then-
It would be, my problem would be, I would have a 2-week interval. Beginning next week, that I would not be available
Okay.
at all at any of those days during the week.
Okay. We'll factor that into how we manage directed verdict argument. That doesn't mean if we find time that works for additional evidence to be presented in the ensuing 2 weeks, and I don't commit that we can.
I'm handling most of the evidence on our side. so I
Right.
think
We could press on with part of the defense presentation with you all waiving nothing, having preserved a directed verdict motion as to all counts. I just don't want us to fail to use time that we find because we get stuck in a procedural point. Did you have more to add, Ms. Veal?
Not on that issue, Judge.
Okay, what's another issue you'd like to talk about?
Mr. Tate mentioned investigator offered and maybe needing to recall him. I understood our agreement regarding subpoenas. It was an individual that was on both of our witness lists, and I had already subpoenaed them that you didn't need to then be subpoenaed. He's leaving on an airplane tomorrow morning, so he is not going to be available.
He won't be available tomorrow, but unless he's going to be gone for 6 weeks.
No.
I think there's a way to get Investigator Alford back in the mix. I was sensitive to your concern. We'll see what happens with the sheriff's testimony. It may not be necessary.
I'm not in a position to just say excuse.
No.
But I feel like some of those last answers, maybe for obvious reasons, makes that much less likely to be of concern.
I think on recross, you got to ask what you didn't get to ask on your initial cross. So,
We skinned the cat a different way, though I have no personal experience with that.
okay. So I don't want Mr. Alford to be worried about, he should go about his business. Anything else?
No, Your Honor.
Okay.
I just want to make sure, so I'm not to have witnesses for tomorrow, correct?
You're clear, other than you could, if all of a sudden the skies smile upon us and the director rests and we decided to not talk about directed verdict, you could always call your client with additional direct. I'm not saying you'd need to do that, and I wouldn't force the way in which you present your case. But it sounds like if there's an early rest, it's going to be in the 4 o'clock hour, not the 11 a.m. hour.
I've tried to be as flexible about this and, agreeable as I can.
Yeah, no, you've been, I appreciate the way you've accommodated things and the way that Ms. Veal has. It's allowed us to maximize our use of the hours by shuffling things around. And thank you in particular to Judge Peterson for trudging up to the witness stand and back. I don't know what number we're on now. So we'll do a little bit more of that tomorrow. So Ms. Veal, you should have witnesses aplenty for tomorrow to fill the day. And you'll call them in the order you need to based on their schedules. And we'll be here. And let's try to start as close to 9 as we can. You can't tell from in here because it's a little dungeon-esque, but apparently it rained real badly. There's been some flooding, so just drive carefully wherever it is you're going. I know we're all going in different directions, but the roads may be a little hazardous right now. Apparently our garage flooded and they had to evacuate the judges couldn't get to their cars, so they had to be driven home. So I'm happy to be in Cobb today. So,
Silver lining.
yep, exactly. Well, thank you, everyone. We'll see you tomorrow. Oh, yes, the courtroom will be secure overnight, so if you want to leave things here, I'd take your cell phones, but papers can stay and they will be unmolested. What Jane Morrison, and if you, just the people who are at the front end of our garage, couldn't get to your car, but Emerson. Seniors. But I didn't have that issue. But then Kevin Farmer put his pants up like this, he had to take his shoes off to get from his car.
Garage underground.
Yeah.
It was down a little bit. It was right up.